I'd
like to call this regularly scheduled September meeting of the Tennessee Real Estate Commission into order. First on our agenda is our roll call by our Executive Director, Ms. Eve Maxwell.
This meeting's date, time, and location have been noticed on the Tennessee Real Estate Commission's website, included as a part of this year's meeting calendar since September the 7th of 2012. Additionally, the agenda for this month's meeting has been posted on the Tennessee Real Estate Commission's website since Thursday, September the 5th, 2013. Alexander. Present. Collins. Absent. DeChara.
Here.
Flitcroft.
Here.
Grease.
Here.
Haynes.
Here.
McMullen.
Here.
Stevenson.
Here. Next on our agenda is our invocation, and for this meeting, I would like to ask Commissioner David Flitcroft to lead us in our invocation.
Thank you. Let us pray. Dear Lord, as Scripture says, trust in the Lord with all your heart and lean not on your own understanding. And in all things acknowledge him, and he will make straight your path. Path straight today in our deliberations. Give us discernment.
Amen. Next on our agenda is to adopt our agenda. Are there any additions or corrections to the agenda as presented?
Mr. Chairman,
Commissioner Alexander.
there is I think an error, when we were discussing about teams in the advertising, and I made a motion, then it does not appear in the minutes as if I made that motion. And that was the fact that Commissioner Grease and Ms. Maxwell get together, formulate, and bring some statements back that we would put into effect.
Now, are you talking about the minutes? You're talking about the agenda?
I'm talking about the minutes. I'm sorry.
Yeah, we're talking about the agenda now, Commissioner Alexander.
I jumped the gun. I had it on my mind. Go ahead.
I think we need.
I'll go back and find that.
I think we need
Yeah.
to
Kelly.
amend the agenda to include Ms. Ryan this morning. Is that correct,
That
Ms.
is
Maxwell?
correct, yes. Thank you.
She's currently in a meeting, so I don't know exactly when she'll be
There
in.
she,
but-
right now.
Ms. Ryan, we're in the process of adopting our agenda, and one of the things that has been requested that we add to our agenda is you. When do you want to be on our program in our meeting today?
Well, how about I let you adopt the minutes first as suggested by your counsel, and then I will tell you.
We're adopting the agenda
We're
right now.
adopting the
We're doing the agenda.
Okay, well then, don't listen to her. I'm happy to tell you now, because the next meeting doesn't start till 9:30, if you want to go forward with this before.
Okay.
I'll move the agenda be amended to allow Ms. Ryan to speak as soon as we adopt the agenda.
I'll second.
Motion by Commissioner Grease and seconded by Commissioner Haynes to amend our agenda to allow Ms. Ryan to be the first thing on our agenda to present what she has to bring before us as soon as we adopt our agenda. Any other additions or deletions to our agenda?
Just a point of order. Always Ms. Maxwell, and I've heard her every time I've heard her, always makes a determination that we have a quorum. Ms. Maxwell, do we have a quorum?
Yes, we do have a quorum. Thank you.
Yes. Do I hear?
Yeah, we did.
Do I hear a motion we adopt our agenda as
So
amended? Commissioner McMullen makes a motion we adopt our agenda as amended, and seconded by Commissioner DeChara. Any discussion? Hearing none. All in favor say aye.
Aye.
Opposed, no.
Greg want to have a roll call.
Commissioner, I think at this time, as the agenda was adopted according to Commissioner Grease's motion, Ms. Ryan, you are next.
I'm on.
You're on.
Okay, first let me tell you all, in case you hadn't been so informed, I did want to let you know that the Trek versus Bobo, I'm loud, everybody can hear me.
You're not, no.
Oh, okay. The Trek versus Bobo matter was accepted for an appeal by the AG's office and will be appealed. And I just wanted to let you know that.
Robin, would that be appealed to the Court of Appeals or
Yes.
to the Tennessee Supreme Court?
No, first the Court of Appeals. Anybody else have any questions about that? Good. Second, tomorrow we were to have a hearing in the matter of Griffey, which you all heard on a summary suspension matter. But Mr. Griffey has agreed, if it'll be accepted by this commission, to surrender his license and has signed an order saying he will surrender his license. The order also provides that he would pay the court costs, which is $200, and he does that within 30 days. And then if he doesn't do that within 30 days, basically his license will be automatically revoked. But I'm asking this commission if they will accept this instead of having a hearing tomorrow. If you choose not to accept this, then I will reschedule the hearing for another date. You should also know that Griffey and Associates, which is the business portion of it, will also be surrendering their license by an agreed order that I will be drafting later. But this is the pertinent thing, which is Mr. Griffey for tomorrow. So I'd like to present that to you and ask your opinion and what you'd like to do on the matter.
Mr. Chairman, I move that we approve council's recommendation in this case. On both cases.
I'll second that.
Was that your recommendation?
Well, it was going to be a surrender or revocation hearing anyway. Surrender means that we don't spend, let me just suggest this. If we do not do this and we have a hearing, he will not appear. We will get a judgment if you assess civil penalties to him. You will probably go forward with a revocation, but the difference is that there will be a judgment out there of a substantial amount of money, perhaps, that probably won't be collected. So my recommendation is to accept this surrender. It is a surrender. He is not practicing and doesn't plan to practice. This protects the public in a way that needs to be protected, which is getting him off the streets.
We have a motion by Commissioner Flitcroft and a second by Commissioner DeShara to accept the recommendation of council, and discussion on that motion.
Mr. Chairman, I think the motion is well taken, especially because I gave it, but I think he is recognizing his culpability, which I think stands well for him.
Is there any, we can't offer any recourse to those people whose money
No.
he's
No.
absconded with?
They can go to civil court and are involved. Julie's going to jump in here, but go ahead.
Well, I was just going to say, if they do go the civil court route, there is the real estate education and recovery account, which if they follow the certain steps laid out in the statute, which I did speak to one of the complainants who had contacted me and said, can the commission help me in getting my money? And I said, we can't order the return of your money, but I gave her the statute number. She has an attorney, and I said, have your attorney pay close attention to these provisions, because it does provide a possible recourse for you to return a certain amount, and we are giving that information to anyone that asks.
Let me also suggest, I just want to clarify a bit, all of these complainants in this matter none of them live in Tennessee. They would all have appeared by telephone if I could have gotten the cooperation for them all.
Any other discussion on the motion to accept the state's recommendation in this matter, which is revocation of license? Surrender of license.
And costs.
And cost.
Both licenses.
Both
No,
licenses.
this one
This
is
is one.
just Griffey, Mr. Griffey himself, because that's the matter that's before you tomorrow. There is another license for Griffey and Associates, but that will be a separate order that, yes, they've already agreed on that one as well.
That's not before us
That
today.
is not before you.
Well, could I ask, could we approve both of them today?
You can't approve both of them because I don't have the other one.
Mr. Chairman, I'm going to amend my own motion. I realize that's quite improper, but I'm doing it anyway. Okay, let me restate my motion that we accept.
Get up there and talk loud.
We accept council's recommendation regarding the one case that's coming up tomorrow,
To surrender his license.
to surrender his license and costs.
You've heard Mr. Commissioner Flitcroft restate the motion that he made the first time. Is there any other discussion? Hearing none. All in favor say aye.
Aye.
Opposed, no. Motion carries unanimously.
Thank you. You should also know that this is a copy that was sent to me via fax, but he is UPSing the original to us this morning. So that will be entered. I will, Mr. Chairman, also draft a final order to incorporate this agreed order for your signature, and I'll get that to you before you leave today.
Okay. Thank you, Ms. Ryan. Next on our agenda is to approve our minutes from our last meeting.
Well, I apologize for jumping the gun, but I have given Kelly the information, and that will be how you want to handle it. It was a motion.
Okay, I guess what we can do is, if you guys want to approve them with the caveat that I'll go back and put that motion in, or I can go listen to it at lunch, whatever you want to do.
But I think that's fine. Just at the end of the day, the approved minutes need to reflect that Mr. Alexander
Yeah,
made a
that's
motion.
what, I understand that.
Okay.
Yeah. I'm sorry I missed that. Sometimes I,
Are there any other additions or corrections to the minutes other than the motion that will be added that Mr. Alexander made and to reflect exactly what happened during that part of the meeting? Any other?
Question. On page 9, the 2014 meeting schedule, whenever it says May 8 and 9, 2014, then it says in Jackson, and then it says June 4 and 5. Is the May meeting in Jackson or the June meeting in Jackson? And then similarly, okay, the October one and November, it has East Tennessee between those two. Does East Tennessee go with October or November? Okay.
No, it's just written below it, Kelly, so,
I just wasn't sure which.
like, between May and June and between October
right,
and
I've always
November.
done it that way, but I guess we could put it all on one line to make it less.
Yeah, just put Jackson or,
Yeah, Commissioner McMullen, it's.
May is
it's-
in Jackson.
yeah.
October.
It's been tradition for this commission that in the month of May, we go somewhere west. And in the month of October, we go somewhere east. But that's the 2 months. It's always May west and June and October east.
It is confusing, though.
And I know, yes.
The way it was written.
Yeah,
I
the
just
way
wasn't
it's written,
sure.
it is kind of confusing.
Okay. Thank you. No problem. Thank you.
Any other observations about our minutes? If no one else has anything to add or delete from our minutes, do I hear a motion we approve them as amended?
so moved.
Second.
Commissioner DeShara makes a motion we approve our minutes for August as amended, and seconded by Commissioner Grease. All in favor say aye. Aye. Opposed, no. Motion carries.
One recuse.
One recused because Mr. Commissioner Flitcroft was not here. He was somewhere else.
Can I just add one thing? And I know that we finished with the agenda, but it might be best if we make a motion to further amend the agenda by removing the formal hearing from tomorrow off of the agenda, in light of what Ms. Ryan just gave you. And I'm sorry to reopen that, but we didn't have it since we were in the midst of our motion when we did it.
So move.
Second.
Have a motion by Commissioner McMullen, second by Commissioner Grease, to further amend our agenda to include the deletion of tomorrow's formal hearing of TREC versus Gary Griffey, which has already been resolved.
You might explain to the people here what that means for them.
Don't you? For what?
For those of you who are attending this meeting for whatever reason, what that really means to you guys is we won't meet tomorrow. So those of you who plan to be here 2 days, it may be a long day today, but we won't meet tomorrow.
But you still get 2 days credit.
Yeah.
It's a good.
All you attendees, I guess since Commissioner Grease has brought this up, I just like to add, I know this is, the meeting is beginning. While you're here, it doesn't matter, you're here. And you heard me before the meeting started, I very facetiously made a comment to a couple of you. The one thing you're going to learn most of all today, by having been at this commission meeting, you're going to learn that you don't want to ever come back to another commission meeting. But you're going to get 8 hours of continuing education by being here, in addition to being able to clear up for whatever reason that you're here. Some of you are here just to get 8 hours of continuing education. Next month, we're going to be in East Tennessee. There's one or two of you here from Knoxville. Just spread the word. They can come to a commission. Licensees can come to a commission meeting. Those that need 16 hours of continuing education every 2 years, they can come to a commission meeting and just sit here, take no test, just be here, sit on the back row, and get 8 hours of continuing education. No test or anything else. It's a good way. For free. Don't cost you anything.
And enjoy our commission meeting.
And enjoy the commission meeting. But anyway.
And if your local board will approve it, you also get credit for an ethics.
Yeah, so there's a lot of good things that come from coming to a commission meeting, other than just to be able to clear up something that's happened with your license. But anyway, next on our agenda, we have an informal applicant appearance, and we have Jacob Becker, who is the applicant, and his principal broker, Pryor Bacon. Are they here? Yes, they are. Just come right over here and sit in these two chairs. And I'm going to turn the meeting now over to Miss Maxwell.
First, I'll swear.
You're going to swear them in. Julie Kropp, our attorney for the Real Estate Commission. Miss Julie Kropp.
Will you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Becker, Jacob Becker, is an applicant for an affiliate broker's license. He has tested. He's 35 years old and appears here with his principal broker, Pryor Bacon, who is the principal broker of the Pryor Bacon Company in Chattanooga. Mr. Bacon has had no prior complaints. As he appears here today. And I'm going to probably read the bulk of this about Mr. Becker because it was a little bit confusing. I think it'd probably be more clear if I read it in the order in which I sort of took notes on it. When Mr. Becker was 17 to 18 years old, he got heavy into drugs and into the drug culture and started using and selling and taking drugs. And he was arrested for assault when he tried to defend a friend of his who was being pulled out of a vehicle. He beat the person up with a stick. He was sent to rehab. And then after rehab, he continued the drug use and got into another altercation with a person at a drug house in which he was living. There was an altercation there, and ultimately his probation that he was on was revoked, and he ended up going to jail for what was going to be 10 years. He was sentenced concurrently to several numbers of years. He was paroled early. He was paroled on 5/24 of 2000. And after being sentenced to 10 years on 4/2 of 1998, he got out on 5/24 of 2000. So after 2 years, he got out. The Iowa governor restored his rights to vote on 4/15 of 2004, and he was granted a limited pardon on 12/16 of 2010. Mr. Becker has sent in a number of letters of recommendation, all praising the rehabilitation that he's made and what he's done with his life at this point in time. He is a chiropractor and just recently licensed as a chiropractor in the last few years, and is the owner of several chiropractic franchises. And now he wants to get into real estate. And I think I'll let him tell the rest of his story, but that's sort of what led up to this today.
I'd say that pretty well sums it up. And
we need you to lean over and speak loudly into that microphone. We're keeping a permanent record of, and we're taping our meetings, so we need you to speak loudly right into that microphone, if you would.
yes, sir, I'd say that pretty well sums it up, brings me up to date.
Would you like and put in your own words just exactly what you did to get yourself in trouble back in '98?
Say around age 17, got at that rebellious stage and just started to kind of revolt from the family and everything that kind of growing up, and got involved in drugs, alcohol, got kicked out of the house, was living in a small town in Iowa, moved to a larger city, and became more and more involved in drugs and even selling them. And then there was an assault in a house that I was living in, and I lied to the police about it, tried to cover it up. And that's ultimately, that was that's what led to me going to jail.
What kind of drugs were you involved in?
Marijuana. And in the house that I was living in, there was methamphetamines that were being sold in the house, which led to the assault that occurred in the house that I was living in.
You would tell the commission, I know you got out of prison in 01.
In 2000.
Now, 2000, okay,
Yes, sir.
not 01. In 2000, you got your rights restored in 2004.
Correct.
By the governor. And what have you done? Tell these commissioners what you have done since then.
Sure. Since 2000, when I was released, I directly went into community college, maintained a 4.0, then got an academic scholarship, went to the University of Northern Iowa, studied pre-med there under an academic scholarship. From there, went to chiropractic college in Davenport, Iowa, and I think I graduated there with academic honors, and then came to Chattanooga, opened up a chiropractic office in 2008, I believe 2008, and then we opened our second in 2010 or 2011, and then our third in 2012. And that's what kind of led me to Pryor has been really a mentor of mine since maybe I'd say 2000, where I got connected with him through opening our second office and purchasing a space there, and got interested in the real estate side.
Are you planning on continuing to maintain your chiropractic practice?
Correct.
In addition to having your real estate license?
Correct. We had 3 offices, just sold one of those offices, and currently have 2 offices that I maintain.
Anybody have any other questions of Mr. Becker?
When did you move to Tennessee?
In 2000, it had been early 2009 or 2008.
So I noticed in your file you have a letter from an Iowa sheriff, which is pretty impressive. How did you get to know that sheriff so well?
Well, I'd grown up in a small town in Iowa where, kind of everybody knows everybody, and came from a real large family, had 2 brothers, 3 sisters, and had a lot of family in the area. And when I was kind of going through that rebellious period in 17, just kind of broke away and rebelled against my, left town. And so in coming back, I was able to reestablish some of those relationships. And it was, and so that sheriff in particular was, somebody that I think he might even been connected with our high school and the wrestling team, and maybe had somehow, assisted with coaching. And so I kind of had known him when I was younger.
So you're already licensed by the state in your chiropractic business, is
Correct.
that right? Did you have to go through the same type
Correct.
of?
Yes. Yep. And then actually with, we have in each of our offices, we have a massage establishment license. So it's kind of the same process that, if there's an application, at least on the first one, and then they can kind of recognize it on in any further licensing.
Anybody have any other questions of Mr. Becker before we hear from his principal broker, Mr. Pryor Bacon? Mr. Bacon, would you like to tell us a little bit about your company, what kind of mentoring program? And I think that Mr. Flitcroft may want to know about that, but just tell us a little bit about your company, how many agents you have, how long you've been a principal broker and had your own firm.
Well, my father had the same name, and I think he was in a family business with 4 of his brothers in 1959, left that business and went to work for someone in Chattanooga, and after a required amount of time, he opened up a real estate firm. So it had been early 60s. My father was in the firm. He passed away in 85. I had been a stockbroker for J.C. Bradford that's located in Nashville in 84 and 85. It was had just pursued a different career other than real estate and got back in. And then came before he died. He died in the middle of '85, and I came back to in the real estate business in January of 1985. And I have a son that'll be 30 next month. It, unfortunately, has the same name, and we've got been in business more on the construction and development side. We haven't pursued historically a large number of agents, have been doing more development, sell or lease our own properties. That's how I met Dr. Becker. Another agent in town brought him to a facility I have at the corner of Shallowford and Gun Barrel. We ended up, another friend of mine and I had purchased a suburban office condominium on Shallowford Road near 153, and we sold that to Dr. Becker, and we created a relationship. He had purchased a lot downtown. Our North Shore is very vibrant right now. He'd purchased a lot and asked me, one, he wanted to sell it to me, and then I, just over a period of time, we're developing it together. It is next to a Publix that's coming to Chattanooga. It's within 2 or 3 blocks of the river. And that kind of, I guess, worked as a catalyst as we developing our friendship relationship as we're working towards. We've gone through in our town. We have a C7 committee, North Shore committee. Then you've got the regional planning. Then you've got the city commission. We've gone through all that, and we're ready to finalize the permitting process on that project. Dr. Becker has gotten interested in real estate and purchased a house at foreclosure. And not that I've helped him. He's done most of it on his own, but I have offered to help and gone by there a few times in what he's doing. And I guess my read on Dr. Becker is that he likes the real estate business. I like him as, I like his energy, I like his intellect, and I can't, if he hadn't told me about some history, I would never have guessed it. But I guess that's all I.
Okay.
Yeah, a question, Mr. Bacon, who's going to supervise him?
Right now, there's the other brokers. You asked me how many. I'm sorry I didn't answer that. My son, a lady named Beverly German, and Dr. Becker will be are the only agents, so it will be me that supervises Dr. Becker.
That's what I wanted to hear.
Anybody have any commissioners have any questions of Principal Broker Prior Bacon?
Bacon, do you all list and sell properties, or you just do your own?
I'm going to tell you more than you want to know. I have made 2 ventures into creating a firm and having agents under me. And both of them kind of just died a slow death because I guess one way of saying it is that owning real estate it's more important for me to lease something I have than it is to earn a commission leasing it to somebody else. So I would gravitate towards, if you came to me looking for a piece of property, whether it be suburban office or flex space or warehouse, whatever it is that we have, I would probably show you what I have and refer you to a friend of mine, Joe Pleva, that worked for KW Commercial, for him to show you other pieces of property that if you didn't want what I had. And so, having said that, I can tell you that we average a cost of about a little less than 4% on leasing expense. A lot of that's internal, paid to me or my son, and it's making sense to me at this point in time that we might want to try that again in a little different format, if you will. I guess the basic idea would be the value of an agent working in our office, me being the broker of the agent, would not be so much from a direct financial, what the brokerage would receive. in the split, but the association of the brokers, if that makes any sense to you.
I just,
If I've made my,
I simply trying to determine why in the world he'd want a real estate license. All he's fixing to do is muddy it up where he's got to work under our rules and regs. If you're not going to list and sell other people's property, if y'all just going to trade together, I don't know why in the world you'd want a real estate license. If that's all I was going to do, I'd surrender mine. That's pretty.
no, I
Stern
can
for,
understand your point, and
Huh?
I've had that. I guess 25 years ago, someone came by and asked, it was my father, would you do a build a suit on this piece of property? Well, if you have a piece of property, the short answer to that question is always yes. 6-8 months later, somebody came in the office and we ended up doing a build a suit for this person. And didn't have any, we didn't know who the person, the agent brought the person by. Anyway, we had a build a suit, we had a lease, and then the agent shows up and wants a commission. At that point in time, I thought, this is crazy. I mean, this guy didn't do anything with respect to earning a commission. He did what I would call the classic real estate parachuting himself in the middle of a transaction in which to earn a commission. Having said that, I guess philosophically, your rules and regulations, I think, are a pretty good code guideline in which to operate, I believe, number one. The only advantage I would see would be able to run a blind ad in the paper without attaching it to a real estate firm, because I believe, and I've seen it, I've experienced this with other people that have run, there are people that will answer a blind ad to try to avoid dealing with the real estate agent and paying a commission. But
I have, along with what Commissioner Alexander has brought up, I'd like to know where Mr. Becker, how he is going to fit in to the company that you have where you are the principal broker. How's he going to fit into your company? What's he going to be doing with a real estate license working for you?
Mayor, I can't answer that question. I don't have the direct answer right now. I can tell you only that I have appreciated his intellect. I've appreciated his energy. And if you've read the book Good to Great, you get the right people on the bus. You sure don't know where you're going, but you get the right people on the bus and you head in a direction. And I believe he's a person that I would like to have on my bus. It could venture out into more of exactly what I mean. I embrace the real estate community. We embrace, if you lease something, we want to pay you a commission. So I guess one of the reasons I have a license is every realtor in town knows that I'll pay them a 4%. If it's normal, there's some realtors who'll take more of a split. We take less than a split on what we do. We solicit other realtors to help us keep our properties leased. So that's an advantage to us from that standpoint. I don't, Mr. Alexander, I certainly see your point. I think it would be appropriate for him to have a license to operate within, to pursue the CCIM designation. I think he likes the real estate business, likes the investment side of it. I think it's similar to what he's doing with investing in businesses in his chiropractic. He's not actually working the chiropractic himself. So I don't know if I've answered it appropriately, but I've answered it honestly.
Chairman, I move we approve it.
A second.
Have a motion to approve the request for Jacob Becker to get his affiliate license, and it's been seconded by Commissioner DeShara. Before I call for a vote, there's one thing that I would like that has been brought to my attention. Mr. Grease has known Mr. Pryor Bacon for some time, and Mr. Grease was telling me a minute ago that he and Mr. Bacon had thought about opening a real estate company together, and they're going to call it Bacon Grease.
I always wanted Prior Bacon to go into business.
Yeah, Bacon, a company of Bacon Grease out of Chattanooga, Tennessee. And ham.
I'll tell you a story. My uncle's on the Bacon side worked for Chatham Drug at one point in time, and this would have been in the 40s, and they went out in their car, their van or whatever, and sold patent medicines. And my Uncle Reed Bacon was in walking into a store, and the man introduced himself, and his last name was Ham. And my Uncle Reed said, "My name's Reed Bacon." The man hit my uncle.
And with that thought in mind, any other discussion on the motion to approve? Hearing none, all in favor say aye. Aye. Opposed, no. Mr. Becker, congratulations. Go forth and do well in this profession.
Mr. Chairman,
Make us proud.
Thank you very much.
Permission to address Mr. Bacon directly?
Go ahead, Commissioner Flitcroft.
Two things. First, you're vouching for this man. If he comes back, you come back.
I'll be glad to, but I don't think we'll do that.
Secondly, if you got a name like Flitcroft, you don't make fun of nobody's name.
Thank you.
Very much.
Thank
Appreciate
you.
it.
Have a safe trip back to Chattanooga.
Thank you.
Now we've come down to our Executive Director report. Ms. Eve Maxwell.
The first item on the agenda is my report is the complaint report, and that is on the iPads. And the first page of the complaint report reflects the number of complaints that we have currently open. We currently have 120 complaints that are open. 15 are against timeshare registrations, 105 are against brokers or affiliates. We have received in this month of August to September 29 complaints. So for the fiscal year, which is July the 1st, it begins July the 1st, we've received thus far this year 59 complaints. This time last year, we had received 69, so we're a little less, but they do seem to come sort of in waves for whatever reasons. We don't really understand that, but we probably will have an increase over the next few months. It seems like the fall months bring an increase with them. But as I say, right now we've had 59 filed in the last couple of months. We have 15 complaints that are over 180 days. Those, all except for a couple of those, have been heard by the commission and already dealt with. There are a couple that Julie sent to investigations. Actually, was two that were over 180 days.
Two that were over 180 days, which were part of a group that were sent to investigations. But the rest of them have either been heard by you all and are currently in litigation, or have been heard by you all. You offered a consent order. Those people accepted it, and they're currently still on the report because I'm monitoring them until they attend and complete all of their requirements. But there were two that are not clock stopping, but they're in investigations right now.
But as far as our performance measure goes, we are at like 95%, so we're well above the benchmark, which is 73%. So we're well above.
Ms. Maxwell,
that.
are
Yes.
we ahead of all other commissions?
Oh, I'm sure we are. We must be. We just certainly must be.
I think we would be.
I think we probably are. Robin would have the best idea, but I think we probably are, don't you?
I don't get those.
Yeah, you don't get those, and I only get ours, so I don't know. They don't show us where we line up with other people, but I feel like just from what I hear that we are better. Of course, we're best. The money that we've received thus far this year since July the 1st is $59,360. So far, we have received only $1,000 in E&O penalty fees, and that's pursuant to the statute that went into effect July the 1st. And after, if you all remember, on the 31st day after you're placed in suspension, there's a $500 penalty fee, which is what it's called under the statute, which attaches. And that penalty fee is due whether you retire, whether you go back active, whether you decide to give up your license, you still owe that $500 penalty fee. And thus far, we've had 2 people pay it. Many more than that complain about it. And in the 6th month, it will go up and start to increase every month until the 12th month. And if you're still in suspension, then your license will be revoked. But that's where we stand with the E&O penalty fee. And and I'll talk about the suspensions later and where we stand, but that's part of the monies that we've gotten in thus far. The number of complaints on the 3rd page, you see that we've closed 54 complaints so far this fiscal year. We've closed 41 with no action. 2 have been referred to an outside agency. 5 closed with a letter of warning or instruction. 5 closed with a consent order, and 1 revocation. And that's the 54 that we've had thus far this year. The next page represents the DAR report, just as it appears on the big C&I site, the Big Commerce and Insurance site. When we do the newsletter again, we'll beef that up with some more information about the various occurrences which resulted in these, although these mainly are these are suspensions that are mainly failure to timely purchase E&O, and then someone who didn't comply with their payment plan but then complied with it later and was suspended briefly. Are there any questions about it? And then there's a pie chart, of course.
Very pretty.
Thank you, thank you. It sort of has an odd box in it, but I don't think you can see that on the iPad.
So Eve, all complaints don't come before us. Like on a consent order, are there some of the staff just send out directly that don't come before us?
No, you all have, the commission has authorized the consent order so that when Julie reads,
What he's saying is some of these,
Required
failure to
education.
timely complete required education, those would be agreed citations, which in what year was it?
oh, yes, right.
That's what he's asking.
Oh, okay, yes. The failure to timely complete required education, there is a $50 fine per month if one does not complete their education timely. If some of those people are brokers and they didn't finish the post 120 in the 3 years allotted. So if you go over the 3 years into the 4th year, and you get that 4th year only because the renewals are every 2 years, it's $50 a month for every month that you don't complete your post 120. And so those don't come before the commission because the commission made that determination a number of years ago that would be the penalty for not completing that.
And there are some agreed citations that are settled before they come to that.
Right. If, say that the agreed citations, say for advertising, the commission likewise a number of years ago set up a schedule of fees that are civil penalties that could be assessed for certain items such as advertising. And so those are citations, and when they come before the commission, the citation wasn't paid. And that's when you all see things like that. They're more the not such large violations.
Could I have a copy of that schedule at some point just to see what
Sure.
it looks like? Are these considered complaints in your complaint statistics?
Yes, they are, because we have to assign them a complaint number.
Okay.
And so they are part of the complaint statistics that you see.
Thank you.
I'd say that's going to be going up with advertising issues.
Yeah, probably so. And most people pay the citations. I mean, they don't,
Usually they were revealed through audits in the past.
right, they were. Or they were, that's, I say, those advertising complaints that come in. The next topic are the licensing statistics. And you can see that our numbers have increased. Actually, we have a total increase in our number this month, which is the first time in a number of months that we've had a total increase. But our active licensees, we have 23,826 active licensees, which is 148 more than last month. Our inactive and retired have decreased. The inactive by 48 and the retired by 35. Our broker release number is up 18, but these 98 people in broker release all have E&O insurance, because all the other broker release people are in suspension that don't have E&O insurance. So these 98 actually do have E&O insurance. Our total number of individual licensees that we have is 33,000 338, which is 83 more than we had last month. Our firms total 4,077, which is 6 more than last month. So our grand total of individuals and firms is 37,415, which is 89 more than last month, which is, as I say, the first month in a long time we've had a total increase in numbers of people. And if you look at the additional statistics, which are, I guess, probably page 4 on your iPad, if you scroll through, you can see the change in the number of individuals from 2008 and 2010 and last year. And we are down still from last year, but if you notice from each of the years that have gone by, like our change from 08 to 13 was 11,791, our overall change. So we have lost that many licensees since 2008, this time 2008. Since 2010, it decreased to 5,573, and then from 2012, this time, to 2013, we only lost 825. So the number of individuals leaving the business is decreasing, and the number of applications that we receive now is on the upswing, not like a large upswing, but is on the upswing, and that's part of the additional statistics. If you go to page 3.
Ms. Maxwell?
Yes.
The ones that are suspended for no E&O insurance, is there a list of those posted somewhere?
There was a list, that was in the newsletter, but we have, I have a list of the principal brokers that are still in suspension that's part of you all's materials. And then I have a list of the individuals who are in suspended status.
Do the associations get a copy of that list?
They got a copy of that list, yes.
Okay.
They did. And we put people in suspension like every week. Betsy goes in and puts the other people, the people who have been either broker released or who, for whatever reasons, their insurance has expired. She puts those people in suspension as well. So, there's a continual cycle of people being put in suspension.
They're also listed on the monthly disciplinary action reports. I think they only included in the part that you all saw the ones that are in there for agreed citations, consent orders, things of that nature. But also there was a rather lengthy list in our July disciplinary action report listing all of those people that were suspended.
My concern, or I guess my point is, if the association offices get a list of agents who are suspended, they can cut them off immediately.
Right, and they do. And we've had
So
several callers who weren't happy because that did happen to them.
And so that's what I wanted to make sure, that the associations are getting those lists so that they are shutting down people who
And
don't have
I know
license.
that Memphis Association said that they have someone who checks she said every day she checks to make sure that people, to see if people have, their statuses have changed. And she said they cut them off as soon as they expire or they are suspended or in problem status. She said they cut them off which probably has a lot more impact than, sad to say.
Yeah, that was kind of my point.
Yeah,
So I want to
than
make
we
sure
do.
the board offices are getting some kind of notification. So
Yes, and they are getting notification.
Okay, thank you.
Ms. Maxwell, how many firms do we have that their brokers are suspended?
Because of E&O?
I don't care what it is.
Oh, we have a total of 33 principal brokers who still don't have E&O. 13 are in Tennessee, and 20 are out of state. Of those, though, several are in a delinquent status, which means they're in that first 60 days after their expiry date. But nevertheless, they still haven't gotten E&O. One of them, we had gotten a note from the owner that the principal broker had left and gone to Chicago, and he's on this list. And then 20 of them are located out of state. And the ones who are in state, their mail, one or more pieces of their mail came back to us. When we get mail back, we have two individuals in our office who who try to call the numbers that we have available. They try to white page the people, and then if they can reach them, they send the information back out with the Trek One form. And if they can't reach them at all and there's no forwarding address, then it goes into the file. But we've tried to email them, we've tried to write them, and we've tried to call them. So, you know, the ones that information came back on, they just don't, we don't have any way to reach them.
Of those 13 firms, how many of them have affiliates?
There's like one that had an affiliate, the rest are like single person firms. And the affiliate on the one that was there, I think he had expired. And the rest are, as I say, are single firm licenses. So I'm surprised that we have that number of principals. I'm actually surprised we have the number of people still in suspension that we do, except that so many were broker released, and we knew all along that there was probably a good possibility that those people would not try to get, wouldn't get E&O. And those statistics are in the E&O update. I have it broken down into the number of individuals that we have. Still have 543 people suspended. Of that, 111 are, I'm sorry, no, that's on the E&O statistics. I just thought I'd move on to those.
Okay.
E&O update.
Well, you threw with the statistics. And
Well, I guess we'll move on to the E&O, sorry. Probably easier since we're talking about it to move on
Yeah,
to
move
that. So if you go to the second page of the E&O update, you'll see that we have,
Chairman, perhaps Ms. Maxwell could address the audience and explain to them the statutory changes in E&O and how we're dealing with it. Just a general overview.
Sure. We have I don't know. There was, I don't know if everyone saw, it was on our website, but as of July the 1st, there was some revisions. Every licensee, I think, knows we've had some problems in the past with legislature this year passed some additions to the statute that licenses who do not have E&O or maintain E&O, renew E&O, active license. If you have anything actually but a retired license, you have to have errors and emissions insurance. It doesn't matter if you're not practicing actively, you still have to have E&O. It goes to your home and to your firm, and it just outlines the fact that your license is in suspension for the first 30 days. First day, like when midnight comes and the 31st day starts, there's a $500 penalty fee that attaches. And as I mentioned earlier, voluntarily terminate your license, whether you go back active, that $500 penalty fee. After 6 months, you have the penalty fee that could be $1,100.
Look at the time, sure.
this is an effort to try to make sure that everyone, that's kind of an overview of where it stands right now. And if you have state insurance, you have till 1/1/15, so. Go back to your firms and tell your fellow practitioners that
I think you've explained it well. The bottom line is, make sure you got E&O insurance. It's the bottom line. Every licensee in this state, statute says shall have E&O insurance. How much more do you have with about E&O, Ms.?
that's really a problem, and we knew that was going to be a problem when they were notified. And notification did go to their former firms, some of which they had left almost 2 years ago. But the developers do have it, so like they get it. They have an overall policy, the developers do, and we write their corporate offices and remind them that they have to renew their policies in a timely fashion.
Ms. Maxwell, when you say developers, you mean the timeshare brokers?
Well, the timeshare, yes, the developers being the Wyndhams and the Blue Greens, and then, they have a firm, and then the timeshare people work for the firm, but the developer is the policies are really purchased by the corporate office, the E&O policies for the umbrellas.
Anybody have any other questions of Ms. Maxwell about our E&O update?
Before we move on to the next topic, can I introduce you all to our new Deputy General Counsel, Sam Payne, who just got into the meeting? He's
That
sitting
man
back
been running around there more than nobody knew he was.
What did you say?
I just want to know, he's been here all the morning,
Yeah, he's
in
been
and out. You're very obvious, you stick out.
I just saw that he was back there. I told him to come let me know when he got here.
Mr. Payne, would you like to either sit down there and talk to us or stand up there at the podium with that mic and just give us an overview as to what you are doing and what you have been so we'll know who you are?
Truth be told, I was here and then I went to the Collection Service Board meeting. They had donuts, so I stayed a little longer than I might have otherwise stayed. But it doesn't feel like quite as long, but I've been practicing law for about 21 years, mostly in private practice. Grew up here and went to Vanderbilt. More recently, though, I've been with the state, with the Attorney General's office. And then I got a call from Nancy Jones with an exciting opportunity here. So I guess I started the Tuesday last week after Labor Day and just trying to take it all in. But appreciate the good work here.
Thank you for coming back.
So I'm confused. Where do you fit in?
He's New Wayne.
Oh, the new Wayne. Okay, now.
I've been telling people that is probably a good way to go, kind of a safe harbor for me. I'm the new Wayne. That probably won't cut it long term, but for now I'm going with that.
That's good. That helps.
If I were you, I would not even admit that. I knew Wayne Pugh when he was working
Sitting
about
here.
like Julie was, sitting in that seat.
I hear you. I've got his phone number, and he's been gracious to say call me anytime, so I'm sure I'll do that sooner or later. But
Ms. Payne, just a bit of advice there. watch out for Miss Maxwell. I mean, you know, Miss Maxwell, I had the sort of supervisory committee, tried to supervise her. She makes me tired. Just watch out for her. Whatever she has may be contagious, and you may be working a 90-hour week.
Works really hard.
But I'm pretty sure it's not my floor, so that may help that. Just kidding.
Oh, you would feel the breeze as she ran by you if you were on her floors, because she doesn't stop.
Well, there's a lot of details to take care of. Again, thank you for all your good work.
Thank you for welcome to the administration, and we look forward to working with you. This commission
Mr.
does.
Payne, you're welcome anytime.
Ms. Maxwell, you have anything else on E&O?
Not unless someone has other questions.
Anybody have any
about it.
questions? If not, we're going to take a 10-minute break.
On spotlight.
I call this Real Estate Commission meeting back into session, and the next thing on our agenda is the team advertising.
As Commissioner Alexander pointed out, the commission had adopted a motion that Commissioner Grease and I come up with some suggestions for team advertising, some guideline suggestions. So we sent each commissioner earlier in the week, Friday to be exact, some advertising real estate teams proposed guidelines for discussion, which Commissioner Grease and I worked on and tried to break it down into just some sort of categories that would be maybe easy to discuss, for the commission to discuss and come up with some guidelines. And these are just suggestions. They're sort of taken from a number of other states, kind of combining what other states have and have suggested and have seen worked or not worked. And the states range from Maryland, that has actually adopted statutory language as it relates to teams, to other states that have no regulation at all and don't really even recognize them or mention them. And then the majority of the states seem to sort of be in the middle, where they have some guidelines in reference to teams, but they haven't gone as far as to have rules or statutes that specifically relate to teams. It's more of a advertising guideline, many of which spring from a rule similar to ours that says that advertising can't be misleading, false, or deceptive. And so that's kind of where most of the team advertising is originating. And I'll let, hopefully everyone had a chance to read it, but I'll let Commissioner Grease sort of go forward with it if he would like to do that.
I'd be happy to do that, and thanks, Ms. Maxwell, for your help with this.
It's just weird. Sorry.
So I think the goal today is to get the commission's sense of these suggestions, whether you think they ought to be included in guidelines that can be referenced back to regulations or policies we already have in place, or you look at them and go, this shouldn't apply, or it's too complicated, but to at least by the end of this discussion have certain guidelines that we can give back to staff so that they can put the appropriate reference to a rule or regulation that's in place. And the overall concept here has to do with team advertising. And you can see the first category is the definition of a team, and I'm going to suggest we save that till last, because I'm not sure we can reference a team back to any particular rule or reg we might have at this point. So we can talk about advertising, which is what the balance of this handout or what you see on your iPad has to do with, and get your take on it and comment on it. It may take a while to go through each one of these, but if we do these one at a time and you guys say, that sounds good to me, we can check that off and go to the next one. If you want to modify it, which I suspect you will on several of these, that's great too, and see if we can get consensus and then send it back to staff for appropriate references. So if we can start with number two. Number two was, what may a team not do? Now again, we haven't defined a team, but generally speaking, in my mind, is more than one licensee in the same firm advertising themselves collectively instead of individually. So with that being the case, here's some, and again, a lot of these were taken from other states and what these states have adopted, some things that we thought were fairly obvious that a team couldn't do. Letter A, have a principal broker as a member. And I think the concept here is that the principal broker is in charge of the company, not a particular team. And so if they're the ones designating agents for either buyer agent or a seller agent or designating.
That's too complicated, just talk.
Okay.
Michelle, can you scoot up? I'm sorry, I can't hear you down there.
I'm giving more detail than she needs.
I just told him, don't look over here, it's too complicated for him. Just, talking to the microphone, we see him. He's trying to look us all in the eye.
Well, just training.
Okay. I know.
So, are there any comments about this? Anybody disagree with that? If we won't spend any time on something we don't need to spend time on.
Well, and I don't necessarily disagree with it. I think we're going to get some questions about that and probably some conflict from some areas that the principal broker does have a team in place that works for him since he's got to be running the office or whatever. And so I think we're going to have to justify some logic behind that.
Are you going to require that they identify the team members to the commission?
No, not with what we've got proposed here today. Let's just talk about it in the sense of guidelines. However, some of these guidelines will be referenced back, especially when it comes to advertising, misleading or false advertising. It could be a basis for a complaint filed or discipline, I suspect.
I think the ultimate goal here is that we try to compile a list of guidelines based on interpretations of existing statutes and rules that the commission has. For example, like he said, within the advertising rule, there is something that states a licensee shall not advertise in a false, misleading, or deceptive manner. I think it's something along those lines. Among these guidelines, I would hope that we could structure it such that the commission could pass by motion. We consider the following to constitute false, deceptive, misleading advertising in violation of that section. That way, when these licensees see that they're doing it, although it's, we can't outline every single instance of false and misleading advertising within the rule. So revising the rule to include it, it would be to the, we would never be able to name everything, but try to clarify what the commission considers as that type of advertising. Therefore, those people have noticed that if I'm doing this, I could very well have a complaint filed against me, and the commission considers X, Y, and Z to be a violation of this rule and something that they could potentially take action upon because it is an existing rule. So,
Julie, just a question or a point of clarification before we go into this team advertising discussion. As a commission, we have never recognized teams before. We have always recognized each person as an individual.
Exactly.
So is this going to cause any conflicts in any of our other rules and regulations where we've never recognized a team before?
I don't think that from my understanding of discussing this with Commissioner Grease and Ms. Maxwell, we are not recognizing teams as a licensed entity. That's why they're not included in the definitions. You can't be licensed as a team. But recognizing that we don't outlaw them, we're trying to create some guidelines for how they advertise, because ultimately these teams are made up of licensees who we do have jurisdiction over. And I think the thought behind this is not to recognize teams as something we license, but give guidelines for the individuals making up these teams as to how they do advertising and work within their teams. Does that make a little more sense?
I just want to make sure we're not going to
That's
be
our
in
intent,
conflict
and we will
with-
try not to do that because right now our statutes and rules don't define it or reference it, nor do they outlaw it. That's why I think just by providing some guidelines for how the licensees should engage in their business while working as teams wouldn't conflict with anything because we don't have anything outlawing them working that way. So.
Okay, thank you, Julie.
John,
Yes, sir.
on the principal broker thing, the principal broker is responsible for, if he's got 10 teams in his firm, he's responsible for all 10 of them. So why would you not say that the principal broker had to be a member of every team? Ultimately, he's responsible for them anyway.
Well, so if he's not a member of any team, he's still responsible for all of them.
That's right.
And that's why I think the simple way is to say, instead of being part of everything, not be part of anything.
I agree with you. Go ahead.
All right.
But he's understood that he is responsible ultimately because of the principal broker.
And we're going to address that 2 or 3 more times in here.
Excuse me, go ahead.
Oh, that's all right. Just back to your point for a minute, Janet, I think your trade association, your local associations, staff at Trek, all would like to have some guidelines, so when people call and say, what can we or can we not do, we'll have this to be able to answer those questions. Most people are trying to do it right. We're not trying to catch people. We're trying to give guidance to people, and that's what this is.
Well, and I agree. I just think we're going to have some
We will.
conflict on principal brokers.
That's okay.
And for example, on this one, I'm having a little trouble off the top of my head connecting this to a specific statute or rule. And so as it's written right now, I don't know if that's something we might want to, pass on for now, because I think the idea, like I said, is to give clarification of how doing certain things violate certain existing rules and statutes. And so this one, I might have to give it a little bit more thought and look more into it to see how I can connect this to a particular rule. But some of the other ones are much more clear as we get down the list.
So I think the goal today is for this commission to say, that's yes to this, no to that, yes to this, let's modify that. And then hopefully next month, staff could come back with printed guidelines with references for each of those guidelines. Is that okay?
Yeah, we could do that. We could do that. And yeah, because I would ultimately like for you all to look over and approve or make comments on it or disapprove of anything ultimately that we post as guidelines.
Right.
Even if you have already passed it by motion, I want to be sure that it's written in a way that you all intended it to be portrayed to the licensees.
Okay, letter B, under number 2, all licensed team members must be affiliated with the same licensed firm and must conduct all real estate activities from the location of record of the firm with which they are affiliated. My only comment to that, and I've thought about these more, and probably more than I should have, real life is many licensees are working out of their house. Their place of business and where their firm is still where their license hangs. I think the concept here is we don't want XYZ team to go rent a separate office in a different building and say that's their headquarters, when in fact they're affiliated with the company.
I totally agree with that.
Any comment on that? Verbal.
I guess as just a general statement first, I think my understanding, well, correct me if I'm wrong. I thought the reason that we were talking about this had to do with advertising. But maybe there's another reason we're talking about this, and that is this question of teams kind of keep coming up all the time.
There's more. Yeah, you're right. This is focused on advertising, and I can connect that by saying no team can advertise they're working out of an office location rather than where their license is hanging.
I guess I just would, just as a general statement, say I have some concern about sort of going down too far into the details of how the company is going to run itself and be organized, and so I just want to just kind of get that sort of general concern on the record. I'm not criticizing anything specifically that we talked about, but I want to be careful about getting too far down into that. On this, I guess just as a specific wording on 2B, what is all real estate activities? If you go out and show a house, is that a real estate activity? Obviously you're not going to be doing that at the office. You're going to be doing that out at the house, or if you're driving down the street on your cell phone, are you engaged in a real estate activity? I understand the point of what you're trying to do with this particular thing, but just the way it's worded could be interpreted in a different way.
That's a good point. Eve and Julie, I'm going to leave it to you to, if you hear a remark and it goes unchallenged, that's what we're wanting incorporated into the finished product. Is that fair?
Combine B and C, or B and C maybe, and that might clarify, I mean, or just have one or the other, that might clarify that they can't establish a separate office.
And we can incorporate
Yeah.
what Commissioner McMullen was saying as, that pursuant to our statute, if you're going to have a separate business location, you have to have a branch license for that location. That connects back to why you cannot be operating out of a separate office, but also connect in that advertising aspect. And you cannot advertise as such. We can work with some of this. That's why.
To clarify that, 2 weeks ago, last month or the month before last, we had a formal hearing because a man didn't change his address. So it says that you will operate out of that, where that firm is established, that office. That ties it back together.
Okay. So I think on B and C, you all work with that, but you get the sense of what we're talking about there. Letter D, the principal broker. Now this is only in here because this has become an issue in some places. The principal broker and not the team leader must pay every licensee on the team. That's statute. I mean, you can only get paid a commission from your principal broker. But apparently, it's been brought to my attention that certain teams, the team leader collects the full commission, then distributes it to members of his or her team. Well, it's illegal. So we stuck this in here, and it may be a stretch to tie it to advertising, but it's one of those core principles that Austin was talking about we may be digging down too far into, but I think the point needs to be made, and I'll try to make it again at another place in here. Any comment on that?
Well, maybe we need to put some team guidelines somewhere besides in advertising to dig into these deeper issues.
In this case, this can be directly tied to 312B11, which states that it's a violation to accept a commission or any valuable consideration by an affiliate broker for the performance of any act specified in this chapter from any person except the licensed real estate broker with whom the licensee is affiliated. So that statement right there can be, if they're not already aware by the plain wording of that statute, which is very clear, this just reinforces that this particular action would be considered a violation of that statute.
Well, and maybe on some of these like that, Julie, we put in there what rule it ties back to.
I plan to do that. I plan to try to tie each of these guidelines to a rule, because if we don't do that, we need to be making it a rule. We're just trying to provide some clarification for the rules, because we can't anticipate every situation, but we're trying to build
I see
on
this
what we
getting
have.
deeper than just advertising.
I do too.
It ought to be a broader scale of what teams can do. We need to set those guidelines and not just tie it to advertising.
Here's our dilemma. Since we don't define a team, it's hard to do that.
Well, my plan for titling it was to say Tennessee Real Estate Commission guidelines based on existing statutes and rules, because we have already adopted two interpretations that didn't have anything to do with rules. One being the statute regarding yard signs. That's not exclusively limited to teams. The other being, what was the second one? The other one, talking about the advertising rule, the commission making a motion and taking a vote that within the advertising rule, when any mention of where it requires listing of the firm name, that means at a minimum the DBA has to be included. That applies to more than teams as well. So this may be something we can build on eventually. And those are already two things that are not exclusively limited to teams.
So, if it's okay with this commission, if conceptually we agree with these statements, let's give it back to staff and see if they can incorporate it in a document that we're comfortable with references. That's... Move on, sir. Good deal. Okay. Letter E, the principal broker cannot delegate his supervisory responsibilities to the team leader. The principal broker remains ultimately responsible for oversight of the team and its licensed members. I think
That's consistent with existing statute, isn't it?
it is.
Several
That's good.
rules
Yeah.
Yeah.
and statutes.
We're
We could
just
probably
trying-
list multiple.
In case somebody had a question.
John, I think at some appropriate time, once it's sort of ironed out, topic for the road show.
Oh, yeah, absolutely, it's something for the road show.
All right, letter F, the team cannot be or present itself as an entity operating separate and apart from the licensed firm. The team's business is the business of the firm. It cannot have a business, an identity, or an existence separate from a licensed firm. And I think you can quote a reg right now that says, you know, you're only licensed with one company, and whatever that company is the company that you have to represent you work for. Any thoughts on that or heartburn with it?
Did that also just specifically say it can't be a separate legal entity?
I'm going to address that in number 3.
Okay.
And let's just see if that
Okay.
takes care. Letter G, the team leader cannot designate team members as designated firm agents. Only the principal broker can make such a designation. Typically, or I'm told by people across the state, that a team leader sometimes says he'll be the seller's agent and says we've got buyer's agents on our team here that'll take care of buyers. Well, the team leader can't make that statement. Only the principal broker can make those designations. And this is just an affirmation of what already is the law.
6213-406 talks about designated brokers and managing brokers, and talks about may be appointed, that a licensee entering into a written agreement to represent a party may be appointed as the designated and individual agent of the party by the licensee's managing broker, to the exclusion of all other licensees employed by the managing
We
broker.
can
So
put the
that's
references there.
something that's already there, but again, just reinforcing what we already have.
All right, number 3, team names, I think more appropriately would fall into or under number 4, use of team names violates Rule 1260, 02, 122E. No licensee shall advertise in a false, misleading, or deceptive manner. So let's talk about, if you don't mind, team names as if it's under number 4 instead of separate category. So under team names, letter A, the suggestion or proposal is the teams cannot advertise themselves using the terms real estate, real estate brokerage, realty, company, corporation, LLC, corp, Inc., associates, group, or other similar terms that would lead the public to believe that the team, and this is just my edit since this was printed, I would add in there, is a separate entity offering real estate brokerage services independent of the firm and principal broker. So back to your question, Austin, about advertise. I would insert there after the word team is a separate entity. This will create some heartburn with certain teams that have already established themselves, but we're trying to give them guidelines and
Then they need to get their broker's license under that name,
open their own companies.
open their own company. I mean, I feel about it.
Well, I think we've had several examples that have been real examples in the past that we've looked at and gone, well, who's the company? Because they're the Barnes Realty Group or whatever, and that's not even the name of the company. So I think that's a real problem out there that we're seeing, is that they are definitely using things that indicate it is a real estate company in and of itself.
Any other comments on this? The second part, under team names, that we thought might be appropriate to discuss was that team members cannot refer to themselves as president, CEO, chief financial officer, vice president, founder, those terms which are typically associated with specific separate entities. It's an advertising issue, again, in my opinion.
I'm not as concerned about that personally.
I don't know.
That's just my opinion.
I don't know how much of a real issue that is, but I mean, I think they're doing a lot more that's a lot worse than that.
Are you saying like as long as they use their correctly licensed name, we could probably pull up who they really were, and so that's why maybe that's not as big of a
Yeah, I mean,
consideration?
You know, as far as them saying, you know, the Barnes team, Chris Barnes president, I mean, you know, that really doesn't bother me as much as you know what company he works for and who he is, then you can find the rest of it.
I don't know. That's confusing to me. That's confusing, a little confusing to me.
Well, I just don't understand why anybody would use it, and I guess I don't see that so much. John may see that more in his area where it's a problem.
Remember, some of these are pulled from other states where it's become a problem. So I'm not trying to anticipate this will be a problem, but if the overall goal is for the public to know who they're dealing with, and they see a title associated with the team, they might, I'm not assuming they would, but it's possible they might go, well, if he's the founder, it must be the company is his team. And that was the only thought.
And I think it's more on
Exactly it.
websites that you see it. The teams will have websites, if you've looked at some of the ones that have the really, fancy websites, and they'll describe the team members, and it'll list one as maybe the president or the founder, and the principal broker may or may not be part of the team, but the other people just are listed underneath this person who's the founder. So you think that person, I would think that you think that person's probably a corporation, or that actually may be the real estate firm.
That makes,
But I do think it's on the websites where you see that
Okay.
the most frequently.
yeah, I can see where that would be more of an issue there for sure.
All right. The next item, which would, as is printed, is letter A under number 4, although we've inserted team names underneath the number 4. It basically, we made an attempt to identify different types of advertising. And so if Rule 12-60-02-12-2E talks about no licensee shall advertise in a false, misleading, or deceptive manner, since it says no advertising, we decided that it would be appropriate at this point to try to itemize a list of potential advertising media and make sure it's clear that these media and others we might not have listed are what we're talking about.
It's all inclusive.
Yeah.
And we do have subsection of our advertising rule states that all advertising, regardless of its nature and the medium in which it appears, which promotes the sale or lease of real property, shall conform to the requirements of this rule. That's another, we could reference both of those subsections because, like he said, it's not an all-inclusive list, but it gives a better idea.
Comments on that list? I'm not going to read through it. It's everything we could think of, basically. Knowing there's more that we didn't think about.
I think it's pretty comprehensive and gives a pretty good overview.
All right, we'll go to the next page, then page 3. The underlined portion talks about that same rule. It says it prohibits false and misleading advertising, but they're not described. So from a guidelines point of view, let's take a little time and try to describe what false means and what misleading is, and that's the purpose of this next section. False is pretty easy. It's factually incorrect or simply not true. Or because of an omission, it's false. Is
The
that-
number one team in real estate.
Perhaps.
Yeah. If there's nothing factual to back that up.
I don't even know how you would factually back that up.
Well, I mean, most of the MLSs keep records of who the top producers are, and typically they can determine who's number one from the MLS as far as sales. And that's where
Some things are just puffery, though. Just,
Well, a lot of it is, but and that was a complaint I got yesterday. I was telling John, we discussed this at an exit meeting yesterday, And that was one of the complaints that I got was, how do we stop people from putting all this stuff on their signs that, you know, they're the best real estate team in the area or the most honest or, you know. And I said, you know, that's misleading advertising. Or could be.
Well, John, one thing that we find, especially in East Tennessee, and you've seen it as well, is these newspapers have their poll, and then you say, we're the best realtor in Knoxville because we were voted by the News Sentinel section on 2013. And I think that's factually accurate.
Yeah, there's like best of Nashville polls and stuff, you know, and you can nominate your dentist or your school or your
lawyer or your pizza shop.
And I mean, if they've got something like that, I think they do have something, like you said, that they were, and they're disclosing how they were.
But Janet, that's different from the
determined
name best. It's best is voted by.
What now? Say that.
You need to disclose the whole statement. There.
That's what I'm
Best,
saying.
Best is voted by. Sometimes the realtors show up at closings and have their clients fill out the forms. They buy extra copies of the newspaper. Sometimes it's more revealing if you know how many people participated in the poll.
Well,
if
that's
less
true.
If there's less than 10, you say, well, that's somewhat suspect.
If it says we sold more real estate in Nashville than anybody else, and that's not true, then that would be false. But if they just say we're number one, I don't think that that's false or really even misleading, because it's just, I mean, nobody would put any stock in that. It's just puffing, you know, it's just saying something. And I mean, maybe, you know, we're number one in running off customers or something. I mean, maybe, you know, I mean, we're just number one. That has no meaning, really, because it just has no context to it. It's just a statement. And that's just my opinion.
You know, I want to, conceptually, we're working on guidelines. So without being too specific, false or misleading, we got, under misleading or deceptive, if y'all are through with false and agree that you can't make false statements, or if you do, you may be penalized. Under misleading, we got a little bit more specific. These are items we've talked about before. You can see our definition: causes a person to have wrong idea or impression, causes something to be easily mistaken for something else or believe something that is not true, imprecise representation, vague or incomplete manner in circumstances where specificity is required to understand. Like if we don't sell your home in 60 days, we'll buy it. Maybe that's deceptive or misleading because there's more to the story. You might have to get an appraisal, and you might have to agree to sell it for 80% of what the appraisal is, those kind of things. So, but based on things we've talked about recently, if you look at letter I under C, it's misleading or deceptive if the name of the firm is licensed with TREC is missing, whether have portion of name or just logo not clearly identifying the firm name. As an example, we had Mr. Bacon here this morning said he referred business to a buddy of his at KW Commercial. Well, as far as I know, there's not a KW Commercial. That's their brand they're trying to increase. And so if you see a sign that says KW Commercial, this is saying that's misleading because that's not the name of your company. And if you're a RE/MAX agent and you've got a balloon but you don't have the name of the company, that may be considered misleading. That's the point we're trying to get here.
And this is already a violation of subsection 2B, which specifically says that too, that they have to have the firm name and telephone number within the advertising rules. So.
And we're trying to, when people call TAR hotline and say, what can I do? Hopefully we'll have a list that they can provide that'll give clarity and take the mystery out of it. Number 2, or letter I, advertise franchise name alone without rest of the firm name. Complete license name required. It's misleading or deceptive if you're not able to identify a specific licensed firm. I have to go back and look at something we did last month where you said we agree that all you had to do is have your DBA on a sign or advertising. I guess it was on signage. Because a lot of, for instance, Keller Williams companies do business as Keller Williams. So if 4 different ones are in Knoxville, they're 4 different franchises, but all 4 have the same name, it may kind of go against what we're saying right here. Is my only thought on that.
I didn't think, Eve, that they could have a name that someone else already has.
They're, like with the Kellers, just to use Keller as an example, they have different, their name would be like the Dream Team DBA Keller Williams Realty. All of the Kellers, except for one, in their DBA is Keller Williams Realty, but the first part of their name may be different, but the end part is Keller Williams Realty.
So we're allowing them to all have the same DBA name?
Because their first name is different, so their whole name is different, but the DBA is the same, and their franchises, so under the franchise portion, they can say each franchise office is independently owned and operated, which probably doesn't mean that much to your average person.
Well, is that not backwards of what it should be?
Well, I mean, I think it's confusing to individuals the way that happens to be set up. It's not, like some of the franchises aren't set up in that same fashion. All the exits are end and exit realty, although some have some identifying information at the end of them.
We all have to have exit something.
Right,
I
like
mean, there
exit
has to be
realty
something
street.
else.
How
with
was yours
it.
done?
Huh?
How was yours done?
My NYPD has nothing to do with my company name, but my company name is Exit Select Realty.
Right.
They couldn't all be Keller Williams Inc. DBA, whatever separate name, because then that would mean they were all singly owned.
Right,
And
but
so
they're,
that means they
they're
couldn't
like,
be
say,
that way.
Keller set up that the DBA is Keller Williams Realty, so that like you have the Dream Team Franklin LLC DBA Keller Williams Realty, the Dream Team Murfreesboro, and Farragut Investments DBA Keller Williams. So they all DBA is Keller Williams Realty, but they have their first portion of their name as registered as the LLC or Corp is
Because they're all
different.
separately owned. They're all separate entities.
Correct, but as I say, if they were just using their DBA name, then they would all look the same.
But they also are required to include the phone number, and the phone number should be different, right? It should probably lead you to whichever office.
One would hope
Yeah.
that if the phone number was included, that you get the right phone number and not like the individual's phone number, that it would lead you to that.
And the way you
But
all
we require
passed
the
it-
firm phone number. We
Yeah.
do require the firm phone number to be
We
listed.
do require the firm phone number.
The way you all passed your interpretation of firm name was that at a minimum, it would include the DBA. So I think to list this under misleading advertising in those cases of franchises wouldn't necessarily fly in the face of what you had passed before, because you said at a minimum should include the DBA.
Well, I can't see us accomplishing a whole lot if we continue to let every firm out there who is a Keller Williams franchise put Keller Williams Realty on their signs, because you don't have a clue who that is. And I mean, I think we're just not accomplishing anything.
You might address that here.
Yeah, this is an example of why these guidelines are a work in progress, and that's a topic we should address, because what we're saying here basically contradicts what we did last month. If at a minimum all they have to put is their DBA, which might be Keller Williams Realty, here we're saying advertise franchise name alone without rest of firm name, complete license name required. The issue is you can't identify a specific licensed firm.
And I think that's what is key here, is that we have to be able to identify which firm it belongs to, besides a telephone number.
For purposes of our discussion today, we may go back and look at what we've done in the past, but is everybody comfortable with that? And we move on.
Could I make just a
Sure.
point about this, kind of related, but I didn't see it addressed anywhere else in this particular section. Don't we do some kind of check to make sure that if there's somebody who applies as a new firm, that their firm name isn't substantially similar to an existing firm name or something like that?
There is an old policy that the commission passed, adopted in like 94 or something, that says that slowly through the years, as I understand it, it's really become, if the Secretary of State accepts the name and we make them give us the Secretary of State information, that we then accept that name. And if they have a doing business name, you know, the Secretary of State is a trade name, then, you know, that's what they turn into us.
So my concern would be that a team name would not have to go through that Secretary of State process because they're not officially being licensed with the Secretary of State. And so my concern would be that we would have some sort of prohibition on a team name that's substantially similar to the existing name of a licensed entity by the Secretary of State.
Or another team name.
Well, maybe, but like, let's say, you know, you were Remax, and you were going to have we're the Keller Williams team or the William Keller team of Remax, or you know, something where you're like, now I'm really confused because your team name is substantially similar to some other firm name out there, and I think we wouldn't want that to happen, and that could be misleading and deceptive if you did that.
Well, like you were saying, the dream team of Franklin, the dream team of Murfreesboro. Well, and then somebody else is just the dream team of Remax, and
Yeah,
I mean,
that's another example.
You all have
yeah.
a list of the big franchises in the back,
Dream
or
team
I
of
guess
Keller
as you
Williams,
scan
too.
through there,
Got a list of all of
kind of just what we pulled off.
If we can, we're going to try to get down to where we restrict how big and what form the team can advertise with that. My goal would be to let people know that they're dealing with a firm, not a team, and maybe that'll help some of this. It's a good point. We may want to revisit that.
I think the Dream Team example is a good one. You know, if you had the Remax Dream Team, well, that looks a lot like the actual entity name of a Keller Williams franchise. And so if somebody were trying to file a complaint about something that team did, it may inadvertently be filed against Keller Williams, which had nothing to do with it, but it was really a Remax Dream, team. And we're just totally talking hypothetical here, but just for purposes of discussion.
All good conversation. Number 3, make representation or claim is misleading, taken at face value and interpreted based on plain meaning. It could be misleading or deceptive. Number 4, even if the consumer is not actually misled, however, the advertisement is capable of misleading a reasonable consumer. May be considered misleading or deceptive. Number 5, if it can be a result of inadvertence, negligence, incompetence, recklessness, or intentionally misleading. It could be misleading or deceptive if the advertisement uses specific industry terms which might be confusing to the general public. In other words, we're saying anything you represent should be clear to the general public, and they should be able to understand what the advertisement means. Look at number 7 on page 4 for just a second. Back to a little bit earlier discussion. If the advertisement holds the team out as a specialty team or compares the team to another team, firm, or licensee, we're saying that could be misleading or deceptive. So if you say we're the number 1 team in Nashville, or if you say we're the number 1 short sale team in Franklin, it's possible that representation could be misleading or deceptive.
Or the commercial team of Keller Williams, or there's commercial division, would that be the same?
Might be, but that's not a team. We're trying to, right now.
So a division's not a team
It
then?
could be. We haven't defined what a team is. That's
Okay.
an issue. We don't have
Because we
that
see the
definition.
division a lot.
Yeah, and we're going to get to divisions. I think that's another day's topic.
Okay.
I think if we get through this topic right here, we'll be making good progress.
Well, or the property management team,
Right.
You obviously, in your company, you have a group that does property management separate. So do they advertise themselves separately? Yes. And how do they do that?
They're just Exit Select Realty Property Management. I mean, we are registered with the state
Okay,
that way.
Just
Okay.
two firms.
I
Okay.
have two firms.
okay. Well, that makes sense, but I bet a lot of people don't do that.
All right, number 8, letter 8, whatever the Roman numeral small 8. If your advertising promotes a team as a single entity, giving the impression that the entire team works for the client or customer, and that's not true. For instance, inside the team, one's a buyer's agent, one's a seller's agent. That's likely to be misleading or deceptive. That's the point. Letter 9, number 9, licensed firm name obscured so not readily apparent to the public, whether by font, size, color, juxtaposition. What does that mean, Ms.
Like
Maxwell?
how it's arranged on the page so that it, like you can put it so that it appears the team is above the firm, or the firm just is sort of written at an angle to the, it just looks like the way you've put the words on the page make it look like the team is the main entity.
That's not my word. I can say it, juxtaposition, but I don't know what it means.
But it's a great word, isn't
It
it?
is, I like
I
it.
love that word.
Yeah.
That's one of my favorites.
And we'll talk about that more in advertising of the team below. Number 10, team internet sites do not conspicuously display the firm name and phone number on each page. That's already in a policy statement somewhere, I think. Okay, so we'll reference that back. These are guidelines again. The team internet site linked to unlicensed real estate business enterprises operated by one or more team members. And I've seen examples of, you go to a website, a team website, and before you know it, there's a link to a separate business entity that I think we've had examples up here before of. And so we're just saying you can't do that. Each page has got to have identifying firm, as we did in number 10, and you can't start trying to scrape people off to unlicensed real estate business enterprises, including property management, I suspect. All right, and again, these are guidelines. So number 5, let's look at these. Always have firm name as licensed clearly and conspicuously contained in advertisement, no abbreviations, omissions, or transposed words. Letter B, the team name cannot be any larger than the smallest font of the firm name as licensed with TREC. Now, we made that decision for licensee names, 2 months ago, I think. This could be controversial. The goal from my perspective was always to let people be able to tell the firm is involved in this transaction or advertisement. And so if we were telling licensees their name on a sign or in an advertisement can't be larger than the firm's name, to me it makes sense that a team's name should fit that same category.
I agree.
There may be discussion on that one.
I really think that's where we've gotten off track, is with team names more so than individuals anyway, and theirs being the largest, most predominant. So I totally agree that team names should not be any larger than the company name.
If I could remind all the commissioners that we are on the record, and to lean over and speak directly into the microphone when you talk.
Who are you talking about specifically?
Right then, I was talking about Michelle.
Well, just call it. Don't blame all of us for something you think it's one person doing.
I will lean over and talk directly into the microphone.
All right. Letter C. Any advertisement must use color, contrast, size, or audibility. I got it right, didn't I? Audibility? Mm-hmm. To ensure that the firm name is readily noticeable and understood, and the name of the licensed firm shall appear at least as frequently as the name or names of any affiliated licensees, team members, and or the team name. Once again, the emphasis here is the firm is responsible for the licensee, and so the firm should get equal play. Because that's, if there's a problem, that's who we've got to go to.
Okay, John, point of clarification here. So we'll use my company, because I don't mind us picking on me, and we'll be Exit Select Realty is on the sign.
Yep.
And then it's the Janet DeChara team, and then we've got, no, I can't do it because I'm principal broker and I don't have a team. I'm just being the example here. And then it's got Connie Knott, Bill Mitchison, and each person of the team under there. So that's, we're not going to allow because the company name's only on there one time?
I was thinking about the audibility part of it more than I was the sign. But here's what happens, I think, in your example on a sign, to get those names on there, the company name's going to have to decrease to let those people get on there. And so the smaller the company name gets, the smaller each agent's name would have to be. I mean, that's conceptually what I see. And these are suggestions and hopefully guidelines. But there are going to be ways around every one of these things if we put these out. I don't doubt that a bit.
John, I think of I can't say it, audibility.
Audibility?
It's like you have an announcer on the radio and he says, you know, Select Realty, we got the team of so-and-so, and blah, 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 blah. Janet the girl, blah, blah, blah. Just kind of blurs everything together there. They can talk real fast sometimes.
And mentions the name 6 times and only mentioned the company name 1 time.
Something like that.
Yeah.
Big blah, 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 and blah, 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 blah.
Incorporate that into your report, will you, Julie?
I want to see how you're going to type that in, Kelly.
I think I'm going to skip over that.
Oh, no. No,
read-
we'll
I
all be
wanna read
looking for
those
the blah, blah,
minutes.
blah, blah, blah.
We actually speak to that in just a second, if you'll just hold that remark for a minute, David. So under letter C, small letter I want to make a slight change to this. But right now it reads, if driving by, the advertisement, or a member of the public can see the firm name while driving at a posted speed. I would like to substitute the word see with the word read. I mean, you might be able to see it but not tell it because it's so small. On the example you're using of 6 names on that sign, so the firm name ought to be able to be read if that's just a...
What if the whole sign is just little? Like they didn't have much money and so they got little signs. You're not going to let them put out a sign because all they got is a little sign?
I'd say nobody will file a complaint because they can't know, they won't...
The sign's only this big. That's all they had.
Yeah, they
That's all they
wasted
could
their money
afford.
on a sign.
Well, we're not, remember the principal broker is in charge of reviewing all advertising and improving it. If he approves it, that's his issue, not the commission's, is how I would answer that question.
I think that was a quick way out there, John.
It's a quick answer. Number 2 under C, if the audio or video, David, number of times licensed firm name is heard, seen compared to the team name, in other words, they ought to be the same. The point in advertising the firm name is used and the speed with which name is mentioned. So your stuff, I mean,
It's covered, isn't it?
yeah, we've got that covered. If you blur the team name, you can blur the firm name, but you can't do the team name and then blur the firm name. We want equal or parity for a team name as well as the firm.
Want to say volume too?
Maybe volume ought to be included in that as well.
Up on YouTube as well. I mean, I think there are a lot of YouTube ads out there where
Virtual tours of...
yeah, where these were coming.
Well, I think YouTube is probably one of the areas that's really starting to get a lot of activity that we're going to see a lot of problems with.
We've seen that. A lot of it's good advertising. It's just focused on the house, which it should be, then the team and the agent, but very little, maybe
About
not
the
even
company.
a company name or a phone number for the company.
How many more staff are we thinking about hiring?
No, these are guidelines now. We're trying to help people out, take the
Okay.
mystery out of it.
Okay.
Letter D on page 5. This is old news, but let's just put it in the guidelines to remind people. The firm name and phone number must appear prominently on every web page and in all advertisements. And there's a little editorial comment there at the end.
I like your little editorial comment there, Dan.
Letter E, we've sort of mentioned this before, but let's mention it again. Web page cannot lead to other websites of other companies with which one or more team members is affiliated and which appear to be engaged in real estate activities such as property management, investor services, etc., that require a license. That's old news, but it's a guideline, so let's include it. F, regardless of the font size, the firm name and phone number must be clear to the consumer and not easily confused with other information. That an audible, it's the real small print, it needs to be easily identifiable. Letter G is kind of a little bit different, but maybe appropriate. It says the team photo, and again, this is probably more website than anything else, must include all licensed members of the team identified individually by name in which the license is issued. So if there's a team website for a team and it shows 4 members of that team, those, if they're licensed people, then they need to have their name. So somebody, a member of the public, can say, this is the person I was working with, and his name or her name is this. This might be controversial. It's new discussion as far as I'm concerned. Any comments on that?
John, I think the wording may be at the end in which the license is issued. We don't issue licenses to teams.
Oh, but each member has a license.
But from a practical standpoint, I mean, aren't practically all teams a member of the same firm?
They have to be.
Have to be.
I thought, okay, that's what was confusing to me. They said you got to put the name of where their license is, what firm their license is with, to identify them.
Oh, like if you, David, and I are all on a team and we have a team photo done and we're doing an advertisement, it can't just have the Janet DeChara team. It's got to have David Flitcroft under his name and Bear Stevenson under his name and my name under mine, so that everybody knows who each person is.
And the reality of it is a lot of teams have unlicensed people on the team too, which we don't control. But as far as the licenses go, let's identify who we're talking about.
Well, actually, that with unlicensed activity, John, if somebody's looking at a website and they've actually been dealing with an admin person who's been out showing them property, and they're filing a complaint with the commission, and they go, well, that's the person I'm dealing with, then we know that we've got a unlicensed agent out there showing, or an unlicensed person showing properties and operating that way.
John, I think it needs to be corrected. We do control administrative people. We limit what they can do.
Well, that's true. Here's, back to Janet's example. If at some point we have a complaint where there's an agency complaint, and on paperwork it shows the team leader as the agent for the buyer, when in fact the buyer has been working with a team member the whole time and has never met the team leader, for lack of a better term, to identify who she's or he or they were actually working with. If we have to break out a picture and say who showed you these houses, who was working with you, she can look at the picture and go, David Flitcroft, as opposed to, it's that person, but I don't know their name. But there are going to be issues with teams that we may or might not ever get to, where people are getting credit and signing disclosures when in fact they're really not the person that's interacting with either the buyer or the seller. There's a real misrepresentation issue that we'll need to address, or maybe it'll be brought to us before it's over.
Well,
but that's not today's topic.
Part of the issue there, I think, is in some of our education classes. I know that we've got a team in our area that was given some bad information in a class that said the team leader was the one who had to sign all documents. And then they were told later by somebody else that everybody on the team had to sign everything. So, there's been some instructional issues that we're going to have to deal with, Steve, with these instructors to get team information correct.
I see that as just as important as what we're doing now.
You can't, it's hard to teach it until you've got some guidelines to
But you've
work
got
off
to have
of.
the
That's-
guidelines first.
But I mean,
That's what we're
once
trying
we
to-
get these in place, I think we're really gonna have to focus
And I don't know
on
how
some
Steve,
education.
how you gonna, well, we'll talk about that later.
I think this team photo rule is kind of getting far down into the weeds. It's just my personal opinion.
I kind of agree with that. But I see where he's coming from.
Well,
I agree with that, but I see where you're coming from.
I have worked in offices with teams, and every team member be blonde. And they would say, well, it was the blonde. Well, okay, gee, 5 of them are on that team, and they're all blonde, so we need a little better description than that. I agree that the team photo should have everybody's name on it.
If you won't hurt my feelings one way or the other.
Let's just keep going. We'll take it out of the weeds later.
I'm just stating an opinion.
Okay, I got you.
I'm not saying you got to do anything about it right now or anything.
I'm trying to keep this framed as guidelines for
Yeah.
people wondering how they can operate.
Yeah.
Letter H, firm names. We've mentioned this before somewhat, but it's important enough to mention again. Firm name and phone number are clearly and prominently displayed, cannot be obscured by shadows, grayed out, graphic, style, thickness of the font, pictures, those kind of things. We want the public to know the company that they're dealing with, as well as the team or individual. Letter I, there's that word again, cannot have juxtaposition of the firm name and phone number and the team name and phone number, which makes it difficult to tell the team from the firm. Guideline. Letter J, if the licensed firm is a franchise, the team must advertise with the entire licensed name so as to distinguish the licensed franchise firm from other like names franchises. As an example, franchise brokerage is not the same name as franchise brokerage of Greater Atomic City, Tennessee. So we're saying, I guess, we're saying that at least at a minimum, the DBA has to be included. Or we're talking just about franchises here, saying.
This one is more, I mean, I think this specific one is really more directed at the franchises where you have those problems of confusing not really knowing which one you're dealing with. You just know that it's, a Remax, and you don't really know which firm it is. And so it all becomes just a generic form of advertising. So this is to identify this really relates only to the franchises. I mean, it would probably hold true for anyone, but this was pointed towards that. Because a lot of states look at teams as I kind of view the franchise issue as part of the team issue because of the advertising involved.
Have any comments or heartburn about this? Remember, it's going to come back to us in the form of guidelines with references, hopefully next month. Okay, and then finally, this section 6 had to do with just kind of a checklist. If you're a team or considering a team, here's some things just to kind of make sure that you're comfortable with and understand before you start advertising. And first is a disclaimer that says the Real Estate Commission does not pre-approve advertising. All advertising under the direct supervision of the principal broker. It is the responsibility of the principal broker to review all advertising to ensure that it is consistent with the Tennessee Real Estate Brokers License Act of '73 and the rules and regulations. Now, I've talked to some people across the state who think it would be a good idea to put some responsibility on the agent or the licensee bringing the advertisement to the principal broker with the argument the principal broker can't see everything an agent is doing. That would probably take a rule change or some reg change, but is there any desire by this commission to shift some of the responsibility of advertising to the licensee and that they would at least have to take it to their principal broker for approval? Or are we still working on the concept that the principal broker is who's in charge and they need to be in charge?
No.
Speak.
Principal broker ought to be in charge.
So leave it like.
I agree. Once you start deviating, then you've opened up a loophole for everything that, well, we didn't do it. You
And you're going to get into all the finger pointing. We're going to be up here in a hearing, and somebody's going to be trying to point the finger at somebody else, and we're not going to be able to tell, and everybody's going to end up trying to
I didn't
walk.
do my job because I thought somebody else was supposed to
Buck
do it.
stops here. I'm the principal broker. That's,
All right. So my comment is noted, and the consensus of the commission appears to be that let's leave it like it is, which works just fine with me. Okay, then some under guidelines. If you turn to the very last page, just for anybody's information, the license law does not recognize a team, and formation of a team does not change the structure of responsibilities for the principal broker, the firm, and licensees to the public. That's just a statement.
true.
Reasonable average member of the public should be able to easily identify the licensed firm with whom it is dealing and a telephone number with which to reach the licensed firm based only on the advertisement. In other words, you should not have to go through a team member or an affiliate license to reach the firm or the principal broker. 3, a team should never give an impression that the team is an entity separate from the licensed real estate firm, that it can operate separately from the licensed firm, or that the team has any type of status with TREC as an independent or licensed firm. Advertising, number 4, influences the purchasing decisions of the public. Truthful advertising benefits consumers and enhances images of the industry. Misleading advertising can negatively affect consumers and the integrity of the profession. So, if you're trying to understand what that means, look at your potential advertisement and say, from a potential reasonable person, can you tell there's a firm involved in it, and can you reach that firm if you need to? 6, the intent of the advertisement is not as relevant as the overall impression. The totality of the advertisement and its likely effect on the target audience. Could the advertisement mislead a consumer acting reasonably in a set of circumstances? Number 7, and I'm going to add a number 8 in a minute to talk about. Number 7, does the team advertise its service or operation in a manner that creates the overall impression that the team is a separate licensed firm? If they do that, then this commission ultimately may decide that's misleading or deceptive advertising and come up with some sort of penalty. Now, number 8, again, as I talk to people across the state, there is this general consensus that may apply to us, may not, that there are some firms in their effort to recruit licensees either explicitly or by implication indicate that if you come to a firm that you can be your own boss, that you can pay your own people. And so it's been suggested, I'm just going to read something and then we'll talk about it, that we have in some guidelines here that firms, when they're out looking for licensees, can't start or use advertising or promotional material to indicate that the licensee can have its own business, for lack of a better term. So just listen to this for a second and see what you think. Firms advertising the benefits of teams to other licensees should not imply or state that the leader of the team can compensate those team members without adhering to TREC guidelines on all compensation flowing through the principal broker. I'll just read it one more time and we'll see what you think. If we had on our guideline checklist right here, this is related to firms, not teams at this point, and that's what's different about what we've talked about so far. Firms advertising the benefits of teams to other licensees should not imply or state that the leader of the team can compensate the team members without adhering to TREC guidelines. especially as it relates to compensation.
Yes, I think I would state it a little differently, but I'm not sure how to put it in words. But firms, yeah. I think that's real. I've even gotten things just in the last, I've gotten emails in the last month. You know, come be a team with us and you can do whatever you want to do, basically.
That's what I'm hearing.
I'm here, I've saved them. It's amazing how they can, yeah.
That's the last thing you had in this section.
Oh, yeah, I'm not quite
Mr.
done with
Gray.
it, though.
Okay, I mean, it's 30.
I know.
It's.
I may be done with it. If everybody says that's a good idea, let staff figure out what to.
I think it's a great idea. I like that one.
My opinion, and I'm not in the business, so take it for what it's worth, it just seems like that's starting to get off track of what our charge is, which is to protect the consuming public. And somebody who's a licensee, they ought to know what they can and can't do. And I understand maybe we're out to protect the licensee from the principal broker too. Maybe that's where we're going with this. But it seems like they ought to already know what they can and can't do if they're a licensee.
Austin, one of the things that I think we run into that obviously you're not going to see from your perspective is that a lot of these teams are out there with the principal broker paying the team leader, and then the team leader disperses that commission check ever how they see fit. Well, of course, the way track rules are written, it doesn't allow for that. And so that's kind of, I think, where this comes back full circle is just to reiterate that just because you've got a team doesn't mean you can operate that team outside of TREC guidelines.
Oh, absolutely. I agree with that. I guess it's just saying, we're talking about not only regulation of advertising to the public, but you're also talking about regulating advertising within the industry to attract employees or licensees or however you want to characterize it. That seems like you're going in a new direction to me.
It is. It's definitely a new direction,
Yeah.
but it's maybe
it's needed.
Maybe it's not something we should talk about now, but it is something that, particularly on a national basis, is becoming more and more prevalent.
Well, I think it's necessary to be a part of this discussion because they're out there recruiting under the stance that you can come here and brand yourself. We don't care if the company's branded or not, which has taken us away from the company being advertised with that agent. So I don't think this is the wrong place for it because I think they're doing their recruiting in that vein, and it needs to be realized that they can't do it. It don't matter what their recruiter tells them. There's guidelines that you got to go by.
Let me just say one thing about it. I think Austin is correct. This is a different topic, but the topic is related to all these other issues because if somebody comes to work for a company with no supervision and apparent carte blanche to do whatever they want to, that's the initial stage of some of the complaints that we've got, or that there is no supervision on it. Frankly, the reason I even bring this to you is I've talked to brokers who are really upset that they've lost licensees to firms that encourage teams, and they give the reason they are going, why the licensee is moving, is they've been told they can basically do whatever the heck they want to. There will be no supervision, even to the point of being able to compensate team members themselves. So all the money, and I've not experienced this personally, but apparently all the money flows to the team leader who then writes checks, which is well beyond our control at that point. Those are IRS problems more than anything else. Pays the team members what they want to. So it's advertising. It's not directed toward the team member so much as to the broker of the teams, I think is probably the best way to say that. And I'm not sure where Julie can fit that in or not anyhow, but if the commission so agrees, we can at least let her take a shot at that and bring it back to us next week.
So my
Next
understanding of all this has been that you all were discussing this for our benefit, in drafting some guidelines. You are not at this point adopting these things as guidelines. This is just so that we could get a feel for it, to try to put something in a format to disseminate to licensees, and then you all will come back and read.
In an ideal world, in my simple mind, you'd get this done in a format that you think would be presentable to licensees or brokers, trade associations, whoever, with references. So in case they say, where'd you come up with that? It would be clear, and we could approve it next month in Farragut.
Okay. So I just don't want anyone to be, that maybe listens to our meetings or is here today saying they adopted these guidelines. I just want to make it clear you're not adopting them at this point. You're just kind of discussing for purposes of developing some guidelines, and that's this. We seem to be all on the same page.
It has been brought to the attention of several people on this commission that these teams, to paraphrase it, have gotten out of hand. Mm-hmm. And we need to, from the standpoint of, as Commissioner McMullen brought up, our job being to protect the public of Tennessee, we need some guidelines to make sure that it's not deceptive and that we let these teams know that what they should do and how they should do it. And these principal brokers, they're the ones that are in charge as long as our statute is the way that it is. And it's right now 20 minutes till 12, and we need to break here shortly. Commissioner Grease, I'm going to let you make this call.
That concludes my report, Mr. Chairman.
Mr. Chairman,
Commissioner Alexander.
I'm going to ask that we go to lunch, we go back to the agenda, and then if we want to discuss this, we leave it open where we can do it later in the afternoon.
I agree.
What time are we coming back?
Look, as soon as we can get back. We have an informal appearance at for a 50-mile rule request at 1 o'clock, so we need to get back as close to 1 o'clock as we can. But since we're breaking almost 20 minutes till 12, we might be 5 or 10 minutes after.
Chairman, perhaps members of the audience would like suggestions on good places to eat?
Oh, Austin's in, yeah, oh.
No.
Good places to eat around here.
Miss Maxwell? Yes. Where can these people eat?
Farmers market.
Just walk.
Farmers market that's relatively close
Yeah.
by. If you walk out to the building and to your right, make a right in front of that other building there, you'll go under a bridge. There's a lot of restaurants in there. That's within walking distance. That's probably the closest thing.
It's kind of neat over at the farmer's market, too. They got vegetables and all that sort of stuff, and we are now recessed for lunch. Are we ready? I call this meeting back into session. Our first thing on our agenda this afternoon is an informal appearance and request for waiver of the 50-mile rule.
Are you going to finish the morning's agenda?
I think we probably just need to go ahead and hear this first, since this gentleman is here, and then we'll go back up and we'll get this other out of the way, and this individual can go on his way since he is here. But I would like to call Principal Broker David Carroll of RealEstateAuction.com up to over here, Mr. Carroll, and have a seat. And I'm going to, and also, he's informed me that the licensee that he's requesting a waiver of the 50-mile rule for is not here, had some health issues, and she is not here. So, Ms. Maxwell.
Yes, Mr. Carroll is the principal broker of a firm called RealEstateAuctions.com, which is located in Franklin. And he requested a 50-mile waiver for a licensee affiliate broker named Marva Elaine Wilson, who lives in Cordova. And Mr. Carroll had emailed us while we were in the meeting this morning and indicated that Ms. Wilson had some health issues and some car troubles and was unable to make it. And by the time we could get back to him, he was already here from Franklin. And so he, just wanted to come, and Chairman Stevenson had told him to let the commission decide whether to go forward, or he can tell you a little bit about his company, which he can probably do better than I can do. I have researched it online, but obviously Mr. Carroll's intimately familiar with it. And maybe he would have to appear at a later time with Ms. Wilson, but it's the commission's decision how they would like to proceed in this matter.
Ms.
Chairman,
Maxwell,
I move we defer.
go
I
ahead.
think we need to look at the person when they're here.
We have a motion by Commissioner Flitcroft to defer this request since the person, Marva Wilson, it's actually, the waiver will be for. And do I hear a second? So there's no second, Commissioner Flitcroft. Your motion dies for lack of a second, so
Mr. Chairman,
Commissioner Alexander.
I'm going to request that Ms. Maxwell bring us up to speed. I'd rather hear you first.
I can tell you that neither Mr. Carroll nor Ms. Wilson have any complaints having filed against them. Mr. Carroll's company is an auction company similar to, well, they have people on the ground, so it's not exactly like auction.com. He probably doesn't like my comparing it to that. But it's similar to that, except for the fact that RealEstateAuctions.com does have individuals on the ground for their auctions, licensed individuals. They're licensed in a number of states. They represent sellers and buyers, and they have a good set of checklist items on their website. If you're going to be a seller, the things that you have to have, clear title, disclosure. They hold 3 open houses at least for every seller that they have. As far as the buyers go, they encourage the buyers very strongly to get inspections, make sure that you've done everything that you have to do before you come to the auction. You have to register at the auction. If you have a agent with you, that agent has to register as well and appear at the auction with you, but then they would pay, they indicated on their website they would pay a commission to the agent that was there present with the person. If you buy, you have to put up the earnest money immediately. You have to come with a cashier's check for $2,500. And they operated, as I said, in a number of states, and they have a checklist of within their office of things that they do weekly. They have weekly meetings, weekly reporting meetings. Mr. Carroll has some numbers that show really the demographics in each part of the state and the number of houses that I believe, people in houses that they can reach as they work through the state. As I say, they have a pretty structured office situation in which they have weekly meetings and they have accountability reports from their team leaders. Mr. Carroll would be here in Franklin. This would be the main office and really the only office, the only on-the-ground bricks and mortar office located in Tennessee. And I'll let him explain the rest of the structure of his office and operation.
Thank you, Ms. Maxwell. And Mr. Chairman and members of the commission, I respectfully appreciate you hearing this today. It is a disappointment that Ms. Wilson was unable to attend. She's been looking forward to this and has had some health issues, and this morning had a sudden attack and was unable to appear. As Ms. Maxwell so nicely represented to you, our company is a startup auction company of experienced and professional realtors and auctioneers across the United States. We were originally founded in Chicago, Illinois, and most recently moved our headquarters to Los Altos, California. Brian Custis is the founder, and he developed this system. He's divided the United States into 342 territories by approximately 1 million population demographics. Each territory will have a team leader and have originally 3 project managers. Now that has been moved to 4, 2 with a commercial interest and 2 with a residential interest. We're trying to abide by of course, the rules of multiple states. I'm only concerned with Tennessee at this time today. And I am regional director for both Kentucky and Indiana as well as Tennessee, but I am the state broker of record for Tennessee. I've been a broker here for a number of years. I've been a licensed affiliate since 1987. As Ms. Maxwell indicated, I've never had a problem. I've never had an opportunity to address this board other than to just participate as a member of the audience. Our program, though, does, however, allow for strict accountability
and focus of the job. We certainly respect the responsibilities of the broker and also our brokers. We certainly do not want to hold ourselves out to have a quasi-branch office in any other part of the state. Our proposal is, and I explained to our founder, that this was contrary to Tennessee practice, to have one office for the entire state of Tennessee. Unlike some of the traditional real estate companies, and we're more of a hybrid, we are not a mega office, and we're not out recruiting just every general agent and charging desk fees and things like that. We're specifically in the auction business of real estate only. We do not auction personal property, pots and pans, office closeouts, or things like that. We do represent asset managers, banks, individuals, anything real estate in any category, whether it be industrial, commercial, residential, multifamily, land, whatever. Our team is coached each week, not only by me, but by our corporate staff and our trainers. We have an accountability agreement they sign just to even come on with us before they go into our 2-week training. And then each Monday, they participate in a corporate call for the entire company. And each Friday, I lead a state call just for our state brokers here. We're just launching, so we don't have a lot of activity. I've lost a couple of people because of the timing of this already. I had a broker hired in the Chattanooga area, and his father was able to persuade him to stay with their firm by doubling his salary and kind of held him hostage there. He was a great young man, and I think he would have been a good example. It's my understanding in discussions from our attorney with Ms. Maxwell that the brokers are exempt from the 50-mile rule, and that she can allow waivers up to 75 miles at staff without coming before this panel. Certainly don't want to waste your time. We have I don't know if you have all the documents with you, but Tennessee has been divided into 6 divisions or 6 territories for us. So we're going to look at a maximum of approximately 30 agents, whether they be broker or affiliate broker. My goal is to hire as many brokers as possible. I think that 1, just their experience helps us. 2, they're exempt from the rule. And because of the geographic center here in Tennessee, we can, by hiring strategically brokers, eliminate this process for, I would say, 40% of our agent population, just because of where they are located and the way the territories fall. With the extremities of East Tennessee, West Tennessee, and Southeast Tennessee are my biggest concerns and biggest issues. I will do whatever the wishes of the commission are. I have put my company on notice that we may be required to have, sub-offices with a firm license and a broker for each location. That is Plan B, should this not be approved. I'm not asking for a blanket request, but I will tell you, should we be approved today, we'll be back, for future requests as well. Up to, like I said, approximately 30 people. There's occasion we might hold a neighboring broker's license that's also licensed here in Tennessee. Maybe they're the regional director in Mississippi or something like that, but they hold a Tennessee license. We may hold their office. But we're not here just to hang license. We're not a license hanger. We're not a mega office. And respectfully, I present that our systems, process, and accountability allows me to supervise that number of people easier than some of these offices that we currently have in the state that have several hundred agents under one brokerage, whether they live within 5 miles or 50 miles. There's some retooling I think could be given to that as well. I've been a part of some of those offices, and they're good people. Everybody has the best intentions, but it becomes a demise of supervision at that level, in my opinion. So.
I have a couple of questions.
Yes, sir.
Where'd you go to auction school?
I went to auction school at the Nashville School of Auction in Tullahoma, Tennessee. Wendell Hanson was my instructor.
Graduate?
I graduated 5 years ago. Like I said, I've been a broker since '87, or affiliate broker. Got my broker's license in the '90s. referred auctions because they were a business that I really care about, but I never wanted to take 10 days out of my business to go sit for my auctioneer's license. When the market kind of stopped on us and the music stopped, as I like to say, in 2008 and 9, I felt like this was my opportunity. So,
Second question.
yes, sir.
Do you do on-site auctions? You do online auctions? You do both kinds?
We do both kinds. We have three basically auction styles. Ballroom, which is multi-asset auction, in a venue here in Nashville or somewhere else. On-site, on your lawn, just like most of the traditional firms that I've been, and I've been a principal auctioneer for other firms as well. And then we also do online, or we do simulcast combination of all the same.
Are you also, you said you had Indiana, Kentucky, and Tennessee.
Correct.
Now, are you the principal?
No, sir, I am.
In Kentucky and Indiana?
Currently, I don't have those states up and running. I'm trying to get Tennessee, stabilized first, but I will hire a specific broker for Kentucky and a specific broker for Indiana. I'll just be the regional that they report to. I'm not going to try to do, I could, it's reciprocal, particularly in Kentucky, I believe Indiana is as well.
Miss Marva Wilson. Miss Wilson, is she an auctioneer?
No, ma'am. No, sir.
So your business model is such, you said up to 30 people in Tennessee.
Correct.
That's what you had plans. I mean, you're going to rely on just brokers who are going to be out soliciting and talking to people about selling properties by the auction method of marketing without it?
They would refer it to the auctioneer, and we will have more auctioneers on our staff here in Tennessee as well that hold both brokers, but they must have a real estate license as well. Can't sell real estate at auction without a Tennessee real estate license.
I'm one of both myself.
Yeah.
But anyway.
I am a member of the NAA, TAA, and certainly respect those rules as well.
You passed this model before the Auctioneers Commission?
Sorry?
Have you passed your model before the Auctioneers Commission?
I have not had a meeting with the Auctioneers Commission. I think I know maybe where you're going with that is whether or not a real estate broker can solicit an auction or not. And I do, I'm very much aware with that. All this is a referral. And it's no different than firms that are currently operating here today that have an auction division within their real estate firm, and they leverage the agent population for an asset that might be an auction prospect. And I have always had strict policies and procedures that ensure them that they cannot speak about booking, if you will, an auction. They must refer it to the auctioneer.
Are you going to physically be located at the Franklin office?
I am physically. It is not a virtual office. I have a desk and a chair and credenza and bookshelves and people that answer the phone and those sorts of things.
So you talked about teams. Would there be 6 teams in the state of Tennessee?
Correct.
And what is a team to you?
A team is basically just a designated territory of focus. Rather than having an agent such as yourself, John, run from one end of the state to the other, we just geographically said, if you will focus in these counties, and here's the list of those counties. They're broken out. If you don't have a copy, I'm happy to share. And it's not to say they can't refer business to Chattanooga from Memphis or Nashville or Knoxville, but that would simply be that. It would be a referral to their teammate there and vice versa, and across the United States as well.
So who's in the team? Is there a team leader?
Yes, sir. Our program designates a team leader for each division. So there would be 6 team leaders, one of which would be the state broker. That currently is me. I am the state broker of record, and I'm also the team leader for Territory 231, which is Williamson County, Rutherford County, Murray, Coffee, all that. It's several counties that direction. of approximately 1 million population. That's how we've tried to most efficiently divide the state.
Those other 5 team leaders, when you have them on board, will they be located out of Franklin, or will they be located?
Correct. Our request is that everyone hold their license in Franklin, Tennessee, or some other designated location that we would, appeal or put a proper transfer into the state if it needed to be relocated. But this business model, like I said, was created by our founder, Brian Custis, and I explained to him up front that in Tennessee, this was going to be an uphill, decision, but I'm not saying Tennessee has to do what every other state does. I don't operate that way, but I will tell you that this is working flawlessly in other states. We're currently licensed in 20 states, and our goal is to be licensed in all 50 by the end of the year.
Here's Max. You go ahead, John.
Just one thing. The reason I didn't second Commissioner Flitcroft's motion is because I think embodied in your correspondence is you'd like some sense of direction from this commission whether we would even consider it.
Correct, and thank you for that. And as I shared with Chairman Stevenson and Director Maxwell prior to this, and I'm embarrassed the fact that, that, again, Ms. Wilson was unable to attend this morning. I respect your time more than you know, and that's why I'm here, and that's why I want to chat with you, and I don't want to take up a whole lot of your time today. But I'm willing to do whatever the wishes of the commission are. Deferment is fine. I'm happy with that. If you could give me some guidance as to whether, that's why we're not here asking for a blanket, request for just 30 unnamed, individuals. I think you do have the right to understand who those people are and see if they fit. We've got some qualifications that they have to meet as well. Ms. Wilson has shown that promise. She unfortunately is just battling some health issues right now.
Tell me one more time the name of the man that headed all this up.
His name is Brian Custis, and that's Kuzdas. He's been a long-time commercial broker in the Chicago market, and the way he came up with this concept was he was a apartment conversion master, actually, and that's where he was very successful in converting downtown Chicago apartment complexes into condominiums and then ultimately selling them at auction.
Is Maxwell?
Yes.
Is this part of the same folks was in here pitching the same thing a month or two ago?
No, it is a different firm and a different concept than what the individuals that were here.
Basically the same, though.
Well, the individuals in here the couple of months ago would go into developments and sell those with massive numbers and then move on to the next development.
Unlike some of the other national firms, and I believe auctions.com was mentioned earlier, and I certainly respect them and their business model, we are not a virtual company, and we're not just simply a technology company. Our goal is to have agent-specific, knowledgeable in their neighborhoods. That's another reason of having the territories, is that we hire people that live within those territories, and they know their bankers, they know their sellers. And so we feel like it's a blend of the best of two complexes. We come in with the technology, we come in with a top-down approach from working with asset managers, Fannie Mae, Freddie Mac, FHA, HUD, whatever. But we also have a boots-on-the-ground approach of local people that that you go to the City Cafe with, and earn that business from the ground up. So it's a unique model. If you stay in this business, as long as we've all been in this business, you understand that change is the only constant, and so we're always going to see a new approach.
Ms. Crop.
Can I ask you a question?
Please.
I'm Julie Kropp. I'm the attorney for the real estate the board attorney, and I'm also the board attorney for the auctioneer commission.
Thank you.
And I just had a question. Who is the owner of the firm and the owner of who's listed as the owner of the auction firm and the owner of the real estate firm?
Okay.
Who owns it?
Okay. The company is a privately held company, and Mr. Brian Custis is the majority stockholder, okay?
Okay.
There are some investors that I don't know the number of private investors, but as a regional director, I have an equity position in the company, and I am an owner of the company, a small share. And so I do, we meet those qualifications. So the license in both cases for the real estate and the auction commission was presented by our attorney as RealEstateAuctions.com of Tennessee, LLC, who I'm the chief manager of.
Okay, so I believe, and I'm not positive.
And it's held under a bubble of RealEstateAuctions.com global, okay?
I believe that at least the auctioneer commission, and I'm not the one that handles setting up licenses, so I'm not positive, but I believe they keep track of an individual person who is the owner as well. Do you know if there was an individual person listed? Was it you?
Brian and I.
So do you know if they told you if it was considered an auctioneer-owned firm or a non?
Yes, it is.
Okay. All right, I just wondered
And
how that
thank
was
you for
set up.
clarifying that, but yes, we did go through that process, and our attorney, David DeZura out of Chicago, brought that issue back to me. I made him aware, and gave him documentation that I am, minority owner, and that did satisfy the auction commission.
And did you have any plans to discuss this business model with the auctioneer commission at any point in the future? I know you said you hadn't yet when Chairman Stevenson asked you.
Well, our real estate, has just been our first priority because of this supervision rule,
Okay.
So, but I'm more than happy to address the auctioneer commission as well. If there, I didn't know of an issue that we were running contrary with, like we were with this supervision rule.
No, I think that it might be something worthy of coming before that commission
more than
over
happy
before
to,
you.
more than happy. And I certainly, look forward to your counsel on that. And if there should be, I want to be the first one to be made aware of it so it can be addressed.
So,
I've never been here under, the scrutiny of either commission, nor do I care to be, so please understand that
I'm going to ask you one
I
question.
want to be a solid citizen.
I'll ask you one question, and I'll give you my opinion.
Yes, sir.
Okay. So, in your business model, if somebody's in Johnson City and they refer an auction to somebody,
sure,
somebody within your firm, how do they get paid?
How do they get paid?
Yeah, and who pays them?
Well, the money would come in to the auction company first, as an auction, but because it's real estate, the real estate firm is involved, and it would be distributed just like any other co-op commission,
To go through the team leader and then to the...
No, sir, absolutely not, no.
Okay, well, here's my comment. Just, if you're looking for direction, this was just my initial thoughts.
Thank you, and I respect your opinion,
So,
John.
in my opinion, as I sit here right now, if you're going to have 6 divisions, then it would be a lot easier for me to grant mileage waivers if it was mileage waivers from one of 6 locations.
Within those 6 locations.
Right. Instead of us trying to approve a licensee in Cordova, which is 3 or 4 miles, 300 or 400 miles, 200 or 300 miles, I don't know.
Sure, I understand.
But if
I've
you
got
have
a son that lives there. I drive there frequently.
Okay. So my opinion is I'd be much more comfortable just talking in general terms with you at this point.
Thank you.
Knowing that you're asking for a waiver of 65 miles from a center in
Correct.
Knoxville as opposed to 180 miles from a center in Franklin.
So if I understand you right, if we came back with 6 branch offices that each had a firm license and a principal broker of record, then we probably could.
Easier sell for me.
Yeah, I understand, and I appreciate it. The only reason, and I've already presented that scenario to our corporate, we just haven't had to do that anywhere else. That doesn't mean we won't abide by that if necessary. I don't have a problem with it. It is certainly just an economic issue, of rents and fees.
If I could make Commissioner Alexander, before you ask your next question, the statutes vary so much from state to state.
Correct.
Some states, it's totally different from what the statutes under which we operate in Tennessee.
I understand.
And we're held within what our statute dictates. And just like what Commissioner Grease was just saying, that very likely is going to be something that you're going to have to do to comply with our statute. Whereas other states, you don't have to. But anyway, that's just.
And like I said up front, I am no way am I suggesting that just because it can be done in another state doesn't mean that Tennessee needs to do that. I respect our commission, I respect our state and our laws, and am happy to work under the guidelines of that. If we have to have 6, 7 offices, that's what we have to do if we choose to do business in the state of Tennessee under this model,
Chairman,
Commissioner Alexander,
I'd like to make a motion.
what's your motion?
My motion is that this whole matter be deferred until he goes before the Tennessee Auctioneers Commission and then we'll come back and address whether we approve it or not. But I think some issues there.
We have a motion on the floor by Commissioner Alexander that this matter be deferred until Mr. Carroll has an opportunity to go before the Auctioneer Commission and for some guidance and direction, and then come back before us, and we'll hear it at that time. Do I hear a second to Commissioner Alexander's motion?
Second.
I have a motion and a second by Commissioner Flitcroft. Discussion on the motion.
I have discussion. I kind of agree with, I think he needs a little guidance, and in my opinion, a broker is going to have to be in each of your little divisions, and your agents then will be underneath that broker. I'm kind of go with Commissioner Grease on this, and I'm also an auctioneer and a real estate broker, so I kind of see where you're coming from, and it's a great idea. But if we're gonna stick with what Tennessee law dictates we have to, that's probably what you're going to have to do. So that's my guidance, is the way I see it. Now, I don't know how some of the other folks here see it. So.
Any other discussion on the motion?
Yeah, I'd like to, in all due respect, Mr. Alexander, are you suggesting it might be a moot point, we don't need to discuss it, or?
I think that why should we discuss it and approve it for him if the auctioneers commission is not going to approve it? I think he's in problem. He's for sure in problem because I ain't gonna vote for it today of getting anything passed. But if he gets back the 6 divisions like you talked to, I might have an interest in it. But I have no interest in I can tell you right now, if it comes to the floor, I'd vote against it.
So you're saying if a company's called auction.com
I don't care what it's called.
of some form or another, it ought to be first approved by the Auctioneers Commission and then come to us?
Yeah, he gets his approval that he has, that they sanction his model, and auctioneers like he's talking about, like he's presented to us, then we'll come back with no guarantee today we're gonna do anything, but we'll listen to you.
You know what, as far as an auctioneer, me owning Stevens Realty and Auction in Clinton, Tennessee, I can have an auctioneer license with Stevens Realty and Auction living in Memphis.
There's no 50-mile rule.
There's no
for
50-mile rule within the auction commission in Tennessee. So it's going to have to come back to us anyway as far as
I think we're
operating within our 50-mile rule. Yes, Commissioner Alexander.
But he was talking about using folks from other firms.
No, sir.
No.
I don't think so.
No,
within our firm.
Yeah, he's going to, all the people that's going to be working in this firm are going to be licensed through RealEstateAuction.com.
Okay, my motion's got a second, I'm gonna call for the question.
Okay. Question's been called on the motion.
Request roll call.
Roll call.
This is a vote on whether or not that Mr. Carroll should first get some decision and guidance from the Auctioneer Commission before returning back to the Real Estate Commission for a decision on the 50-mile rule. Alexander?
Motion.
Collins, absent. Grease?
Yes.
Flitcroft?
For the motion, but I'd like to state my reasons, and the reasons are, first, I think that the Auctioneers Commission needs to be involved. Secondly, you'd have a vote if the lady was here and you had your little segments there. I just wanted you to know that.
Thank you.
And sir, it's often said it's easier to seek forgiveness than permission. asking permission, and that's to be commended.
Haynes?
I think he's come to the right place first, but I am going to vote for the motion just because everything that's been said.
McMullen?
Yes.
Chara?
Yes.
Stevenson?
Yes.
The motion carries 7-0. 7 yeses.
If I could just respond to the vote, thank you very much for your time today. Thank you all for your diligent, concern. That is what I'm here for. I want to operate within the guidelines of both the Real Estate Commission and the Auctioneer Commission. I've been proud to have, like I said, never had a complaint, and hopefully that won't change in the near future or the long future. But I think we can get an answer from the Auctioneer Commission probably through staff.
They're the ones that make the decision. I mean.
Yeah, but whatever we need to do, I believe we can address that, and I do have to agree with Chairman Stevenson on that. I think that the rule is the 50-mile rule is what we're working on, which is a Real Estate Commission matter. I have prepared my group that this could be the result of this. This was just the first opportunity we've had to address it. I'm sorry Ms. Wilson wasn't able, and I thank you again for your time. And I respectfully request an opportunity to come back and meet with you again.
Mr. Carroll, I would just like to say that if you come back, we've had this brought before us before, people wanting a broad expanse. And I'm like Commissioner Grease, if you're 100 miles away, okay, we can work with that. If you're 300 miles away, I'm probably going to have some issues with that.
I respect that very much. Thank you. Y'all have a great afternoon. Thank you for listening.
Thank you, Mr. Carroll.
My pleasure.
Okay, now, next on our agenda, we're going to back up. Did you get everything done with the teams, Commissioner Grease?
Yes. I think I mentioned earlier that concluded my report.
I just wanted to see if you had any thoughts of wisdom while you were having lunch.
Not with the people I had lunch with.
Okay.
Thank you, John.
And I shared part of my lunch with you.
Now, we've got our October, Miss Maxwell,
Yes.
you're in charge. You
Okay,
haven't finished your report yet.
Yes, Doc, this is just information about the meeting, October 10th and 11th, which is Thursday and Friday, in the town of Farragut.
Thank
Much
you.
like a village, I think. And the meeting room.
Village idiot.
That's right.
Thank you.
If he lives there. The meeting room is it's the Farragut Town Hall, and Commissioner Flitcroft gave me directions the other day. It's quite simple to get there, but I won't try to tell you. And the directions are there, and we're staying at the Hampton Inn and Suites, Knoxville, Turkey Creek, Farragut, and the address is there. And I'm guessing that maybe Kelly will send the confirmation numbers later. Yeah, she'll send the confirmation numbers later.
Kelly, can you also send us this sheet here that's got all the phone numbers and addresses on it, please? Thank you.
Since we're on this meeting for next month, I would like to ask if he would be willing to share with us, Commissioner Grease, what you have, and I want to congratulate and commend Commissioner Grease for what he has done in getting this meeting for all of us prepared in West Knoxville and the town of Farragut.
It's not West Knoxville, it's the town of Farragut.
The town of Farragut, somewhere located in the western part of Knox County.
Thank you.
Okay. But anyway, you have the floor, Commissioner Grease.
I have no report. I would like staff and their families and members of the commission to know that there are events scheduled for both Wednesday night and Thursday night. And the invitation, which you will get verbally or informally, is directly sent to members of this commission, their families, and to the staff in particular, and your families, whoever you want to bring along. So Wednesday night and Thursday night are handled. The Thursday night dinner is sponsored by the Knoxville Area Association of Realtors at a nice restaurant overlooking a marina and a lake. It's good food, good view, and a good place to go. Ms. Maxwell, we also, despite certain reservations that I might have, we'll have our 40th breakfast for those people in East Tennessee, any number up to 255 people that have been licensed for 40 years or more. That's sponsored by a company called Mortgage Investors Group, and the logistics are being handled by the Knoxville Area Association of Realtors. And Steve, whether he knows it or not, has agreed to help out if he can in some form or fashion. So with that said, I anticipate the breakfast being on Thursday morning, 8 o'clock. And based on what I've never attended one of these meetings, but I suspect that the meeting won't end by 9 o'clock. And so my request or direction, I'm seeking direction, or you guys tell me what to do. There's no way the meeting can start the first day at 9 o'clock if we're trying to feed somewhere between 40 and 255 licensees. So should there be a later start date or a later start time on the first day? That's just kind of a question, Mr. Chairman.
Have we not in the past started at 10 o'clock?
I think we have after we learned the first
Right.
time that it wasn't possible to finish.
How far is the meeting from the breakfast?
5 minutes.
Okay, so we'll have to get in a car and go somewhere. It's
Correct.
in the same building. Okay.
So do we need just a motion on the record that we start the meeting?
Yeah, probably would be the best thing to do.
I'll make a motion that our start time for Thursday, October the 10th, or October the 11th, be at 10 a.m.
The 10th.
Is it the 10th?
What day is that, Thursday?
Thursday is the 10th.
The 10th.
Okay.
I'm looking
October
at the, yeah, Thursday's the
Thursday's
10th.
right.
Breakfast is at 10.
October the 10th at
10th.
10. Have a motion by Commissioner DeShara that we start our commission meeting on Thursday, October the 10th at 10 a.m. at the Town Hall in Farragut.
Second.
And second by Commissioner Flitcroft. Any discussion? Hearing none. All in favor say aye. Aye. Opposed, no. Motion carries.
All right, with that said, then, do you need a motion about this breakfast, or is it just going to start at 8 o'clock, or how do you guys handle that?
I think it's probably better to have a motion just to have it on the record that the commissioners were all in favor of having the breakfast.
All of us?
I'll let the
Well,
record.
if it,
Roll call vote.
All these days, you will have been licensed 40 years.
Yeah,
And
you-
I won't be at a breakfast getting a certificate.
Mr. Chairman, so moved.
Mayor Stevens.
Commissioner Flitcroft makes a motion that we go on record as saying that we have our 40-year recognition award for all those agents in the East Tennessee area who have had their license for 40 years and longer, start at 8 o'clock at Fox Den Country Club. Do I hear a second?
Second.
Any discussion? Commissioner Alexander, second that. Any discussion? Hearing none. All in favor say aye. Opposed, no. Motion carries. And let the record show that Commissioner Grease passed on the vote.
John,
We
which
have-
is gutless on my part.
We have
frankly.
six yeses and one pass.
I'll vote yes.
did you say it was at the Fox
What
Glove?
is the chairman?
Fox Den Country Club.
Fox Den?
Fox Den Country Club.
How far is that from the hotel?
It's about,
Close.
it's real, it's within 5 minutes, everything.
Okay.
It is.
Yeah, yeah.
Yes,
Can I ask a question?
yes, Dr. Alexander.
I want to know what the chairman's done to help you facilitate all of this stuff.
Well, first he appointed me to do it.
Is that
That's
it?
the end of my report, right?
See, and I keep bragging on him. He's done a wonderful job. I called him, asking him if there's anything I can do to help. He said, no, get out of my way. You'll mess it up. So I've stayed out of his way.
Well, then you've done an admirable job.
Yes, I am.
That was just one call you made, right?
Yes.
Just one, I just went for the record.
Yeah, just one of many. Okay, anything else on our October 2013 meeting a month from now?
Will there be a hearing? Yes. There will be a hearing.
On Friday?
Yes,
On Friday.
at 9 a.m.
Just for scheduling purposes, the dinner on Thursday night, I believe will start at 6. Social hour, dinner. So we may have to work a little later on the first day because we're starting an hour later, but
And that is not Central Standard Time.
It is not.
of course not.
Oh, it's
No.
Eastern.
It's Eastern Time.
John,
Yes, Mr.
Eastern
American
Daylight
time.
Time will still
What?
be in, right?
American time.
American time, yes.
American Time, okay.
Anything else on the October meeting in Knoxville?
On Friday, breakfast will be provided by Hampton Inn.
Motion to go to the next item.
Do what, Commissioner McMillan?
Motion to go to the next item on the agenda.
Thank God.
Thank God. Miss Maxwell, continue
Yes, this
on.
is the last thing on my report. I know that you all are glad. I just have one letter from an individual who is requesting a waiver of the E&O penalty fee. And this is a licensee, Miss Barbara Bobby Lovretta from Memphis, Tennessee. She's been licensed since 1989. She has been ill, and she has a doctor's statement to back that up. And I'll read her letter to you. Commissioners, I'm requesting that the $500 E&O insurance penalty against me be waived. I have attached a letter from my doctor attesting to my condition and why I was not able to handle any personal or business matters. I hope that you understand that I was not myself during that time period. I was informed that on July the 1st, 2013, a letter was mailed to me concerning my E&O insurance status and what needed to be done. Unfortunately, I'm still sorting through and trying to locate mail and letters that came to my home for various reasons. Thank you for your consideration and understanding in this matter. Please feel free to contact me if you need any other information. Warm regards, Bobby Lovretta. She did get insurance, but it started August the 1st. And the statute required that on the 31st day, she owes $500. And as I say, on the 1st of August, she actually had purchased her insurance on July 27th, but she didn't have it become effective until the 1st of August. She does, in fact, have a letter from a doctor that describes in detail an ongoing condition that she has been under medical care and treatment for, and the doctor, in fact, does say that she was not functional and was on short-term and long-term disability during the fall, and during the fall of 2012, and it continued on until the spring and really through like June of 2013. Her condition, which is actually an ongoing condition, but it worsened during this period of time.
So she purchased the insurance within the 30 days?
She did, and really it's to provide us proof of insurance, and she purchased it, and I don't know, she is a little bit confused. She's an elderly lady, and she is a little bit confused about it. She purchased it, but then did not have it begin until August the 1st. And so she was suspended July the 1st in accordance with the statute. But then she would have had to show us proof of insurance by July the 30th. And on the 31st day, the $500 penalty fee attaches according to the statute. So by the time hers started on August the 1st, she was actually 2 days into that period of time that the penalty fee was attached to her license. And so now she wants to go back active. She feels like, and her doctor feels like, that she's stabilized enough on her medication to return to work. And so she wants to return to work. And she, as I say, has an insurance policy. We have proof of it in force. And she provided proof of it. The thing is, it didn't start until 2 days after the...
And you have proof that she did purchase it?
Yes, we had proof of it.
In that 30-day period?
We actually had proof of it in the 30-day period, but it didn't start, so she didn't have insurance until it began on August the 1st. And so she is requesting a waiver of the $500 penalty fee, which the commission provided for in the policy, which was adopted while we waited for the rules to be heard in.
Doc, does the policy provide any guidance to the commission as to whether to grant a waiver or not?
I'll read the second paragraph of the policy, because basically the first paragraph states that it's the maximum amount allowable and under the statute, and that's what's going to be in effect until our more detailed rule is effective. The second paragraph states, this policy is intended for the use and guidance of the staff of the Tennessee Real Estate Commission. This document is not intended to create any substantive or procedural rights enforceable by any party in administrative and judicial litigation with the state of Tennessee. The Tennessee Real Estate Commission reserves the right to act at variance with these guidelines. So if you wish to act at variance with your policy, then you'll just need to articulate a reason as to why you are varying the policy set forth, which is the maximum amount allowable. We'll just need to articulate a reason for varying from that, but your policy does allow that.
I'd be willing to vary just because she purchased it during that time. You want me to make that a motion?
You
I'll
want to make it?
Okay, I'll make that motion that we give her a waiver of E&O penalty fee because she actually purchased it within the 30-day period, but it was just not enforced till the next day.
I'll second.
Have a motion by Commissioner Haynes that we grant this request, give a waiver of the E&O penalty fee, seconded by Commissioner DeShara. Discussion on the motion.
Did that policy have any kind of tail coverage, or did it?
Well, she had the state policy, so that it would have expired on 1/1 of 2013. So it has a 90-day tail policy, which goes into would have gone until March 30th.
But Commissioner Alexander?
The way I understood the at the meeting in Jackson, for the Rice folks, once you let that policy lapse, all back coverage is gone.
That is what they say. Yes, that's correct about what they say. But she retired. She was not able to work. Yes, she was retired.
Okay.
License was retired?
She did. Well, let me. I think she was retired. Well, she was in suspension. She was not retired because she was placed in suspension on July the 1st. So she was not retired. She had been retired in the past, but then she was in a broker release status at the time this all took place because she had already. She's been licensed since 1989, but she was not retired at the time. She was in a broker release status at the time.
During that time, we sent correspondence to her principal
We
broker
sent
as
correspondence to her. She was.
To her principal broker.
Her doctor's letter. I didn't read it because of the nature of her illness, but her doctor's letter is pretty specific about that she was very confused and not really able to function.
We also notified her principal broker, right?
Yes, she was broker released, and her principal broker that she had been with, which is actually First National Realty, she was with them prior to her broker release, and so they would have been notified, and she would have been notified
At her last known
residence
business and
too.
home address.
I'm a little troubled that she would remain licensed while in that condition if she's not able to take care of, getting her insurance. I don't know what else she might have been doing, but it's a little troubling. Is it possible under the policy to have a reduced penalty, or are our only options the full amount or zero?
You have the right to act at variance.
Okay.
And the way that the statute is worded, I didn't bring a copy. That's why I have it pulled up here on my phone. I'm not just, I'd forgotten to bring a copy of the statute. The way the statute is worded, it has discretionary provisions, which is why we have this policy in the interim until we have a rule. The statute states that a license suspended pursuant to this section shall be reinstated if on or after 31 days of suspension, the licensee provides proof of insurance that complies with the required terms and conditions of coverage to the commission, and the licensee pays for a license suspended more than 30 days but less than 120 days, a penalty fee of not more than $500. That's how the statute is worded. The way the policy is worded is until our rule comes out, we're going with the maximum for each of the time periods. But again, it allows you the opportunity to act at variance with that if you wish to do so.
I just one more question. And I don't know this answer, but if she'd bought it on the 27th and made that the effective date, would the premium been more than if she waited till the first day of the next month?
But it would have been more, but I can't even imagine it would have been much more.
I know, but
to tell you the honest truth, I can't imagine that it would have been much more. I don't know what. Maybe the first just sounded like a good round number to her.
But she could have made it effective the same day she bought it.
She could have made it effective the day she bought it, but as I say, she didn't, and she really didn't. She didn't really seem to have an explanation. She just said that she.
Is there any indication that she asked it not be reinstated until the first? Or is it just
That she was
simply?
no, she just said that she was going to go back to work. She had indicated she was going to go back to work, and in fact, she had filed. She had actually sent in a Trek 1 form to transfer to a firm, and when the Trek 1 form came in, she didn't have her E&O, and she was suspended, and so we contacted her and told her that she was suspended, and until she took care of her suspension issue, she was not going to be able to transfer anywhere. And she then explained that she'd had this medical condition, that she had been on short-term and then long-term disability. And
My question though is Ms. Maxwell, is she sent the money in, that they received it the 27th. But did she request it not become effective until 1st of August?
I think she.
Or did the insurance carrier not put it into effect till the
No, I believe she requested for it. I mean, I know that she requested for it to become effective August the 1st. I mean, that was just what she requested.
Talk to himself.
I don't think she was clear on what it was. I don't think that they really understood that.
Personal conversation.
Any other discussion on this motion that's been made by Commissioner Haynes and second by Commissioner DeShara that we grant the waiver of the E&O penalty fee?
Is this the full amount or a partial amount?
It's full amount.
I move to amend the motion
Commissioner McMullen.
to reduce the penalty from 500 to 250.
We have a motion to amend the original motion to waive it in its entirety, to waive it from 500 to 250.
I'll second that amendment.
And we have a second by Commissioner Alexander on the amendment. Do I hear discussion on the amendment? Hearing no discussion on the amendment, we're going to vote on the amendment. All in favor of the amendment, say aye.
Aye.
No.
No.
Roll call, Miss Maxwell.
That's pretty close in noise level there.
I didn't say a word, I just listened.
Okay, this is a vote on Commissioner McMullen's amendment to
Reduce
Mr.
it to
Haynes's
$250.
original amendment to reduce the penalty of $500, the penalty fee from $500 to $250 for Ms. Lovretta pursuant to the E&O statute and policy. Okay, so Alexander,
Yes.
Collins absent, Grease,
No.
Flitcroft,
No.
Haynes,
No.
McMullen,
Yes.
DeChara,
No.
Stevenson.
No.
So the amendment does.
Fails 5 to 2.
Fails, right.
Amendment fails 5 to 2. Now we're back on the motion as originally made, which is to waive in its entirety the E&O penalty for Miss
Lovretta.
Loretta.
Lovretta.
For
Roll call.
roll call. Call the roll again.
Okay, so this is on the motion to waive the entire penalty fee.
Go in reverse.
Right.
That would be
Go into reverse?
That'd be me first.
Stevenson?
Yes.
And the reason is she paid for it in July. I think that's real important.
DeChara?
Yes.
McMullen?
No.
Haynes?
Yes.
Flitcroft?
Yes.
Grease?
No.
Collins absent. Alexander?
No.
So there's 4 yeses and 3 nos. So
Motion
it passes.
Mr. Chairman, a comment for Ms. Maxwell. Ms. Maxwell?
Yes.
Talk to Rice Insurance. They need to be telling people, especially once we come out with the new thing, that if you delay the effectiveness of your insurance, you may be fined.
Right, this was not Rice, quite frankly. It was another, it was one of the alternate carriers.
Tell them.
But we will tell them as well. We'll tell Rice as well, but this happens to have been an alternate
But this
carrier.
could be coming
But
up
one
often.
that licenses, I mean, insures a lot of
You
people.
don't even abide by it.
Okay. Do you have anything else, Miss Maxwell, in your report?
No, I do not. I'm finished.
Finally. I would just like to bring something up that involves Ms. Maxwell's report, is the audit. Michelle and I both took our test,
Did I pass my test, Ms. Maxwell?
Yes, you did pass it, and in 30 minutes if you have a firm, and 45 if you have a property management.
There were a couple of things that I wanted to bring up in the audit. There were a couple of things that I gave Ms. Maxwell just on some verbiage that I felt should be changed to make it a little clearer. Those I don't think we really need to discuss. But in here, we referred to it as trust accounts, and that all trust accounts include trust accounts in their name. I think most real estate companies use escrow account in their checking account name rather than trust account. And I would like to see that changed to say trust or escrow or something to that effect so that people realize escrow is okay.
And I know in this second document that you gave me, you specified it, but I would like to see trust, escrow/trust, every time you see trust. Because when you refer to it as trust, I think it's a little bit confusing. Another thing, we're auditing not just their trust account. I'm looking at this first letter, but we're auditing their firm, aren't we? Because we're looking at the license and we're looking at other things besides just their trust account. So on your first page where it says this first page of your letter, it says your firm, you wrote your firm trust account had been randomly selected, but actually your firm has been randomly selected.
Right, to have its, yeah,
So,
okay.
I mean,
okay.
we can.
I can restructure that
We
first
can
sentence.
restructure that
Right.
trust account, and then every place that there's trust,
Just slash it with escrow.
Yes.
escrow trust.
Okay.
Because that's just the way we understand it
Right.
as people in the real estate business.
Okay.
Or you
and I
could
love
probably
some of the
create a
things that
defined
you-
term.
Oh, I tried to do that.
And I like what you added on the broker review. You added a couple of things. I
Right,
thought
I did. I tried
that
to
was
break it
really
up
good
and
idea. And we may
simplify.
even find a couple more once we get through
Once we
the
get through that,
advertising.
yeah.
So, and that was my main
And I do
concerns,
think it'll
too.
be a working, I mean, even once it starts going out, I think there'll still be changes that maybe, we notice after a period of time that, or feedback that you all might get, that someone says, gosh, we maybe should do this or include that, which I think, might have to be, maybe that would occur over the course of actually putting it in use and seeing what it does.
But I think one of the things that the commission was concerned about was how long it was going to take the audit. And I did it in about 30 minutes for the real estate part, like Eve said, and I think the property management section took about 45, and I think Michelle said hers was about 30
to
as
45
well.
minutes.
But that's a pretty reasonable amount of time.
Yeah,
don't you-
I thought it was. I didn't make copies, and I was mostly going through
yeah.
trying to audit what we had here. One other suggestion is when we do the property management, there are some people that are in business and like myself, property management for properties I own
Right.
and not for other people's. And I just want to distinguish it that it's properties not belonging to it has to be
Yeah,
a third party.
properties.
And that's under the property management big heading.
Right.
Eve's done an absolutely fantastic job, by the way. And there was one other thing in here. I think that got it. That was the major things.
I'll just clarify.
I mean, it's just
properties,
simple
that it's
things.
Properties, yeah, and then I'll restructure that first sentence and.
And
put
part
escrow
of the
trust.
reason for, and you attorneys can jump in here, trust accounts a lot of times you are a trustee for a specific person or entity, where an escrow account holds money in trust for many other people. And that's, in my mind, because I've got trust accounts
Right.
along with escrow accounts,
Right.
how I distinguish the two.
And that's probably how a lot of people distinguish it. I don't.
Yeah,
Austin
and I
probably
think
knows
for
exact
me, it was
definition
really
better than I do.
confusing when we kept saying trust. And then when we refer back to our law, too, it says escrow, and it doesn't say slash, it says escrow and trust.
Right, and unfortunately, the statute doesn't even define
I know.
escrow or trust.
Well, and I had
so it
emailed
makes it
Steve, because
difficult.
I wanted to know what people are teaching as a definition of, because, I mean, when you've got property management, you've got so many different trust accounts or escrow accounts, and then you've also,
Got a
I
security
don't know
deposit
what they're
account
teaching.
as well, and I don't know what they're teaching either. But I do think it's important that people know they have to label it as some sort of.
And I love what you described on this first
Just
page too. That was
trust
much, they made
account.
it much clearer. So I thank you for what you've done.
Well, I appreciate y'all's comments. I appreciate y'all taking the time to take it because I think it was important to know how long it was gonna take. Especially, I mean, you all are organized. If somebody's not organized, it's probably gonna take longer, but that's just, maybe next time they'll learn to be organized.
Well, I think it is a good self-check because they're accustomed to an auditor coming in.
Right.
And an auditor's going to be there half the day. So, I mean, once they figure out this is actually going to take less of their time, if they just go on here and do this, then, I mean,
Well,
and it's much worse thinking about it than it is to actually sit down and get it done.
And I think it's important to make it clear to whoever's sitting there looking at it thinking, well, what exactly are they looking for? And I think your revisions have made it much clearer, and that's just really, really important.
But I think so too, because we want it to be worthwhile, and if it's, otherwise it's just people think they're just wasting their time.
Going, I don't want to fool with this, yeah.
Right,
And I
yeah.
think
Name's on the bottom of the signature page. Who signs for it? Principal broker?
Yes.
principal broker, and she's got it where you have to initial each page, which I like really well. She's done it like a contract, like a lawyer might do.
Lawyer drew it.
Yeah, yeah.
It's always been my understanding, I'll defer to Austin on this, it's been my understanding the proper term is escrow, and that has a particular meaning in bankruptcy court.
Well, it has a
That's why I'm
particular.
deferring to you.
It has a particular meaning when you go to a bank, because if you're going to set up a trust account, you have to have a legal document that you have to give them specifics in this legal document to set up a trust account. Where an escrow account, again, you're holding monies for lots of different people in trust. So trust account is a different, it's just total different entity out there from the bank's point of view is what I have found out. And we don't want to confuse banks anymore. They're already confused.
Oh,
So
that's true, for sure.
Who's gonna send those to, Ms. Maxwell?
You.
Well, Michelle and I already did ours, so we're clear.
Right.
Well, I actually hadn't completely done mine because I was trying to audit it. I mean, but anyway, I can do mine. And it won't take
I'll
long.
send everybody that has a license at one time.
At one time, yes, yes, yes.
Yeah.
Everyone will get one. Everyone will have a.
Can you hear me, Bear?
I can hear you now.
We'll get you a lavalier mic. You know what that is? You can rear back and still talk.
What I need.
Is that everything on the audit? Commissioner Haynes and Commissioner DeShara?
I think
I
so.
think so.
And she'll mail it back to us, and then if we've got something, simple, we'll mail back to her.
You have anything else, Ms. Maxwell, in your report? Is this everything?
That's everything, thank you.
Okay. At this time, let's take a 10-minute break,
Let's get Steve out of the way first.
and then we'll.
Who's after me?
He's after you?
Oh, well.
Oh, my. Well, then we're going to take a 30-minute break.
10-minute break. We'll come back and we'll get into our legal report, and then we'll have our education report, and then we'll be finished.
Steve, how'd you get stuck?
Without me? Okay.
With or without you. The next thing on our agenda is our legal report. We're on now. The next thing on our on our agenda is our legal report by our attorney, Miss Julie Kropp. Julie, the floor is yours.
Hey, thank you. All right. I'll start by reading the statement on the first page. Any consent order authorized by the commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. The first item is 2013-005421. TREC open complaint based on information received by the TREC office on or about February 2013, which indicated that respondent, an affiliate broker, pled guilty and was convicted of a number of criminal offenses over the years of 2009 to 2011. The relevant plea conviction was a misdemeanor theft plea and judgment from 2009. Respondent failed to report this plea conviction to TREC as required by Tennessee Code Annotated Section 62-13-312F, which requires that whenever a licensee pleads guilty or is convicted of any offense enumerated in the chapter, the licensee must notify TREC of the conviction within 60 days of the conviction. Without timely notification and a request for a hearing, the section provides that the licensee's license shall automatically be revoked. TREC had no records of respondent ever notifying TREC of this misdemeanor theft conviction. Due to the type of information received, in order to ensure that the information was correct and that this respondent was the correct party who pled guilty and was convicted of the aforementioned theft charge, and to ensure that there had been no expungement, this matter was opened as a complaint, thus giving respondent an opportunity to respond before taking action instead of immediately automatically revoking respondent's license as specified by statute. Respondent's attorney has submitted a response asking for 10 additional days to respond to the complaint, but never submitted any additional information or response. Therefore, legal counsel obtained a certified copy of the plea and judgment regarding the theft offense from the court, and it was determined that all personal information contained therein matched respondent's personal information. Upon receipt of this information, respondent's license was automatically revoked pursuant to Tennessee Code Annotated Section 62-13-312F, and notice was sent to respondent via certified mail. Therefore, there is no action necessary from the commission. Therefore, the recommendation is to close.
Motion to accept.
Second.
Motion by Commissioner McMullen to accept council's recommendation and close, and seconded by Commissioner Grease. Any discussion?
Yes, is this the same one that we mentioned on, back in Eve's report? I noticed there was a revocation failure to notify commission of criminal conviction.
It's okay to identify it in this case since it's all out there, but yes, it's the same individual.
It's the same one, okay, because I had a question about it earlier that I never got to, but gotcha. Okay.
Any other discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Prop, have we notified the principal broker?
They were also sent a copy of the letter. Yes, sir.
Number 2.
Number 2, 2013005791. The August 23rd, this was originally presented at the August 2013 meeting. Complainant is a licensee who states that a property owner contacted complainant regarding managing the owner's property, which had been handled by respondent, an unlicensed individual with an unlicensed company. Complainant states in the complaint that the property was in disrepair, and complainant did not believe that it had been managed by a licensed professional. Based on the complaint, a search was conducted of respondent's company's website, which showed 3 property listings and indicated that it performed property management services. A copy of the complaint was sent to respondent at the address featured on the website, which was returned to TREC's office with a notification stated attempted, not known, and unable to afford. Legal counsel followed up with the complainant, who stated the complainant does not have any information regarding the property owner referenced in the complaint because complainant did not ultimately begin managing the property. Further, complainant stated that complainant did not believe that respondent was any longer in business. Legal counsel then attempted to call the telephone number on the website and reached a young woman who stated that she worked from her home in another state and therefore could not provide a business address, but stated they are involved in apartments and provided respondent's cell phone number. Legal counsel obtained a possible alternate address through the internet for respondent's company, and attempts were made to reach respondent by telephone, by mail at the alternate address, and by fax to the fax number in the original website. In response to the fax, another business contacted legal counsel stating that respondent had not been in that location in over 3 years and had no forwarding address for respondent. Further, the individual believed that respondent was out of the real estate business altogether. Attempts to contact responded at the cell phone number were unsuccessful, and it appears that the alternate address obtained is that of a UPS store. Based on the lack of information regarding respondent's activities and the inability to determine where respondent is located, it is recommended this matter be closed and reopened in the event that additional information is obtained. It was verbally updated to the commission at the August meeting that on the morning of the meeting, legal counsel received an email from respondent indicating that respondent would send a response. The original recommendation was to close, but the decision was in light of the new information received on the date of the meeting. The commission voted to defer determination of the matter until the next meeting. Since the time of the original presentation of this matter to the commission, respondent sent a substantive response to the complaint regarding unlicensed activity. Respondent states that respondent set up respondent's management company in 2010 and at that time was managing full-time under the impression that respondent did not have to be licensed. Respondent states that respondent stopped managing full-time about a year and a half ago, passed off a number of clients, and has been working another full-time career since that time, but continues to manage my own properties and the properties that I have an equity interest or partnership interest in, as well as one property owner who respondent considers a friend. Respondent states that the owner of the property referenced by complainant licensee was referred to respondent, and respondent managed the property from September 2012 to February 2013. Respondent states that during that period, respondent never negotiated a lease but did collect rents. Respondent states that respondent now realizes the requirement to be licensed to manage properties in Tennessee and will be happy to do what is necessary to comply. Legal counsel was contacted separately by the owner of the property referenced in the complaint, who stated that respondent managed her properties and conducted activities such as showing the properties, locating tenants, and taking care of the properties. The respondent provided a number of emails and email communications between the owner and respondent. Among this was an unexecuted property management agreement for the period of August 1st, 2012 through August 31st, 2014, which stated in relevant part that for a 10% management fee, respondent's company would make efforts to lease the property and negotiate with all tenants, enter into leases, maintain the property, and deposit revenues from the property into a trust account, which would be used to pay expenses, compensate the agent, and return the balance to the owner. The owner stated that she did not sign the agreement because she did not believe respondent was doing what the agreement specified. The new recommendation is a consent order for $1,000 for unlicensed activity in violation of Tennessee Code Annotated Section 6213-102-4A and B, which defines broker, Section 6213-103, and Section 6213-301. Said order to also to include an order to cease and desist all unlicensed activity.
Any questions of Ms. Crop?
Motion to adopt the recommendation.
Have a motion by Commissioner McMullen to accept council's recommendation. And seconded by Commissioner Alexander. Discussion.
Are we going to require any education on this one?
Unlicensed.
I'm still not sure they don't need some kind of education.
Don't we all?
Is council's recommendation based in part on the property management agreement that was referred to as unexecuted?
It's just that all of the information combined indicated a significant amount of proof that there was unlicensed activity at hand.
Had the respondent signed that property management agreement?
It was unsigned. The way that I spoke with the property owner by phone, who terminated this individual services pretty soon after it was begun, just because the owner claimed that they weren't happy with the services being provided. They also indicated that they refused to sign it because they just didn't think that by the time they got the agreement, that everything was being, all the terms were being met, and so that's why it was never signed. It really just has more. I mean, the management contract shows that there was an intent to do it, and he also admits to having done the activity for this
recommendation's
person.
based more on his testimony than...
It's based on a combination of what I obtained from both of them since the last meeting.
Any other questions or discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
4 and 5, 2013-006321, 2013-006322, and 2013-006323. Complainant, the designated agent of a vacation lodging services firm, states that Respondent 1 is an unlicensed company, and Respondents 2 and 3 are unlicensed individuals running the unlicensed company, are utilizing the internet to advertise nightly cabin rentals in Tennessee. Respondent states that respondents are not licensed as a vacation lodging service firm, and respondents do not have an office in Tennessee. Respondent 2 sent a response on behalf of all respondents stating that Respondent 1 is a registered company in another state which operates an advertising platform only on the internet. Specifically, Respondent 2 states that Respondent 1 advertises the properties on its website, which are managed by licensed vacation lodging service firms located and licensed in Tennessee, and Respondent 1 performs no service other than advertising these properties on its website. Respondent 2 states that Respondent 1 does not collect any reservation money and does not own or manage any properties in Tennessee. Respondent 2 states that Respondent 1's website links to the websites to the vacation lodging service firms who manage the nightly rentals of the properties listed on the website, and the booking is done directly with that vacation lodging service firm. Later, Respondent 1 is paid a commission by the various vacation lodging service firms advertising their properties on Respondent 1's website based on the number of reservations which are booked with the vacation lodging service firm through customers' utilization of Respondent 1's advertising website. Respondent 2 provided the names of licensed vacation lodging service firms who utilize Respondent 1's advertising platform, who all confirmed in conversations with legal counsel that Respondent 2's representations were accurate. Respondent 2 suggests that respondents and complainant have had a personal issue, which was the reason for the complaint. Based on the information provided and obtained, it does not appear that respondent's activities constitute unlicensed vacation lodging service activity, and therefore the recommendation is to dismiss.
Second.
Have a motion by Commissioner Grease to take council's recommendation and dismiss, and seconded by Commissioner McMullen. Do I hear any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
2013-006541, 2013-006542, 2013-006543, and 2013-006801. Complainant was the seller of a property. Complainant entered into a lot land purchase and sale agreement with a partnership consisting of respondents 1, 2, and 3, unlicensed individuals, in 2011. Respondent 1 was licensed for a brief period of time at the very initial stages of the transaction, so a complaint was also opened on Respondent 1's principal broker at the time. Respondent 4 is now inactive. The issue at hand for TREC is whether unlicensed activity occurred on the part of Respondents 1, 2, and 3. Complainant alleges a number of matters regarding Respondents 1, 2, and 3, including but not limited to breach of contract, failure to purchase the property, failure to account for monies held in an escrow account overseen by a third-party attorney to be used for improvements to the property, and failing to respond to communication regarding the property and contract. Complainant states that Respondents 1, 2, and 3 are primaries of a partnership which entered into a purchase agreement in September 2011, which provides that the partnership would purchase complainant's property before September 2012. The contract further provided that during the intervening period, a tenant would occupy the property and eventually purchase the property from the partnership, with rent payments going to the partnership and being passed through to the complainant, with the rent amounts being applied to the eventual purchase price of the property by the tenant. Also, an escrow account was set up with the oversight of a third-party attorney to hold the purchaser partnership's funds, which would be used to make repairs to the property. Complainant states that near the end of the contract period, Respondent 1 contacted complainant on behalf of the partnership, inquiring as to whether complainant would be in agreement to extending the lease with the tenant for an additional 6 months so that the tenant could get credit issues resolved, which complainant accepted via email. Complainant recognizes that there are no signed documents stipulating the extension, but argues that the emails are binding, and complainant argues that the request was not made in good faith by the partnership, since everyone associated with it has been non-communicative with complainant or complainant's broker since February 2013. Complainant states that all of these circumstances have harmed complainant as the sale did not take place. Complainant states that all of the circumstances have harmed complainant as the sale did not take place. Complainant has not received rent since the initial expiration period in the lot land purchase and sale agreement with the partnership, and the tenant is still in residence of the property. And from the documents submitted, appears to be paying rent directly to complainant since April 2013. Complainant sent in documentation and emails relevant to the transaction, including the lot land purchase and sale agreement and memorandum of purchase agreement, which states in part that unless an extension is recorded, the terms of this memorandum and purchase agreement shall expire either upon conveyance of the property by the seller to the partnership or upon the date of September 14th, 2012. Complainant states that the tenant is still in residence, but all repairs were not completed, which would allow the tenant to obtain financing, and complainant states that complainant did not receive several months' rent to which complainant was entitled. Copies of the complaint were sent to all respondents, with complaints sent to respondents 1, 2, and 3 at the P.O. Box address of the partnership, which were received, but no response was sent by any of the respondents. The complaint for failure to supervise against Respondent 4, who is now inactive, was returned as not deliverable as addressed to the only address on file with the Commission. Based on all of the documentation submitted, this appears to be a possible contractual issue between complainant as the seller and respondents 1, 2, and 3 as the apparent individuals who were responsible for the partnership, which was the buyer, and possibly other parties such as the tenant. But this does not appear to be unlicensed activity on the part of respondents 1, 2, and 3, as they all appear to be tied to the partnership which entered into the agreement to purchase the subject property from complainant. Therefore, there's not appear to be a failure to supervise on the part of respondent 4, and the recommendation is to dismiss.
Motion to accept the recommendation.
Second.
Motion by Commissioner McMullen to dismiss and seconded by Commissioner DeShara. Any discussion? All in favor say aye. Opposed, no. Motion carries. Number 10.
I got a quick question. If we've got unlicensed activity and say 3 years ago, have we got a list of those people that if they try to come into the real estate business, we will know that we have had a complaint against them for unlicensed activity? There's no way to know that somebody we've already looked at for unlicensed activity 3 years down the road decides they want a license. And I don't guess it matters either.
I mean,
And we,
don't, yeah.
I was going to say, we did have one individual who was sent a consent order by this commission for unlicensed activity, who paid the consent order, and within the month, because it contained a cease and desist, within that month became properly licensed and affiliated with the firm and corrected the behavior before even sending it in. So,
Well, that's okay.
I mean, that's one way where we obviously were keeping track of it, and that person was keeping in direct contact with me because they did not want to send in the consent order. Was very interested in becoming compliant.
Okay.
But
Well,
I
that's
don't know
good.
that we've
That
ever
was-
had
that's
anybody
good.
that has come back later. I mean, usually you either have someone that wants to become compliant or they don't.
Fall off.
Otherwise, we'd have to check the complaints, and they would have to tell us, unless Connell has a pretty good memory of recognizing people's names, but, they would have to probably answer question 4 in the affirmative, have you ever had a complaint filed against you? And they're probably,
That would be the only way we'd really know.
really, yeah, it would be.
Okay, thank you.
Number 10, 2013-008221. Complainant was the seller of a property, and respondent, principal broker, was hired by complainant to list the home through an MLS limited service contract. Complainant states that the home was not listed with complainant's name on the MLS and did not have for sale by owner listed. Complainant states that complainant did not want realtors involved, and complainant made this clear, but the only calls received regarding the property were from realtors. Complainant states that the ad did not have complainant's name and number, only respondents. Complainant states that complainant called a computer service who accessed an ad and said the ad did not have for sale by owner in complainant's name. Complainant further states that complainant was adamant about not wanting a middleman and suggests that respondent attempted to take advantage of complainant's age. A printout provided by complainant had some pictures and complainant's phone number, but not complainant's name or for sale by owner. A listing from Realtor.com did not have complainant's name and number, but it states that it's brokered by respondent's firm with the firm number. Respondent states the respondent was hired to list complainant's home on the MLS, and respondent spent hours explaining the process, after which complainant signed the permission statement indicating that complainant understood the process. Respondent states that complainant was told that other realtors could not be excluded, so complainant provided only a $1 commission to discourage agents from contacting complainant. After the home was listed, respondent states that agents called respondent due to being unable to access complainant's answering machine, and respondent states that respondent had the same issue. Respondent states that complainant started receiving notice from other agents stating that respondent states that respondent started receiving notice from other agents stating that complainant would not let them show the home at all because it was for sale by owner only. Due to this problem, respondent states that complainant instructed respondent to remove the listing immediately. Respondent included the signed contract for permission to market, which outlined the terms. Respondent states that the MLS listing was exactly as explained to complainant and included a copy of the MLS listing showing complainant's name, number, and noting to call complainant directly. There does not appear to be a violation by respondent, and therefore the recommendation is to dismiss.
Motion to adopt the recommendation.
We have a motion by Commissioner McMullen to accept council's recommendation to dismiss, and seconded by Commissioner Grease. Does anybody have any questions or discussion? All in favor say aye. Opposed, no. Motion carries. Number 11.
2013-012331. Complainant states that respondent, principal broker, same as previous respondent, met with complainant regarding listing complainant's home. At that time, they discussed listing traditionally and also discussed listing the home through an MLS limited service contract. At that time, complainant paid the amount for the limited services contract. Complainant states that complainant understood that complainant could pay this upfront limited services fee, which would be all that would be paid if the home sold only because it was on the MLS, or that complainant had the option of later changing to the traditional route with respondent earning a commission with the upfront limited fee being returned. But complainant never thought that complainant's money would not be refunded if complainant no longer decided to list the home on MLS. Since the home did not sell, complainant believes that complainant is owed a refund. Respondent states that respondent was contacted by complainant to assist complainant by putting complainant's home on the MLS. Respondent states that the two met in person and went through an explanation of the process, examples of listings, and the related forms and documents. Respondent states that complainant needed to ask considerably more for the home than others in the neighborhood. would. Respondent states that the home was marketed for approximately 4 weeks and complainant decided to take the house off the market, requesting a return of the fee which complainant had paid for the limited MLS listing. Respondent states that respondent reminded complainant that there was no refund for the listing fee. Respondent attached a copy of the signed MLS limited service contract with complainant, which outlined the terms of the service and provided that the seller could terminate at any time, but there would be no refund made. It does not appear that there was any violation by respondent, and therefore the recommendation is to dismiss.
Motion to accept the recommendation.
Motion by Commissioner McMullen to accept council's recommendation and dismiss, and Commissioner Grease second that motion. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Number
Mr. Chairman?
12, you Commissioner Flitcroft.
Is this kind of like help you sell? Is that what they're doing?
Yeah.
Kind of a
The
limited,
where they just put it in the, you don't need it for me, I got a big enough mouth. Where
kind
you
of
just
limited
put it,
representation?
where you just put it in the MLS and then everything else is pretty much handled by the seller.
How much do people charge to do that?
Anywhere from $250 to about $1,000.
And the MLS is all right with that.
Well, it depends on the MLS. Some MLSs allow it and others have more strict guidelines. Like in our MLS, even if you agree to do that, there's still certain things you have to do.
Number 12.
2013008231. Complainants who were represented by a broker and entered into a purchase and sale contract to purchase a property under a lease purchase arrangement due to complainants needing to sell another home, and respondent principal broker represented the seller. Complainants state that the home was listed as a modular home on the MLS listing. Complainants state that after their home sold in another state and after complainants had been leasing the home for several months prior to closing, complainants' lender informed complainants that the home was a mobile home, not a modular home, and thus would not qualify for the loan. Complainants state that they invested a large amount of money into the home during the time complainants were leasing the property to make improvements, which complainants state were necessary as the home was not livable. Complainants state that they never would have entered into a contract to purchase a mobile home. Complainants state they were told that the home was reclassified by the county where the home was located, which complainants state is not possible. Complainants have since purchased another home and placed a lien on the subject property for the repairs modifications which were done by complainants. Complainants believe that respondent knew the home was a mobile home and not a modular home, and the MLS listing was a misrepresentation. Complainants included a copy of a complaint which they filed pro se against respondent, respondent's firm, and the seller in court, which is currently pending. Respondent, through an attorney and by respondent's own affidavit, states that respondent, as the listing agent, did not believe that the designation was incorrect when it was entered into the MLS, and further, complainants had access to the property before making the offer and before making repairs and modifications to the home. When respondent listed the property, respondent was aware that the property was a mobile home at one time because respondent was the listing agent when the seller purchased the home. However, respondent was also aware that while the seller owned the home, the seller refinanced the home and the mobile home was detitled and was considered a fixture to the property. Respondent states that respondent did not look into the crawl space, but respondent observed brick at the home's foundation area and believed a block foundation was behind the brick. Based on this information, the designation on the MLS was listed as modular, and respondent's attorney argues that the RealTrax definitions of a mobile home and a modular home are not entirely clear. Respondent's attorney further states that MLS listing states that the information is believed to be accurate but not guaranteed, and encourages buyers to independently verify all information before making an offer. Respondent states that the purchase and sale agreement provided that the complainants would lease the property for about 6 months before the property would close. Respondent further states that complainants included a list of costly repairs in the purchase and sale agreement which complainants requested credit for in the sale, which respondent states shows that complainants had inspected the home in order to know what repairs were necessary. Further, respondent states that complainants emailed the seller approximately 1 month after moving in, and part of the email stated that one of the complainants had replaced the ductwork, which respondent states is in the crawl space, and had jacked up portions of the home. Approximately 1 month before closing, complainants listed additional repairs for which complainants wanted credit on the sale, and the seller did not agree. In an email from complainants to respondent, complainants stated that one of the complainants had been in the contracting business and the repairs were necessary, which respondent states evidences that complainants were aware that the home was a mobile home. Respondent further states that after the complainants received notice that their mortgage company would not give a loan, the insurance company issued a check to complainants for damage to the roof, which was cashed by complainants shortly before complainants terminated the contract and that was never returned to the seller after the complainants vacated the property. Based on the circumstances, the modular versus mobile home issue appears unclear, nor does it appear clear that respondent knew the home was mobile versus modular. However, there's a pending lawsuit. Often facts are revealed through the litigation process that could have a bearing on the ultimate issue, and therefore the recommendation is a consent order for litigation monitoring.
Motion to approve council's recommendation.
Do I hear a second? Who said that second?
I did.
Commissioner McMullen. Commissioner DeShara makes a motion, we accept council's recommendation, and Commissioner McMullen seconds it. Discussion.
So is it just our general policy that we'll wait on court before we make a decision?
Mm-hmm.
I think in this case, it's possible that that there could be something revealed through the litigation that might be pertinent to this commission's determination of this matter. And by placing this in litigation monitoring, we're putting it on hold. We're not dismissing the complaint. So if this lawsuit takes a while, we're not running into a statute of limitations problem by dismissing it and then possibly something coming up in litigation that would warrant a complaint later on. It's just based on the facts. I thought that that was appropriate here. Not in all cases where there may be litigation, but I thought here something may come out.
Oh, you used a legal term here that I probably don't understand, like pro se.
Oh, I'm sorry. That just means without an attorney. Yeah.
They don't have an attorney.
They filed it themselves, which they can do, but the respondent is represented by an attorney, the same attorney who submitted the response to this complaint.
John, sometimes you get the feeling that they're using the Trek complaint as leverage in the...
It's just we have limited powers to obtain information. The court could probably obtain more than we could, and so that was the reason for the recommendation of this. We're just deferring any action if the court issues. Basically, by executing this litigation monitoring agreement, they're agreeing to keep us informed and as to the progress of this, and then when it concludes, they're to notify us and provide us with documentation, letting us know how it was resolved, and if we need more information, give us that, and then the commission will consider it at that time.
But if they settle, just come to some financial settlement and that case goes away, we're notified of that too.
We'll be notified when it's disposed of, and I'm not sure. I've never seen it through. If it's a confidential settlement and they won't give it to us, I don't know where we'll stand. We may have to stand on the facts as we have them at that point. It's just basically to keep us informed of what's going on in the court.
Off the question, Mr. Chairman.
Well, I'm not ready yet.
I'm calling for the question. We can take a vote on it to see whether the commission agrees with it or not.
Talking about a modular home
only one of 8
and a
people, you
mobile
tell people all the time.
modular home and a mobile home. I find this very interesting. I mean, I've had this discussion. Commissioner McMullen, what's the difference between a modular home and a mobile home?
I guess it depends on who you ask.
David, Commissioner Flitcroft?
Lawyer.
Commissioner Flitcroft, what's the difference?
Mr. McMullen has come up with, we've had... You can say, well, a mobile home has a title and a modular home does not, but often modular homes do have a title.
Also, a mobile home has a tongue under it where they've pulled it.
And I think more than that, too, whether it's mobile versus modular, our issue is did she know about it and misrepresent something? So, that's another component to that.
Yeah, I think it's more of a disclosure issue where it said earlier that they had sold it before and knew that it was a mobile home and had been detitled.
Right.
The respondent, he was a listing agent and sold it as a mobile home once before.
That's what I'm saying. So,
Question
I think
has
it's
been
a
called.
disclosure issue.
Finally getting around to that question.
The question has been called. All in favor say aye. Opposed, no. Motion carries. Number 13.
2013-008251. Trek open complaint based on an audit of respondent principal broker's firm in April 2013. The auditor's report indicated a shortage in the firm's escrow account, which only held one earnest money deposit. When comparing accountings to the most current bank statement, based on the escrow account shortage, a complaint was opened. Respondent submitted a response admitting the escrow account shortage due to obligations, which led respondent to utilize funds from the firm's escrow account, which respondent states respondent used due to expected income in the near future, which did not come to fruition. Respondent acknowledged in the response that respondent's action was a clear violation, but expressed regret and stated that the account was...
Motion to accept council's recommendation.
Second.
Before you act on that, I do have a question.
Well, you just go.
You do it.
Wait a minute. We do have a motion and a second on the floor, and then we'll have some discussion. I think it'd be the proper way to go. We have Commissioner McMullen makes a motion. We accept council's recommendation in this matter, and it's seconded by Commissioner Alexander. Now we have discussion. Commissioner Grease.
So in the caption, number 13, it talks about the history, and it's closed CO. What is that?
It was a consent order, and I unfortunately don't have any more information about the substance of that complaint. I believe that complaint was back in like 1996 or something. I don't know what the content of that previous complaint was. You have as much information as I have there.
So
Why do we not know?
Well, the history.
It's not in our files anymore. I mean, it's from almost 17 years ago.
It was downgraded, but apparently then got his principal broker's designation back at some point.
Pretty quickly after that, I believe.
Okay. That was my question.
The motion is to accept council's recommendation, and I'd like for you, Ms. Crop, to read into the record what your recommendation is, so we'll have
I wanna hear the
we'll have a
Read the rest of the
history of this of your recommendation.
Do you want me to read the rest of the summary? Is that what you're saying? Okay.
No.
Just your recommendation.
Just the recommendation, okay. The recommendation is a consent order for voluntary termination of respondent's license for failure within a reasonable time to account for or to remit any monies coming into the licensee's possession that belong to others in violation of Tennessee Code Annotated, Section 6213 312B5. Failure to timely account for trust fund deposits and all other property received from any party to the transaction in violation of Tennessee Code Annotated, Sections 6213 312B14 and 6213 4036, and failure to properly disperse funds from an escrow account in violation of Rule 1260.02.09, subsections 3 and 6.
How much money was at stake here?
It was a $5,000 deposit. It was a $5,000 earnest money deposit. Currently zero, I believe, based on the most recent information I was given by the respondent.
So does the respondent know what your recommendation is?
No, I typically don't disclose that to anybody before it's given to you all.
I see this is probably coming before us.
I'm not sure. In the audit statement, it said that this earnest money deposit was the only transaction that had been done in the last 4.5 years. So I'm not sure how actively engaged in the business this person is. I don't know. But based on the fact that when the audit was done, it was at a certain point and it was promised it would be rectified, and that it has regressed worse since that time, that's the reasoning for my recommendation.
Any other questions of Julie or discussion on the motion to take council's recommendation that has been read into the record? All in favor say aye. Aye. Opposed, no. Motion carries. Number 14.
2013-008271. Complainants were the sellers of the home and respondent broker was the listing broker. Complainants state that in April 2011, complainants had a contract with a VA loan contingency. Complainants state that respondent told them that complainants would have to pay the closing costs and told complainants that they would have to be out of the home by the closing date. Complainants state that complainants made an offer on the house that was a short sale but lacked storage or garage, and complainants state that they told respondent that complainants needed 2 weeks in their home so as to do work on the new home and get rid of tools and equipment that had to be sold before moving. In order not to lose the sale, complainants state that they hired an auctioneer to sell off the items. Complainant states the respondent told complainants that the sale was a go and all that was left on the sale of complainant's home was the appraisal. Complainants state that a problem arose with the appraisal. Specifically, the bank turned down the loan due to the appraisal reflecting problems with the complainant's home's foundation. Complainants state that complainants had a letter from 2009 from an engineer approving the foundation. This letter was given to respondent and the appraiser. Complainants state that complainants do not know why the loan was not approved except for what was told to them by respondent. Complainants do not trust respondent. Respondent submitted a reply stating the respondent warned complainants prospectively that a manufactured home in a yard with a partial floodplain was a difficult sale and that appraisals are generally difficult with manufactured housing. Respondent denies that respondent tried to get complainants to pay anything for the buyers to purchase the home, but instead states that respondent told complainants only that when an offer involved a VA loan, it was customary to pay closing costs. Respondent states that respondent told complainants that the buyers were pushed to move, but did not tell complainants to hire an auctioneer to sell their personal items. Respondent states the complainants countered the offer with a 2-week possession after closing for complainants, and this was accepted by the buyer. Respondent states that respondent gave the 2009 engineer letter provided by complainants to the appraiser, but the letter did not impact the appraiser's professional opinion of the foundation, and the foundation was not approved. Respondent states that the loan was denied because of the appraisal, and although respondent states that respondent had no involvement in the appraisal and wanted the deal to close as much as the complainants pulled the listing from the respondent. Based on the information within the file, there does not appear to be a violation by respondent, and therefore the recommendation is to dismiss.
Oh, I don't got a little problem with that.
For the record, I'll move to accept council's recommendation.
We have a motion by Commissioner Grease to accept council's recommendation. Do we hear a second?
Yes, second.
Second by Commissioner McMullen. Now discussion, Commissioner Alexander.
Well, I'm not advocating a whole lot, but I think that if I'm a broker and I tell you that everything's on go and we haven't got an appraisal and we're going to get a VA loan, I think that he was some misrepresentation there, maybe hearsay on each part. You listen to one or the other. I really think some education might be appropriate.
He denies that he told them everything was a go.
Okay.
I should have included that in there. I mean, it was two statements, one versus the other, and I'm sorry when I was summarizing it. I guess I didn't leave that in there.
I've said my piece, so I'll
Okay.
pass on. Call for the question.
Was it manufactured or modular?
I think it was a manufactured home, but if you'd like for me to check, I will pull the file. They called it a manufactured home throughout, and that didn't appear to be disputed here, so.
Did it have a tongue?
Or certificate of title?
I don't know about that.
It had wheels. It didn't have a tongue. It had wheels. Any other questions or comments? Hearing none, all in favor say aye.
Aye.
All opposed, no. Motion carries. Number 15 is next.
Oh, Lord have mercy, we got 3 pages here.
I'm sorry, this was a really long one. Complaint 2013008681. Complainant's son is a property owner. Complainant has a power of attorney. Complainant states that complainant contacted respondent, principal broker, regarding the possible sale or lease of complainant's son's home, and respondent agreed to inspect the property. Complainant states that respondent arranged for the rekeying of the locks, arranged for the boxing and removal of personal items in the unit, and for a cleaning service, which complainant states surprised complainant because the parties had no written agreement. Complainant states that respondent told complainant there was an interested party and this party was going to put the utilities in their name and there was to be a contract. Complainant states that respondent informed complainant that the interested parties were waiting to get married and were not ready to move. Complainant states that after a few months, complainant was informed by the HOA manager that there was some activity at the property which was causing problems with other owners. Complainant was informed by respondent that all was fine and there was no one residing in the property, but that the interested party was only storing some items in the unit. Later, complainant states upon requesting an update from respondent that respondent notified complainant that the interested party was no longer interested and the party would be removing the furniture stored there. Complainant states that complainant again received notice from the HOA that the tenants living at the property were causing problems, and again respondent denied that anyone was living there, but stated that respondent had given the party who was storing the items there notice to vacate. Proof of this notice was never provided, according to complainant. Complainant states that respondent began eviction proceedings, but ultimately complainant's attorney caused the persons to be moved from the property. And complainant states that the property was damaged through the unauthorized rental. Complainant further states that the son's property was put to the curb and thus destroyed. The respondent gave a key to the tenant with no lease agreement, and there was no written lease, that no rental income was received by the complainant. that there was no signed contract to put the property on the market, and the respondent allowed someone to store items in the property without permission of the complainant. Respondent denies that respondent was contacted by complainant to get the subject the respondent states that respondent was contacted by complainant to get the subject property on the market. Respondent states that respondent sent the necessary paperwork to complainant for signatures via email and regular mail. Respondent states that complainant said that with power of attorney, respondent could do whatever was necessary to get the home ready and on the market. Respondent states that respondent hired a cleaning service and had the property rekeyed, for which respondent states respondent was never reimbursed, and respondent packed up what was left behind, but there were only a few items, which respondent attempted to arrange for the owner's friend to pick up, but ultimately the items were placed in the attic. Respondent states that the property was placed on the market at the end of June, but complainant also expressed interest in renting the property. Respondent states that soon after, respondent was contacted by an interested party. Respondent showed the property, and the interested party, who was planning to get married, wanted to occupy in November. Respondent states the interested party had to move soon and needed a place to store property before the November date. Respondent states that the situation was discussed with complainant. Respondent states that a hold harmless document was drafted for the potential buyer's signature, and the utilities were switched to the potential buyer's name. Respondent states that respondent was checking on the property, and the property was in great condition. After receiving an email about suspicious activity at the property, respondent discovered that it was the potential buyer who had access to the property due to a locksmith making the key for the potential buyer. Respondent states that respondent told the potential buyer that she could not have a key until the purchase and sale agreement was signed, but the key was never returned. Respondent met with the potential buyer to sign a purchase and sale agreement, and respondent states that the potential buyer determined that she wanted her own agent. Respondent states that respondent then sent the documents to that agent. Respondent states that the agent could not get the potential buyer to cooperate, and a few months later, respondent states that respondent spoke with the potential buyer, who now stated that she was planning on moving her furniture out and would not be buying. Respondent then discovered the potential buyer had the locks rekeyed in order to gain access to the property. Respondent states the respondent drove by the property on several occasions, spoke to a neighbor, and did not know there was anyone living in the property. Respondent states that respondent did knock on the door and was threatened by a male at the property. Respondent states that the respondent posted a 3-day notice and began instituting proceedings for eviction, but was called by an attorney who was then going to handle the proceedings in court. Respondent further states that respondent did not instruct anyone to throw out complainant's son's personal property, that there was never a lease, only a purchase and sales agreement with a temporary occupancy agreement, which was never signed by the buyer despite respondent's attempts, and there was no rent money collected since it was not a rental situation but a purchase which was to take place. Respondent also states that respondent did not give any key to the potential buyer, that respondent did have a signed listing agreement for the listing, and complainant did not pay the invoices paid by respondent, which were sent to the complainant. Respondent included a purchase and sales agreement, temporary occupancy agreement, and amendment, all dated November 8th with no signatures. Respondent also included a copy of the power of attorney and a letter from complainant stating respondent had permission to deliver a utility check and sign forms for water activation. Respondent states that when respondent moved offices, the office owner shredded the files, and therefore respondent does not have the signed listing agreement or the hold harmless document. A review of the emails and other matter would seem to indicate that there may have been an agreement to sell the property, but there is no document to support this. There is also no document or email to support any agreement with complainant to allow furniture to be moved into the property pending sale, nor is there an agreement outlining the terms of the storage access. The recommendation is a consent order for $2,000 for failing to be loyal to the interests of the client in violation of Tennessee Code Annotated Sections 6213.312b14 and 6213.4042 for failing to diligently exercise reasonable skill and care in providing services to all parties to the transaction in violation of Tennessee Code Annotated Sections 6213.312b14 and 6213.4031, and failing to preserve for 3 years records relating to any real estate transaction in violation of Tennessee Code Annotated Section 6213.312b6, plus attendance by respondent at one entire regularly scheduled meeting of the commission within 180 days of respondent's execution of the consent order.
Motion to approve council's recommendation.
You don't want to add any education to that?
He's got education.
8 hours.
Just 8 hours.
The attendance of a TREC meeting. We have a motion to accept council's recommendation. Do I hear a second?
Second the motion.
Commissioner McMullen has seconded a motion. Now I'm looking for discussion.
So Julian, the recommendation, the first recommendation specifies failing to be loyal to the interests of the client. Do we have any documentation there was an agent-client relationship?
There's no signed agreement. She claims there was one, the complainant claims there was not one, and there's no proof that there was one.
So, in my sense, perhaps that shouldn't be part of the recommendation, or the justification for the recommendation.
I can outline to you the specific reasons that I recommended these three things. What?
I'm not doubting any, and I like the recommendation. I'm just saying, if we include failing to be loyal to the interests of the client, I don't have any reason to think there was ever a client relationship with an agent. You have to have a written agreement to have an agency relationship, and I don't, based on what the transcript says, there was never a written agreement signed by both parties.
There were emails back and forth, and this person was giving a key to access the property. I know there was no agreement, but I mean, it appeared that there was an understanding that this person was acting, just no agreement outlining the terms.
And my point is, in Tennessee law, I'm not preaching to you about it, but without a written agency agreement, there is no agency relationship. Therefore, there is no client. There are only customers. I've got a real heartburn with this guy doing stuff without authorization, but I'd hate to reference this as not being loyal to a client when he never really had a client. He was just out there freelancing, it looks like to me.
Well, in her own response, she claims there was one.
The respondent or the
The
complainant?
respondent claimed there was one, but it got destroyed. So if you were to take the respondent at their own word, then they're,
Well,
yeah, they say there was one, but it got destroyed.
The respondent does. The complainant says there never was one.
They said there was never one, that was signed between them.
Right.
The respondent admitted it, and it's being used against the respondent. The fact that there was one.
Well, but the complainant says there never was one, and there's no proof that there was, is all I'm suggesting.
But except for the fact that the respondent admits
against
it.
interest.
I don't know what that means either, David.
Yeah.
but-
It means you're guilty.
He admit, or she, the respondent, admitted that she had a client relationship with him, so she admitted that she was guilty of not taking care of her client.
The way the respondent outlined the response was that there was a listing agreement, but it was destroyed. I couldn't, there's no way, when a document's been destroyed and nobody has a copy of it, there's no way for me to prove if it existed or not. That was the reason for the recommendation of failing to maintain those records.
I
But
agree
there
with
is a signed, I think, sworn statement by that respondent stating that there was a listing agreement and
Okay.
that it was destroyed.
So what's that called, David?
Admission against interest.
Admission against interest. Okay. Is that what you were talking about, Austin?
Okay. He admitted it. That it
Even
was
if he
being
didn't
used
have it, he
against
said he did,
Yeah.
or she.
And does it have to be in?
If he lied, then.
Does it have to be in writing?
Yeah.
Huh?
To have an agent, to have a client relationship, you have to have a written agreement. As the only
So
way.
under the real estate statute.
It
Yeah.
has to be a bilateral
Okay, but
agreement.
not generally.
But
It's not like statute of frauds. Okay.
That's how client is defined
Correct.
within the
It's at the
broker.
Austin, you can still be a customer.
You're always a customer until you're a client.
Yeah, and you have responsibilities to customers, just not as much.
Okay.
You know, loyalty or obedience.
Julie, was the only thing that was destroyed inadvertently was the document we wanted to see? Or did they destroy everything?
The two documents that respondent did not have, that the respondent claimed existed, were the listing agreement and the hold harmless document. I don't know any more about whatever the content of that was other than what is referred to. It related to the storage of the property in the unit. As far as I know, the complainant had no knowledge of that. I assume it was some sort of agreement that was with the tenant or the storer outlining the terms of the property being stored there. I don't know anymore because, again, this document wasn't produced by any party. It's claimed to have existed but was not produced.
26 minutes of the tape inadvertently destroyed?
I didn't get any tapes, but
Here's Maxwell, I believe you can send them on audit too, well, it's audit forms.
That's right.
Okay.
Just
Any
depends
other-
on the juxtaposition.
Any other discussion on this motion?
Call for the question.
Mr. Chairman, we are requiring attendance at the track meeting.
Yes, that's included in the motion. All in favor, say aye. Aye. Opposed, no. Motion carries. Number 16 and 17.
2013-008-711, 2013-008-712. Complainant made an offer to purchase a property which was listed for sale by Respondent 2, an affiliate broker. Respondent 1 is now a broker but was Respondent 2's principal broker at the time during which the subject incidents took place. Complainant included a copy of the MLS listing for the property which stated that the property had been vacant, needed repairs to the water damage and mold remediation, and stated that the property had city water and a septic tank. Complainant states that the parties negotiated a contract for complainant's purchase of the property, which had a binding agreement date which was approximately 8 days before the closing date specified in the contract. Shortly after the contract was fully executed, complainant states that while inspecting the property, complainant could not locate a water meter and contacted the city and learned that the water lines at the road do not extend to the property, and the property had well water. Shortly thereafter, complainant states that complainant was asked to sign several forms, including a subsurface sewage disposal system permit disclosure, which complainant states that complainant refused to sign because of the discovery regarding the well water. Complainant states that the said refusal to sign made the contract null and void as far as complainant was concerned. Complainant states that on that date, complainant told complainant's agent about the water situation, that complainant wanted the contract canceled and the earnest money refunded. After the closing date passed, complainant states that complainant received an earnest money disbursement and mutual release of purchase and sale agreement signed by the sellers, and stating that the earnest money would be forfeited to the sellers. Complainant changed the form to state that the earnest money would be returned to complainant, signed the form, and returned it. Complainant also sent a notification form after the closing date which stated that complainant did not want the septic tank. The MLS showed city water and there was no city water. Complainant states that complainant was approached with an offer to split the earnest money, but complainant refused. Respondents state that the overall response to the complaint is that complainant was out of contract with the passing of the closing date and the inspection period before any communication or proper notification was given regarding complainant's cancellation of the contract. Respondents state that the only notification received from complainant's agent prior to the closing date was several emails which were included with the response, which indicating that there may be an issue concerning the septic system, which respondents state was clear in the MLS listing, and stating that complainant implies this could be a deal breaker and that the deal may be dead due to the home being on septic, but there was never any mention of city water or any formal notification or confirmation or termination prior to or on the closing date. Further, respondents state that the MLS had initially been entered as city water based on a previous MLS listing, which was initial oversight by the sellers. Respondents attached the initial MLS listing indicating city water, which had been initialed for approval by the sellers, which was later updated to indicate well water well before complainant sent the written notification form after the closing date. Respondents state that complainant was not in regular contact with complainant's agent in the final days of the contract period until the termination of the agreement was sent, and telephone calls with complainant's agent during that period indicated that complainant had walked away from the deal. Then complainant stated that after the closing date, complainant signed the earnest money release, which was sent to complainant from the sellers, requesting the earnest money back to the complainant, and sent the notification regarding city water in the MLS listing, which respondents state was the first time that city water was ever mentioned to respondents, or that it was communicated to respondents that complainant wished to terminate this agreement. And there was no documentation by any party to contradict this statement. The responses did not specify the current status of the earnest money, which was in dispute, so legal counsel contacted Respondent 1 because Respondent 1 was the principal broker throughout the transaction until well after the complaint and answers were filed, who submitted a response by email stating that the earnest money was still being held in Respondent's firm trust account due to the dispute. Respondent 1 states the respondents had told complainant and complainant's agent that the money should be interpled, but then respondents received the TREC complaint and the money is being held until instruction is received on how to proceed. It appears that a written request for the earnest money was submitted in writing by complainant via complainant's alteration to the earnest money release form on March 5th. The recommendation is to close as to Respondent 2, but as to Respondent 1, a consent order for $500 for violation of Rule 1260.02.09, specifically referencing subsection 3, which states that brokers are responsible for deposits in earnest money accepted by them or their affiliate brokers. Subsection 6, which lists a number of conditions which allows a broker to properly disperse funds from an escrow account. And subsection 7, which states that funds in an escrow or trustee accounts must be dispersed in a proper manner without unreasonable delay and should be dispersed or interpled within 21 calendar days from the receipt of a written request, plus attendance by Respondent 1 at one entire regularly scheduled meeting of the Commission within 180 days of Respondent 1's execution of the consent order.
Chairman, move we accept council's recommendation in part, but add a requirement that within
They respondent 2 or respondent 1 complete 8 hours of ethics training as well.
In addition to the
In addition to everything else.
In addition to the recommendation by council read into the record, Commissioner Flitcroft is making a motion. We accept council's recommendation with the addition of 8 hours of ethics, 8 hours of ethics training classes within 6 months.
Or can we do within 180 days?
180 days is fine.
And I just want to make a comment about 8 hours of ethics training. Steve, do we have anybody that's approved for 8 hours of ethics?
They'll have to be a makeup of several classes.
Typically, it's only going to be 4 hours.
4 hours would be fine.
Commissioner Flitcroft has amended his motion to 4 hours of ethics classes within 180 days.
Is that for respondent 1 or 2?
It's for the broker.
Respondent 1.
Turn respondent 2 loose.
And I'd like to talk about respondent 2. I'll second Dave's motion.
Okay, motion been seconded by Commissioner Grease. Discussion on the motion.
Well, he wants to talk about
Well,
respondent
well, after we get one out of the way, I'll.
Did he do a motion to accept it?
Yeah, he
did
made a motion to accept
That
it.
involves closing is to respond.
Okay, any discussion,
Okay.
any
Yep.
discussion on,
She's right. We need to discuss, because the motion now includes closing on number 2.
Yes,
John,
that's the first
I'll-
sentence of the
I'll-
recommendation.
I'll agree to amending it to say as to only respondent 1.
Well, let's discuss and we'll see where it goes. It may just be me, but respondent 2 was the broker or the licensee who was representing that it was on city water when in fact it wasn't. So the question in my mind is that a latent defect of the property, or should a reasonable licensee know whether the property is on city or well water?
What I was going by, and this is obviously something that you all may know more about than I do, is they provided copies of documents signed off by the seller that was what the information that was conveyed to them. Whether they should have taken further steps to have verified that, they had a signed off MLS listing with that on there.
A previous MLS listing, and so, is that right?
It was that MLS listing, the one that was utilized by these sellers for this person. When it was first put on the MLS, they submitted it to the sellers, and they signed off that the information was correct. So it was placed on the MLS. This complainant buyer came along. Sometime throughout the transaction, they realized that it was an error, and it was changed before apparently the whole situation fell apart. That was the version of it, and there's a copy of the initialed MLS listing.
Well, the seller said city water.
The seller had signed off on city water.
Property disclosure form had that too.
You know what? I don't think that they gave a copy. They said that there was extensive water damage in there, mold remediation, so I'm not sure if they even did a property disclosure, because it did not appear that it was an inhabitable property. All that they gave me was a copy of the MLS listing. I don't believe I had that.
For property inspection done, do you know that?
I believe, let me check. I believe that the complainant went out there by themselves to look at the property, and that's when they discovered the issue themselves.
Thank you.
It was a very short closing period, as I said, and I think the person just went out there and looked at it themselves.
Don't look it up.
All for the question.
heard the motion?
Mr. Chairman, are we voting as to 1 and 2, or just as to 2?
We're closing as to respondent 2. Motion that you made with council's recommendation is to let respondent 2 close to the respondent 2. But as a respondent 1, all of the things that has been required is...
Plus 4 hours of ethics.
Plus 4 hours of ethics is for respondent 1. Respondent 2 is off the hook, for lack of a good legal term at this moment. You've heard the discussion. Question has been called. All in favor say aye.
Aye.
Opposed, no. Motion carries. Number 18 and 19 next.
2013-00-8751, 2013-00-8761. Complainants were the buyers of a property and Respondent 1, affiliate broker, acted as a facilitator to the transaction. Complaint was also opened against Respondent 2, principal broker, for failure to supervise. Complainants alleged that Respondent 1 told complainants that the property had a septic system. After purchasing the property and purchasing a manufactured home to be placed on the property, complainants state that complainants discovered that there was no septic system, only a septic tank, and no way to put a system on the property. Complainants state that Respondent 1 did not check the land before complainants purchased it. Respondent 1 states that Respondent 1 was introduced to complainants who Respondent 1 was told wanted to purchase the subject property and needed assistance in writing an offer. Respondent 1 states that complainants intended on putting a mobile home on the property. While meeting with complainants, Respondent 1 states that Respondent 1 pulled the listing, this was a foreclosure property, as well as the tax card, and stated that the listing represented that the property had a septic tank and that there was an older home on the property. Respondent 1 further states that Respondent 1 explained that the county would not have any records on the septic system due to the age of the home on the property, and due to the foreclosure status, complainants would have to purchase as is, where is. Respondent 1 states that Respondent 1 told complainants not to tear down the existing house until getting a repair permit on the existing home for the septic. Complainant denies this statement. After closing, Respondent 1 states that complainants contacted Respondent 1 stating that there was only a tank and complainants could not get a repair permit. At this point, Respondent 1 states that Respondent 1 learned that the existing home had been torn down. Respondent 1 states that Respondent 1 made calls and informed complainant that if complainant could find evidence of field lines, the repair permit could still be issued. Complainant states that this information was not received from Respondent 1. Respondent 1 states that Respondent 1 set up a meeting for complainants with a soil scientist to look for suitable area for a system, but there was none. Learning that complainants had obtained a building permit and placed a mobile home on the property, Respondent 1 states that Respondent 1 then assisted of complainants in contacting the adjoining property owners to ascertain whether one of the property owners would grant an easement, which was denied. Respondent 2 confirmed the information in Respondent 1's response, stating that neither respondent did anything wrong and instead worked together to assist complainants with the issue. Further, Respondent 2 states Respondent 1 never viewed the property and was never asked to view the property by complainants, as they knew this was the property they wanted. Further, Respondent 2 states that numerous documents accepting this bank-owned property and as is where it is condition with no express or implied warranties. The documents specifically state that Respondent 1 was a facilitator for complainants and this foreclosure property was listed by another licensee. The contracts further state that the property was purchased as is whereas with all conditions and exceptions waived. An addendum to the contract, a disclosure and hold harmless agreement, also states that the property is sold as is with no warranties or representations regarding the structure on the property. There does not appear to be a violation by respondents, and therefore the recommendation is to dismiss.
Motion to accept the recommendation.
Second.
Motion by Commissioner McMullen to accept council's recommendation to dismiss, and second by Commissioner Alexander. Is there any discussion? I have two questions. One question especially. What price range property was this? Just out of curiosity. They were going to put a mobile home on it, and on the property was a septic tank. No field line. And an old house. This just is, I'd like to just, I'd say, I can't ask what part of the state it was in, but this just.
No, you can't.
It has just sort of raised my curiosity. How you have a septic tank without a field line?
You got a straight line going out there to the ditch.
You got one going to the ditch? That's the way y'all do it in West Tennessee. This must have been in somewhere out near Dresden, huh?
That's right.
Graywater takes on a whole new kind.
You would be surprised at the homes in my county that does not even have a septic tank.
Looks like it was
Straight line.
sold for $30,000.
$30,000. Okay. Any other comments or discussion or questions?
One of my comments is that the agent was a facilitator rather than being a buyer's agent, and that's just a little. I wonder why they do that when they're not the listing agent, and that's just curiosity to me why agents do that.
I think the way that they presented it in the response was that they were kind of put in touch with this person by a mutual acquaintance, said, hey, they need help writing this offer and they know what they want. Can you just help them put it in the right form? You just wrote it up. That's how it was presented in the response, at least.
Okay. Any other discussion? Hearing none. All in favor say aye.
Aye.
Opposed, no. Motion carries. We're on number 20 next.
20 next.
20 next, yes, we are.
2013-009101. Complainant is a property owner and respondent, unlicensed individual, was hired to provide property management services for 2 properties owned by complainant. Complainant terminated the contract with the property management company owned by respondent after learning that the company was not licensed. In an email exchange, respondent stated to complainant that respondent was a licensed business entity through the IRS. In response to this complaint, respondent stated that respondent is CEO of the unlicensed property management company and that respondent's father had been manager of another management company but had died. Respondent stated that the property owners wanted to continue with the father's company, so respondent completed a real estate course and applied for a business license. Respondent stated respondent did not negotiate any lease on behalf of complainant, but only collected rent on the properties and sent that rent minus a 10% management fee to complainant. Respondent states that the management contract sent to complainant was the same contract complainant had signed with the previous company. The contract provided is a management agreement and bears the name of the unlicensed property management company now run by respondent. Respondent provided a form indicating that respondent had completed the course for new affiliates in January 2013, but as of the date of the Commission's review of this matter, there was no application for license and no license. Does it need to say new recommendation? The recommendation is a consent order for $1,000 for unlicensed activity in violation of Tennessee Code Annotated Section 6213-1024A and B, defining broker, and 6213-103 and 6213-301. Said order to also include an order to cease and desist all unlicensed activity.
Have a motion by Commissioner Grease to accept council's recommendation, which is consent over $1,000 for unlicensed activity in violation of all those things that he was in violation of, and cease and desist all unlicensed activity. Seconded by Commissioner McMullen. Any discussion? Hearing none. All in favor say aye. Opposed, no. Motion carries. I just wanted to ask you if it's okay, being just one of 9 commissioners, but I'd like to suggest that we just work right on through. Unless you need to go to the restroom, your Eve, y'all got to be here. And if anybody does need to go to the restroom, then just get up and go and come back as quickly as you can, and we'll continue right on until we finish. 21's next.
2013-009241. Complainants alleged they made an offer for a house which was listed as a short sale. Respondent broker was the listing broker, seller's agent. Initially, complainants drove by the house and the sellers allowed complainants to view the home. After calling respondent to ask if offers were still being taken, when respondents were informed by respondent that there was one offer on the house, but respondent was not sure what the bank would do with the offer, complainants state that they contacted their broker to schedule an official showing and placed a written offer on the property. Later, complainants state that they were contacted by respondent who informed that the sellers planned to bring funds to closing to avoid a short sale since there was a first and second lien on the home, and complainants would need to submit a higher offer to accomplish a sale. Complainants state that they then contacted their broker to get the offer in writing and submitted, but state that respondent never contacted their broker directly regarding this matter. Complainants state that an offer was submitted to respondent and that weekend, the seller saw the sellers in the yard in an inspection truck. The following week, complainants state that they contacted their broker and received the news that sellers were out of town and would sign the deal on the following day. 2 days later, complainants state that they were told by their broker that the house had been sold to someone else. Complainants' broker submitted a statement as well, stating that complainants' broker was upset that respondent had talked directly to complainants and not dealt with complainants' broker regarding the increased offer. Complainants' broker and complainant state that during the process of the home going out of short sale status, they were all led to believe by respondent statements that the complainants were going to get the house. Complainants and their broker believed that they were misled by respondent during the process. Respondent submitted a response confirming the initial contact respondent received from complainants regarding whether offers were still being taken, and respondent confirms that respondent allowed complainants' broker to show them the home and spoke with complainants' broker regarding submitting an offer because respondent was not confident that the bank would accept the already pending offer. Respondent states that respondent received notice of the bank's rejection of the initial pending offer on the same day that complainant submitted their offer through their broker. According to respondent, due to a health issue with complainant's broker which had him out of the office, complainant's broker's assistants got respondent the additional short sale documents a few days later to begin to process the short sale. Respondent states that respondent was contacted by complainants directly 3 times. Once to check the status of the short sale, the second time to discuss the fact that the other that the offer covered the first lien but not the second lien in the typical timeline. This was for the short sale. And the third time to discuss complainant's current living situation and the fact that they could not get news from complainant's broker, whom respondent states respondent could also not reach due to the aforementioned health issue. Later, respondent states that respondent got written notice that the first lender had rejected complainant's offer, and the sellers instructed respondent to stop the short sale process, stating they were going to bring money to the table but also need a higher offer than complainant's. Respondent states that this information was conveyed to complainants, and complainants were instructed to discuss writing a new offer with their broker. Respondent states that respondent then sent, and complainant signed and returned, a written mutual release of complainant's earnest money. Respondent states that respondent never received a second offer from complainants. Several days later, respondent states that respondent notified complainant's broker that the sellers had received another offer. Respondent states that with regard to contacting complainant's broker was not always available due to the health issue, and respondent denies making representations that complainants had the house. The matter regarding respondent contacting complainants on a few occasions instead of their broker would appear to be an ethics issue. Further, with regard to a second offer, which complainants state their broker submitted and respondent claims was never received, there was no proof submitted that this offer was ever transmitted to respondent. Based on the information within the file, there does not appear to be a violation by the respondent, and therefore the recommendation is to dismiss.
Rob, I think there is a ethics issue. I think when it says respondent states that respondent was contacted by complainants directly 3 times, I think 3 times, that's too many times. That's 3 too many. I think the contact has to be through the other broker.
But I think that that might be an ethics issue with maybe the association instead of us, because I don't know that we have anything with regard directly to contact that I saw in here. I believe that is directly addressed within the canons of ethics, which is the
So it's not a
TAR
violation of the Brokers Act to...
I believe that's listed under the canons of ethics that are the national association that TAR would have in the local association. I think it's an ethical thing more than a violation of the Brokers Act.
Learn something new every day.
We don't have any motion.
Move to accept council's recommendation.
Second.
Commissioner Grease has made a motion. We accept council's recommendation to dismiss, and Commissioner DeSharo has seconded that motion. Any other comments or discussion? Hearing none. All in favor say aye.
Aye.
Opposed, no. Motion carries. Next, we have 22 and 23.
2013-009451, 2013-009452. Complainant purchased a home in December 2008, and Respondent 1, affiliate broker, represented complainant in the transaction. Respondent 2 is Respondent 1's principal broker. Complainant states that complainant discovered mold and standing water in the crawl space of the home in November 2012. Complainant states that complainant's homeowner's insurance will not cover the damage because the issue is due to grading. At the time the home was purchased in 2008, complainant states that there was a grading issue which was raised during the home inspection, and the seller's representative, in communications with Respondent 1, assured that the issue would be resolved prior to closing. Complainant states that due to the assurances that the issue was taken care of, complainant proceeded with the closing in December 2008. When the insurance company informed complainant that the issue was not covered in November 2012, complainant contacted respondents, and complainant states that both were of no assistance. Complainant feels that respondent's firm and Respondent 1 are responsible for the repair costs. Complainant included documentation from the seller dated from the month of closing in 2008 outlining the irrigation and drainage improvements which were made to the property. Complainant also attached the 2012 denial letter from complainant's insurance company, which appears to outline a number of reasons why the loss is excluded from coverage, with grading being one of multiple exclusions outlined. Complainant also included a report on the damage and moisture intrusion completed by an engineer, which indicated extensive moisture conditions, wood decay, and microbial growth, which the report opined occurred over a period of time greater than 1 year as a result of groundwater seeping into and standing in the crawl space, lack of adequate moisture control, damp proofing, and a lack of adequate crawl space ventilation. Respondent 1 states that Respondent 1 was complainant's agent for the 2008 sale. Respondent 1 states that complainant had a home inspection during the contract period prior to closing, and the inspector noted an issue with water runoff behind the property. The home had never been lived in by the seller, who had bought the home and later resold it that year. When the water issue arose in the inspection, Respondent 1 states that Respondent 1 contacted the seller's representative who sent a contractor to remedy the problem. Respondent 1 states that complainant was made aware of what was being done prior to closing, and complainant agreed to close. When contacted by complainant in 2012, Respondent states that Respondent tried to contact the seller to no avail. Respondent 2 states that Respondent 2 spoke with complainant about the issues with the home, and Respondent 2 told complainant that Respondent 2 would speak with Respondent 1 and the seller's representative in the transaction. When the seller's representative was non-responsive, Respondent 2 states that Respondent 2 called complainant and stated the seller's representative was non-responsive and suggested that complainant might call an attorney. It does not appear that there was any violation by respondents. Instead, if anything, this appears to be a possible dispute between the seller and the complainant, and therefore the recommendation is to dismiss.
Questions of Ms. Crop? I hear a motion as to the disposition.
Move to accept council's recommendation.
Second.
Motion by Commissioner Grease to accept council's recommendation and dismiss, and seconded by Commissioner McMullen. Any other comments or discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Number 24 is next.
2013009491. Complainant states that Respondent, principal broker and principal auctioneer for a real estate auction firm, conducted an auction on a property which complainant attended. Complainant states that complainant was competing against another bidder and was the winning bidder, but complainant then heard that the second bidder worked for Respondent's firm and was there solely to increase the bid price. Complainant states that complainant told Respondent to have the second bidder buy the property, but states that Respondent said no. Complainant states that now Respondent continues to attempt to get the deposit money from complainant even though the property later sold to another person. Respondent submitted a reply stating that the auction was properly conducted with the firm recording all people who had an interest in purchasing the property and Respondent calling the auction. Respondent states that initially there were 4 bidders, but later only 2 individuals, complainant and another individual who is a real estate broker, were the final 2 bidders. When complainant won the bid and after complainant signed the contract and had given the deposit check, Respondent states the complainant later contacted Respondent stating that complainant did not want the property and instructing Respondent to give the property to the second bidder, at which time Respondent states that Respondent informed complainant again that complainant had purchased the property. Respondent denies that anyone was running up the bid and states that the property did later sell to the second bidder. Respondent states that an attorney is currently attempting to serve complainant regarding an action in court for writing the deposit check and then stopping payment on it. It does not appear that there was a violation by the Respondent, and therefore the recommendation is to dismiss.
Is this typical of most auctioneers that they'd have a buy? They'd have a buy bidder of some sort working the ring? Is this typical, Julie? Do you hear a lot of this in the Auctioneers Commission? Especially in East Tennessee, for instance.
It is against their rules to have that, but here it did not appear that that was what was taking place.
Julie, is, just for my own information, is this complaint going to be heard by the Auctioneer Commission, or would you have, I mean, is there a fine line in there somewhere between you say, okay, this is an auction complaint versus a real estate complaint and send it to the Auctioneer Commission versus coming here?
I don't get to make that call. I mean, right now I could have recommended refer this to the Auctioneer Commission, but I saw nothing indicating a violation under the auction laws either. This was filed as an online complaint with the Real Estate Commission. I checked the Auctioneer Commission's complaint listings. Sometimes people will file both places. It was only filed with Real Estate. Based on the information that was given, I don't see a reason to refer it to the Auctioneer Commission. We can do that, but based on the documents that were submitted in support of the response, I just don't see the need here.
What is the violation? There's no violation.
It's a violation of the auctioneer laws to use false bidders, cappers, or pullers, but here it did not appear that that was the case.
If the false bidder, so to speak, wound up buying it, it wasn't false.
How's it false?
Right.
How's it false if you spend your money?
That's why I didn't recommend referral to the...
Motion to adopt council's recommendation.
Second the motion.
We have a motion by Commissioner McMullen to accept council's recommendation to dismiss, and seconded by Commissioner Alexander. Hearing no more discussion or comments, everybody who's in favor say aye. Aye. Opposed, no. Motion carries. Number 25 is next.
2013009651. Complaint opened by Trek against respondent principal broker based on respondent's failure to satisfy an agreed citation sent to respondent. Respondent was sent an agreed citation which contained a civil penalty for an escrow violation discovered during an audit of respondent's firm regarding an earnest money check which the auditor stated was not timely deposited into the firm's escrow account pursuant to the terms of the contract. Because respondent had not signed and returned the agreed citation, this matter was opened in legal as a complaint. After this matter was opened in legal, respondent submitted the executed agreed citation and paid the civil penalty included therein, and therefore the recommendation is to dismiss.
Move to dismiss.
Second that.
Motion by Commissioner Grease to dismiss and seconded by Commissioner McMullen. Any discussion? Hearing none, all in favor say aye. Opposed, no. Motion carries. Number 26 is next.
2013010341. Complainant, expired licensee, previously had 2 complaints for which consent orders had been sent and which respondent had not resolved, resulting in 2 matters being forwarded to litigation. Due to the nature of the violations contained within the consent order and the fact that respondent was no longer licensed, it was determined by the litigation attorney that litigation could not proceed with the facts as presented. Additionally, an investigation yielded information that despite respondent's license expiration in February 2012, it appeared that respondent and respondent's business may be engaged in unlicensed activity. Based on this information, the Commission voted to close the 2 previous matters and open this complaint against respondent based on the information obtained during the investigation for unlicensed activity. This complaint is based on an investigation wherein it appears that respondent and/or respondent's business is advertising homes for sale. Some of the listed homes are owned by respondent and/or respondent's business. It appears that respondent is the sole member of the business, but the investigation yielded information that other listings on the advertisement were not owned by respondent or respondent's business. Neither respondent nor respondent's business have any current license that would allow respondent to list these properties, which indicates unlicensed activity. Respondent submitted no response to this complaint. Therefore, the recommendation is a consent order for $1,000 for unlicensed activity in violation of Tennessee Code Annotated Section 6213-102, 4A and B, Section 6213-103, and Section 6213-301. Said order to also include an order to cease and desist all unlicensed activity.
Heard the recommendation of council. What's your pleasure?
So moved.
Mr. Flitcroft makes a motion to accept council's recommendation and seconded by Commissioner Haynes. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Number 27.
2013010351. Complainant states that respondent, principal broker, advertises listings on Craigslist which are not respondent's listings. Based on the information submitted by complainant, which consisted of multiple MLS listings of HUD properties along with respondent's Craigslist advertisements of the same properties, it appears that respondent fails to mention the listing agents for the properties and fails to include the proper identifying information as required by Trek's advertising rule. Respondent submitted a response expressing confusion with regard to why a complaint was filed against respondent for these ads. Respondent states that the properties are all HUD properties which can be advertised by all HUD-approved brokers, which respondent states is encouraged, and respondent states that respondent is a registered HUD broker. Respondent states that respondent believes that all advertisements were done correctly, but indicates that respondent has stopped placing these types of ads since receiving the complaint and would appreciate advisement as to the correctness or error of respondent's actions. In light of the format of these ads, the connection to HUD properties, and the provisions of the Trek advertising rule, it is recommended that the Commission discuss this complaint to determine what action is appropriate. I'll just tell you that based on the fact, I know that a number of you are well more informed of HUD properties than I am. I had the paralegal do a little research into HUD properties, and it did indicate on the website that HUD-approved brokers can advertise these listings. But despite that fact, I still saw some issues with the format of the advertising under our advertising rule. Specifically, the way these were listed on Craigslist stated to call respondent, just had the name and a telephone number, which doesn't appear to be this respondent's. It's not this respondent's firm telephone number. Based on that, it appears that that would be in violation of the provision of the advertising rule saying that no licensee shall advertise to sell, purchase, exchange, rent, or lease property in a manner indicating that the licensee is not engaged in the real estate business, because it doesn't make it clear whether that person's the owner, a broker, or what have you. Also, under our advertising rule, it says that all advertising shall list the firm name and telephone number. This respondent didn't include the firm name or the firm telephone number on the Craigslist ad. The question comes in down with the internet advertising provisions. 4B states that each page of a website which displays listing from an outside database of available properties must include a statement that some or all of the listings may not belong to the firm whose website is being visited. It's not this person's website, but it would seem to me, based on this provision, that this individual should have put, this is, not my listing, this is someone else's listing, and perhaps should have gone further based on 4A that states, under internet advertising, the listing firm name and telephone number must conspicuously appear on each page of the website. Now, I think that provision was originally meant for when the listing broker utilizes internet advertising, they're supposed to put their name and firm name. However, it could apply here for someone who's listing someone else's listings. It could, I think, be read to require that if you're going to advertise on the internet, you need to include the listing broker's name and telephone number. I was wondering your thoughts on this, if you didn't see any problems with it. Those were the issues I saw, all within the same rule but different subsections. Just interested to see what you think and what you thought the appropriate disciplinary action would be, because based on my own knowledge of it, it would appear that this gentleman appears to have been doing something he was allowed to do but was not exactly listing it in the correct format. I would think he would benefit most from a letter of warning explaining to him in detail how he needs to do this, but you all may see this as something more egregious that warrants something further.
Wendell?
Well, these things that we have calls every day of these HUD homes where people have pulled up on Craigslist. We don't enter them on Craigslist. They pick them up off the MLS or other places. Now, you, first of all, would be interested to know if the individual that picked this up or may have got it off of my website or HUD's home store, wherever they might have gotten it, if they had a NAID number. If they don't have a NAID number, they can't sell it anyway.
He lists that in the response. This individual does have a NAID number.
Okay. But you can't. The only official, and HUD will tell you this, the only official website to know exactly about a HUD home is HUDhomestore.com. Any other thing is irrelevant. That if you want to know about a HUD repossessed house and know what the facts are, you gotta go to HUDhomestore.com. Now you can go to my multiple listings in Jackson, Paris, anywhere, and you'll find those things. But the official site for a HUD house, you can go to HUDhomestore.com, plug in an address, a zip code, or anything, and you can pull up any house in the United States that is available. But we consider, and when people call you or call us about what they see on Craigslist, we say go to HUDhomestore.com if you want to know what the facts are. Now, anybody can list can advertise them, but you've got to have a NAID number. You got to be a broker. You got to have a real estate license to sell a HUD house. Every HUD house has a designated listing broker, but anybody can sell them if you've got a NAID number. If you haven't got a NAID number, you haven't got it. But I would disregard it.
This complaint?
Yeah, I think you need to dismiss it.
Okay.
Well, I think the problem is, Julie, like you said, he don't have his company name and phone number on the Craigslist ad.
I was just
think
trying
that's
to look at the
biggest-
Craigslist ad from the stance of someone who didn't know any of this, just looking at the Craigslist ad, and it just says, call this person at this number. And I don't, it doesn't identify. What?
Does it say HUD home for sale? Call this person at this number?
It just talks about the home itself.
Just 3-bedroom, 2-bath home. Call
and a
me.
picture. Call me at this number. And so.
And the me is the broker, but it's his personal number?
It's not the firm number that's on file with the Real Estate Commission. It's a different telephone number.
But it is the broker's name.
Mm-hmm, it is. But it doesn't identify the person as a broker or list the firm name or firm telephone number.
I have a problem with that one.
I felt at a minimum there was an issue with not identifying himself as a broker or listing the firm name and telephone number. I don't know. It appears Commissioner Alexander feels differently, but I mean, that's why I recommended this for
No,
discussion.
Judy, I
because-
misunderstood what you said. No, my point was that, did this individual actually enter this himself?
Yeah, he
He put it on Craigslist himself.
Okay, that part, I'm just brought you up to date. What, the official way to handle it. Now, I don't have any part, I don't care what you do about this dismissal if you feel like that. If it's.
I think he
but
should
this
be.
man- Excuse me.
I'm sorry, go ahead.
This individual's not a listing broker.
He was not the listing broker for any of the homes.
Okay.
But I definitely think he should be given a letter of instruction and possibly even a fine for the advertising violation
I
because.
think he should have a fine for the advertising
Well,
violation.
I mean, as a broker, he should know he's got to put the company name and phone number on there at a minimum.
I mean, it sounds like he's
Do
the
either you-
individual selling his own house.
Do either one of you two like to make a motion as to what we do with the disposition
Well,
of this
we're still
complaint?
discussing.
Do you
Thank
think
you
that
very much.
Maybe, I mean, I realize what you're saying, but this person seems to. Sometimes I find that when we send out consent orders, people will sign them and send them back and not even really know what they signed for. They just pay it to get rid of it. I mean, do you think there's any possible way that a letter of warning might serve to prevent this more in the future than a consent order would under these circumstances? Since, according to Commissioner Alexander, the act of doing it was not improper, it was just not done in the proper format. I mean, I'm wondering if a letter of warning, they would actually pay more attention to, hey, this is how I should format this in the future than a consent order would. Because I find I have people call me that have signed things and have questions about attending a meeting and don't know what they signed it for. They just,
Janet, I don't know about you, but I'd like to make a motion that was $500 fine and attend a track meeting.
And a letter of warning.
I can only do one.
Only do one or the other.
Why, you do it all.
I can only do.
Well, I agree with that. I think if he attends the track meeting, he'll understand what we're talking about.
But a letter of instruction.
Well, and I'm hearing over here too, if you write a check, you usually figure out why you've written a check.
I've had people call me to ask about meeting
You
times
better
that
figure
don't
out.
know why, and they've signed and returned it with the money. And
Okay, does in the consent order say
it lays
why?
it out.
It lays it out.
It
Well,
does.
And when he comes to the commission meeting, if he needs help, we'll explain it to him.
But I think he needs a fine and come to a commission meeting.
Yeah.
That's my motion.
I'll second that, Michelle.
Can I just ask, this was my point of clarification I was hoping to get resolved. I realize 2A and B are a problem. He did not identify himself as a licensee and did not list his firm name and telephone number. Also, under internet advertising, would you all say that there should have been some sort of statement, as 4B says, stating that this was not his listing? And do you also think that he should have listed the listing broker's name and telephone number as well? Not that far.
That's a gray area.
It is.
Well,
because
I
don't
think
know
that-
that's
I
how
think
it
the
was.
Craigslist is blatant.
And I think that his own MLS rules may address that, and that's something for them to deal with as far
Okay.
as that goes. But I think we've got the
So
other
then-
track rules that are pretty obvious.
So then 2A and B, and then 4B regarding the statement, this is not my listing, basically.
Where's the telephone number? Where does that telephone number ring to?
It's in that,
I did not call it, but it's not the number that is. I didn't want to call
Probably
it
a cell
hang
phone.
up, but it's not the name, the number that's registered with Truck. It's also not the number that was on the company letterhead that was sent in response to the complaint. So I feel sure it was not the firm number, but it did not have the firm name in any case. So
Mr. Chairman, what's the status of our motion?
We don't have one.
Yes,
I was
we
getting-
do.
No,
Michelle
no,
made
that-
one and I
I made a
seconded
motion
it.
for a $500
Okay,
fine.
restate your motion.
$500 fine.
Civil penalty, not
Civil
fine.
penalty, right, civil penalty, and attend a track meeting based on that he's got to have, I don't know which statute.
do you
it
want
is.
me to list the subsections we were talking about, the three
Please.
that you all just said?
Yeah.
That would be 2A, which is talking about no one shall advertise to sell, purchase in a manner indicating that they're not engaged in the real estate business. 2B, which says all advertising shall list the firm name and telephone number. And then 4B, which says each page of a website which displays listing from an outside database of available properties must include a statement that some or all of the listings may not belong to the firm whose website's being visited.
Offer the question.
And I seconded it.
You've heard the motion and you've heard the discussion. All in favor say aye.
Aye.
Opposed, no.
Abstain.
Motion carries 6 yes and 1 abstention.
500 and a commission meeting within 180 days.
Yes.
I was trying to get down the other part.
Number 28 is next.
28, 2013-011-001. Complainants have been longtime timeshare owners with respondent a timeshare registration. Complainants state they were victims of misleading and deceptive statements by salespeople and were held for long periods of time for sales presentations. In 2009, complainants decided to purchase an upgrade and were not pleased by the product they received. Therefore, complainants complained to respondent wanting a contract cancellation, and respondent did cancel the 2009 contract, but complainants also want the remaining contract owned by respondents canceled and a refund of the down payment, stated the complainants only owe maintenance fees, which complainants now refuse to pay. Respondents submitted a response stating that complainants have made numerous additional purchases since their initial timeshare purchase in 1994. In 2001, respondent states that complainant traded in a number of contracts to utilize the equity to purchase a single contract. In 2009, Respondent states that complainants traded another contract to utilize the equity to purchase a new contract. Respondents state that complainants signed the statement of understanding and purchaser summary outlining the terms of the product which was purchased and disclosing issues regarding ownerships, assessments, and programs and containing rescission rights. Respondent confirms that complainant's 2009 contract was canceled due to delinquent amounts owed. Respondent denies the allegations contained within the complaint, but states that as a gesture of goodwill, respondent will agree to cancel complainant's remaining contract with no further financial obligation. It appears that these subject transactions occurred outside of TREC statute of limitations. Despite that, however, there does not appear to be evidence of a violation by respondent, and the recommendation is to dismiss.
Second.
Commissioner McMullen makes a motion. We accept council's recommendation and dismiss, and it was seconded by Commissioner Haynes. Any discussion? Hearing none. All in favor say aye. Aye. Motion carries unanimously. Number 29 and 30 are next.
Somebody's singing.
29 and 30, 2013-012271, 2013-012272. This complaint was originally filed with the Consumer Affairs Division in 2012, but was recently forwarded to TREC by Consumer Affairs. Complainants allege that they attended Respondent 1's unlicensed activity sales presentation. Respondent 2 appears to be an individual who works as an administrative director of Respondent 1. Complainants state that they were promised greatly discounted vacation resorts, hotels, cruises, and airfares by purchasing a membership with Respondent 1, which is a vacation travel club. Respondent states that vacations were not cheaper as a result of complainant's membership, and discounts were in reality very small. As a result, complainants state that they are entitled to a refund. Based on the documents received from Consumer Affairs with the original complaint, it appears that complainants received a return of their money from their credit card company and did not pursue the matter further. A response was submitted on behalf of respondents, which states that the travel discounts marketed for hotels, condominiums, cruises, rental cars, etc. are true and accurate, but savings can vary depending upon what type of booking a member chooses to make. The issue for TREC is whether or not respondents are engaged in unlicensed activity. From all the documents and contracts submitted regarding the sale of the vacation membership, it appears that respondents are merely selling travel memberships which allow members discounts on travel for condos, hotels, airfare, cruises, etc. And based on this information, it does not appear that respondents are engaged in unlicensed activity, and therefore the recommendation is to dismiss.
Happening all over the state. Move to accept council's recommendation.
I'll second with a comment. Can we not just tell Consumer Affairs we don't want these kind of things? I mean, why do they think it's appropriate? What basis would they have at all for sending this?
And
to
does
us?
it affect real estate?
It doesn't. I know, and that's why I'm not sure why we.
It's just a travel club. I could tell you which.
Can't we just say thanks but no thanks?
Tell them we gave it the office or something.
I'll have to check that. That's above my pay grade to tell them that.
Question.
But
okay.
I can look into that.
You have heard a motion made by Commissioner DeShara to take council's recommendation and dismiss, and seconded by Commissioner Grease. Any further discussion or comments? Hearing none, all in favor say aye. Opposed, no. Motion carries unanimously. And next we have a...
Mr. Chairman, request permission to address the audience.
You may, Commissioner Flitcroft.
We have found today that if you give a key to a potential buyer, the buyer may make a copy of the key. We've found today that if you have a listing, you ought to visit it every once in a while, certainly within 3 months. We have found that if you are a broker, you're going to have your license revoked if you have one $5,000 check in your escrow account for 4 years and you spend the money. It's not yours. We have found that a broker is required to file an interpleader within 21 days. They ought to have known that anyway. We have found the caveat emptor, buyer beware, is still alive and well in Tennessee law, that you're probably better off being a facilitator, and that even the most careful buyer can buy a home that has a septic tank without a drain field, and in western Tennessee often without a septic tank, just has got a piping line. And a certain unnamed lawyer who also serves as trustee is allegedly to have sold a house in Sevier County on a foreclosure sale, but much beyond the statute of limitations. We have a number of unlicensed activity cases, and we cannot do much about them. We can find these people. They're not going to pay the fine. They don't even have a license.
Sometimes they do.
And we've learned that talking to the other side, the buyer in this case, is not a violation of the Brokers Act, although it may be a violation of the ethics law.
Did we
We've learned
figure
a
out
lot.
the difference between a mobile home, a modular home, and a manufactured home? We had 3 different cases about it.
That was a lot of this month.
I have an article on it.
Well,
She offered me that.
Mr. Chairman, there's a lot we have learned today.
yes, we do know what you've been doing for the last 2 hours, Commissioner Flitcroft. At least we know you paid attention during this legal report. Thank you for bringing that to our attention.
You did good.
And I do want somebody to explain to me the difference between a modular home and a mobile home.
I'll send you, oh no, I'll have to bring it next month. 'Cause
Okay, bring it to me.
Wait, do we have an expert? If we have an expert, we'll like to hear from him.
We'll visit briefly after our adjournment.
It's not on the agenda.
It's not on the agenda. But next we have a consent order log that I think Ms. Julie Kropp, you did an excellent job.
She's gonna do the AG opinion.
If you don't have any questions on the consent order log,
No.
these are just the four matters that were consent orders that have been moved over to litigation. I move the ones that have been closed and satisfied to a separate one. That's why there's so few. I was going to move on to the Attorney General thing, which y'all deferred from last month, if you remember.
Julie, don't pay any attention to him. He's just the chair. He doesn't. He's only one of 9.
One of 9.
He's one of 7, so your odds are better. We had a request for a formal Attorney General opinion, which was submitted to the Attorney General's office in May of 2012. In your materials, it outlines the original question, but basically it asked for an interpretation of Tennessee Code Annotated Section 6213-104A1. Which is some of the exclusions from licensure. And this, I'm not going to read the entire exclusion, but it applies to individuals working with a corporation. The original question as presented is included also. And we were contacted recently by the Assistant Attorney General who is working on this, and he requested some clarification as to what the commission exactly wanted to know. He was having trouble drafting an opinion based on the original question as presented. I thought rather than coming to you and just explaining this to all of you, I would try to break it down. I discussed with him some of his confusion as to what you were wanting, and I tried to break this down into 3 separate questions, which are outlined here below. I can read them aloud if you want. I know you looked at them last month. But basically, what I'm asking is, do you believe that these 3 questions still hold true to the purpose of your original request? If so, I can submit these to the Assistant Attorney General and maybe assist him with going ahead and getting an opinion on this topic, because apparently he's struggling with trying to figure out exactly what questions need to be answered as the question was originally posed to them.
We put this off specifically for Commissioner Flitcroft because I know he's been real interested in this opinion. We didn't.
I am.
Well, we didn't talk about it last month because you weren't here.
No.
That's my point.
That was our excuse.
That was our excuse, right?
I think Julie's done a good job. I'd return it back to the AG
Okay.
with her comment.
I will just get back in touch with him and just say that we've tried to break this down a little more, and that I wanted to confirm with you all that this still held true to what you originally wanted to ask, because I believe when your discussion started, it was before I even came on as board attorney, and I wasn't here for all of those, so I wanted to be sure that it was still holding true. So I will get back with him, and hopefully that will move this along, because if you could do it by motion that you want me to submit these kind of the new breakdown of the question, that would be great, just so we have it in the minutes for a
It's
record.
been referred to me. I move that the council submit to the Attorney General the format as stated in her record. I think the questions are exactly right.
Second.
We have a motion by Commissioner Flitcroft to do all the things he put in his motion, and seconded by Commissioner Grease. Any discussion or comments on Mr. Flitcroft's motion?
For the vote, one question.
Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously. Commissioner Grease.
Julie, is it correct that you described the Attorney General as confused?
Not confused. I guess. And it's not the Attorney General. I talked to one of the Assistant Attorney Generals.
Julie, you may not want this on record. You may refuse to answer that on the grounds that might incriminate you.
I'm just checking.
The Assistant Attorney General wanted to be diligent about
was the
providing.
confused
He wanted to be diligent about providing as complete a response as possible, and therefore thought it would be beneficial to break down the
Having
question.
fun.
You're just having fun
Thank
with
you
me,
very
aren't you?
much.
That's all I have, Mr. Chairman.
You did an excellent job as usual today, Julie. We appreciate the job you do for us. Now, let's see if our Education Director, Mr. Steve McDonald, can do as good a job.
Wake up over there, Steve.
Thank you, Chairman, and continuing the spirit of good humor, I have placed before you 33 courses and would like to ask you respectfully, do you have any questions about them?
Yep, I do.
Yes, sir.
Course S15. Did you just put that in there to see if we would actually read through this?
No, sir.
And
I
would love
respect your time. All courses that are submitted are put before you. And Northwest Exterminating is a previously approved provider. The purpose of their course is designed to help real estate agents determine what to expect, being contacted to solve problems as they relate to Tennessee wildlife. It does provide some interesting information on remediation of such furry and legged pests in a home, which could be valuable for licensees that actually have this issue in a house that they're trying to sell.
Your summary that caught my attention said, provide information on how licensees can recognize, control, and remediate damage to properties from mice, rats, squirrels, ground rodents, coyotes, foxes, snakes, and birds.
Yes, sir.
What does the course outline look like? Or maybe you'd like to just send it to me on under separate cover.
I actually did have a complaint maybe a year ago where the issue was that some rodents had gotten in the property, and the purchaser claimed that the selling licensee knew, and it turned out there was no real proof that they knew. But I mean, it has come up before.
I don't-
Pictures of dead rats.
I don't doubt any of that, but I don't think I expect licensees to be proficient in identifying and remediating and removing wildlife. I just don't think,
They don't have to remove it.
Mr. Grease, what you need to be is something besides a commercial broker. You need to sell him some of these rat holes we've been dealing with.
But think about it, they left off raccoons. Raccoons. Yeah, they get.
No, they're actually considered a ground rodent. Chipmunks, possums, armadillos, raccoons, rabbits. But I can read the the course.
My dog.
Does it actually tell us how to get rid of these animals?
No, sir, you have to pay for the course and take the class.
Before, I have to approve the course first before I do that.
This is correct, sir.
Where is it going to be taught? I don't really care about it because I don't want to know how to do it. I just want to know who to call.
I can have you call my little man because he could probably teach you just in one quick lesson after this.
All right, do you recommend approval of that class?
I would say, considering the makeup of our state, that not everyone lives in large areas such as Farragut, that yes, this would be
Town of Farragut.
the town of Farragut, that this would be an informative class, as some people do live in rural areas of the state.
I'll make a motion the courses S1 through S33 be approved per the recommendation of the Education Director of Trek.
I'll second that.
We have a motion by Commissioner Grace to approve S1 through S33 as per the recommendation of our our Education Director, Mr. Steve McDonald, seconded by Commissioner DeShara. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Courses are approved.
Mr. Chairman, I abstain as to course S2.
S2.
You teaching it?
No.
Okay, so
I have a question. Do you
Yes,
go
ma'am.
through and read all of these courses,
absolutely.
word for word? Wow.
I do. Because if you ask me about them, I want to be able to go back and try to sound as intelligent as possible, and also it comes back on me if something happens. I don't want to get rat bit or raccoon bit.
Raccoon bit?
Yeah, we're stepping something
If you get
out.
them as babies, all they want to do is just find milk. We had some of those recently.
The next issue or tab is the instructor approval. I place before you, Commissioners, two requests. One, Sally Cummings of TAR requests the approval of Karen Randolph to teach the NAR Ethics Approved Course 7286. Ms. Randolph is a previously approved instructor. And the second is Sally Cummings of TAR requests the approval of Ann Sciarra to teach Transaction Desk Basic, that's approved course 5747, and Transaction Desk Advanced, that's course number 5748. Ms. Sciarra is also a previously approved instructor.
I make a motion, we approve.
Have a motion.
I'll second. Is the reason since they're previously approved, was that in a different cycle? Is that why?
Different classes.
Correct. Now, if they are coming before you to teach the law of agency or the core, I will put that in there that they have actually completed that part of the law, because that's now law to teach agency or teach core. You have to take a course.
We have a motion and a second to approve Sally Cummings. No, Miss Randolph.
Randolph and Ann Sciarra.
And Ann Sciarra. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Hey, Chairman, question for Ms. Maxwell.
Yes.
Did you get your raise?
No.
Chairman, in light of the fact that we have a new officer, what action should we take to get Ms. Maxwell a raise? As the chairman of the evaluation committee? Where I haven't met for the last 2 years because she's doing such a good job. Frustrating.
It's very frustrating. When do you want to meet and have a committee meeting about this issue? I mean, I had last month scheduled with Commissioner Giannini. I was going to meet with him, and he called and canceled, or his assistant called and canceled the meeting. He was in traffic and was not going to be able to make it. And I have not called him back to meet with him pertaining to this issue, but I will do that. We're going to be in East Tennessee next month. But
November meeting?
at our November meeting, yes. This needs to be addressed because we all heard when Commissioner Myshak talked to us about this issue, and we need to follow up on this. Yes.
Okay.
And we will
Thank
do
you.
that at our November meeting.
I have one question, and it's not on the agenda. You were referring to a while ago about this telephone number on Craigslist, and it's not registered with the commission. What is the responsibility about telephone numbers? Or is there any responsibility? It's like I have a firm number. If I change that firm number, or nowadays, people are beginning to do away with landlines and it's cell phones. Do I have to notify the commission that we're using cell phones more than we are landlines?
We require firms to have a landline if they have more than one person in the firm, because you can't really share a cell phone line. So we require that they have a landline number. And you're supposed to when you fill out the firm application, as a principal broker, you're supposed to update the commission with your phone number and keep the phone number and the address current with us. Not all the cell phones that your licensees have, because we don't. I mean, we have those on the licensee file, but not as part of the firm file.
The point I'm getting to is okay, if you have my current telephone number,
Correct.
landline, there's nothing that prohibits me or my agents from advertising with cell phone numbers and things like that.
As long as they have the firm phone number listed on the sign as well, so it has or on the advertising, it has the firm name and phone number, and then they can have their own cell phone number on there as well, which is what I think the bulk of people do.
Well, I just know that you're going to see a time that you will do away. People will do away with landlines.
Well, yeah, I know that they will. I mean, the general principles say that you should list the firm name and telephone number, and I know that they will, and that's a problem that comes up, especially with the cost of landlines. I mean, I know that some licensees have written us when they've opened a firm and said that, it's going to cost X to have a landline, and it would only cost this much to have a cell phone, just cell phone lines and not any landline at all. So I know it's an issue more and more with people. Yeah.
Steve, is that all you had for your report?
Sir.
Miss Mac, oops. I'm just going to ask do you have anything else, Miss Maxwell?
No, I do not.
Ms. Crop, do you have anything else?
Do we need to go back and do anything on that team advertising? Did we need to make?
Going to be back next month with something on the agenda.
I expect the agenda to have
Okay.
items for us to consider and possibly take action.
Okay.
And since we're going to be in East Tennessee, in the village of
Town.
the town/village of Farragut.
You'll be the village idiot if you're not careful.
This is true, I know, but I have heard rumored that there's going to be several representatives from several teams come to our
I
meeting.
hope the heck they do.
I'm gonna put out the word.
Send
They're
'em
going to be some down there in the audience.
All teams welcome.
All
Yeah.
teams welcome. John Grease is going to be asking you questions.
No, I'm not. We're going to be voting on items that'll affect their business.
Now, Commissioner reports. Commissioner McMullen.
No report.
Commissioner Haynes.
I don't think I have a report either.
Commissioner Alexander.
Due of time, I'm going to pass too.
Commissioner Grease.
No report.
Commissioner Flitcroft.
Mr. Chairman, we have an able staff. Thank you.
Would you go over again all the things we learned today?
I would do that again, but I think most of the commissioners would prefer not to.
Okay.
I wrote it down if you'd like to.
Commissioner DeShara.
Nothing to report.
Nothing to report. I'm looking forward to being in the town of Farragut next month. It should be a fun time, be interesting time. And I just want to say thank you, Commissioner Grease, for all that you have done to put everything together and to make it happen. And you are to be congratulated, and we're going to wait until the meeting's over.
Let's wait till it closes.
Yeah, until the meeting's over, second day in Knoxville, just to see how much we really appreciate you.
Move adjourn.
A second.
Motion has been made, we adjourn. Before you licensees leave, you sign out. If you want to get credit, get your certificate. Mr. McDonald, Steve McDonald, our education director, you gonna give them their certificates?
Two of them are, I'm looking for my list.
Cheats.
Just bang it.
No, I was looking for these.
You sign out and get your certificates. You have gotten 8 hours of continuing education.
This is close.